so this should be pretty easy. My questions will be somewhat basic. When will this law take effect if signed by the governor and passes today?
So the actual judicial districts take effect in 27, January 1st, 27. The judges that run for office in 26 will be running on the new lines.
I'm sorry, say that last part again.
The folks that are running for office, to assume office January 1st, they run in 26. The new offices will be 27.
So the people that already elected, that are already sitting in those judicial seats, will then also move in 27, correct? If they are ones chosen to move.
Yes.
Oh, bless you, sir.
Yes.
So do we know how many judges that are currently seated will have to be moved once this takes place in 27?
Well, I suppose it's laid out in the bill what judges go to what districts, but I would say when you say moved, you mean like physically relocate?
Yes, yeah. Will be running, or excuse me, be put into a judicial district they weren't elected to.
Well, just remember, this doesn't truncate their term. So if anybody is a sitting judge currently and they were just elected last year, they still have 13 years under, without having to run again, is what
right.
I would say.
I understand it doesn't change the length of time that they're running. I'm saying if they ran in this district here, they could be moved to another district, right, to fill those vacancies that you need.
Well, remember, these folks are assigned by OCA to the county that they're assigned to. That doesn't change in this. So
who votes for these judges then?
Like who elects them?
Yes.
Oh, well, the process is unchanged. The whatever a party circulates petitions in the same timeline as when our petitions are circulated for judicial delegates. And then a convention is held in usually August, and then the delegates of their respective parties and choose their respective candidates.
Well, I understand that part of it. I'm saying the residents that live in the area, correct, vote for these judges, correct?
Sure. Yes.
Okay. Yeah. So now they're voting for a judge that's running on a line that represents their area, essentially, at the time for that district that it was presently constituted. Not starting next year, currently. Correct? So in other words, I voted for a judge that's on the ballot that I go in and vote for, if it's my election, your election, if someone's on the ballot that year, people are going out and voting for these judges, correct? Just like you or me.
Correct.
Okay. Now, it's possible that a judge was elected, right, by people that will no longer be able to vote for that judge per se, if they were able to run again, not represented. In other words, I voted for you to be on the ballot as the judge I'm voting for. They could now be put into a district where I could have no longer voted for you to be that judge, correct?
Well, that could happen today, I guess is what I would say. That could hypothetically happen today. But for example, in my district, where I live, we'll use that example. If I voted for a judge in Cattaraugus County, which I'm just picking a county, currently in the 8th Judicial District, it's in the 15th district as well. So there's no change. In the majority of counties, there is no change.
But there will be a change in some. There's a possibility that it could, correct?
Yeah, but again, where a judge is seated is dependent upon what OCA designates, where they tell them to sit.
Do we have an idea of how many of those judges may be moved out of a district they weren't elected in?
Well, it's reflected in the bill where it lists the judges. So it says, if you're, it lists judges in Judicial District 8, I'll use it as an example. The new Judicial District 15, it lists the ones that are there. It's there.
Right. So if I voted in 8, but now that judge has moved to 15, right? If that election would have taken place today, I might not have been able to vote for a judge that I voted for last year, this year.
That's true, but you're also talking about somebody that has a 14-year term, so it's unlikely. Yes, you might be able to say, well, I can't vote for this person who I voted for 14 years ago.
Correct. But when you go in to elect these judges, it does say in the ballot, 10-year term, 14-year term, correct? But now so someone I may have voted for a 14-year term, I no longer have as the judge in my district, correct? Even though I voted for them, they could essentially be taken away from me as the voter.
But, this bill doesn't change that because you could vote for them today, hypothetically, and they might not be in your district. Not be seated, I should say, where you are.
Okay, but I can still vote for them. So if they're, and I understand they're not seated where I am,
Yeah.
right? But the overall vote, I still have to vote for them, correct?
Once every 14 years.
Correct. What I'm saying is they were elected into that position by the voters that they, I don't want to say be represented by, those voters aren't represented by a judge, but they are voted on by the voters in that district, which now they will no longer be the judge in some of those districts any longer, correct?
Yeah, but what you're not taking into account is the probability of that narrows because, again, in the case of my county, the only change in my judicial district is one county. So if you lived in any other county, you were getting the same district, the same judge, the same judges.
I'm not taking into account the probability, but what you are saying, it is going to happen in certain districts.
It is going to happen in certain districts, yes.
Okay, so, and that just brings me to my larger point, is that we are now essentially disenfranchising voters because they voted for someone that no longer is going to be in their district. Yeah. So we had voters last year that could have went in and voted for someone for a 14-year term, and now we're telling them, sorry, they no longer are in that district. How is that fair to the voters who voted for them?
Yeah, but that only matters for purposes of re-election.
Well, no, but it doesn't. So what I'm saying to you is you're saying that you want more people in those districts to be representative of the people that are in that district, correct? Which I understand. Mm-hmm. But at the time, they were voted on for a 10 or 14-year term, and we're now telling the people in that area, the person that you voted for, whether they voted for him or against them, is no longer going to be the representative, and we're making that decision here. We're not letting the voters decide. We're just saying, sorry, you can no longer have this judge.
Yeah, I guess the only thing I would say is, we can kind of go in circles on it, but at the end of the day, OCA could make that decision with or without this.
Right, and I understand exactly what you're saying.
That's a higher probability. Actually, the two higher probabilities is that these judges are not going to run for re-election, so they would retire at some point, either because of their age or for whatever reason, or that OCA could potentially just move a judge to a different place. That's substantially more likely than the scenario I think that you're going.
But my concern is, it's possible. So again, you brought up redistricting before with us, right? It does happen every 10 years. But every time there's redistricting, we have public hearings, and you can't be redistricted out in the middle of your elected term. But we're doing that to judges. Isn't that disenfranchising voters? Again, whether you agree with who's in that position, why they're in that position, who voted for them, the fact of the matter is they were voted for, and we're saying that person will no longer represent you.
I guess what I would say to that at the end is that the state constitution is clear. We're able to do this every 10 years, despite their terms being even larger than that. So this is an inevitable thing that would happen no matter the scenario, no matter the timing, that as long as we're able to do this every 10 years, if we choose to, since we're authorized to, and their terms are greater than 10 years, then that is something that's taken into account and considered.
Okay, so...
Yeah. And everyone obviously finishes their current term. So it's not as if a voter can't look at a judge and that judge look at them and say, sorry, because of a bill that they passed in Albany, I no longer am your judge. I disenfranchised you. The state isn't disenfranchising somebody by saying, judge, you can't be a judge anymore. That would be the problem.
No.
These judges are able to fill their terms, and they're still, as they are today, under this new bill, they are, constrained to how OCA determines how judges are placed, seated.
I completely understand, but as much as a judge can't sit there and say to the voters, sorry, I no longer represent you, we shouldn't be able to sit there and say, sorry, you ran for office, we're just going to move you. That being said, I have a question. Could a current elected Supreme Court judge that's unhappy with where they were moved to or they're assigned to, under this legislation, run for a Supreme Court seat from the original JD that they're assigned, instead of being assigned to another?
Nothing prevents a judge from seeking an election anywhere they want to run. There's no residency requirement.
And I'm asked that because there's no residency requirement.
Correct.
So if they're elected to a 14-year term last year, they get moved to a different JD, they could run next year for Supreme Court judge again. Do they still get a 14-year term? Do they have to run? Can they run in another district?
Oh, I mean, there's nothing preventing a judge today from running for a different judicial office in a different region. I would only say it would be a strange thing to do because at the end of the day, OCA could just put them back to where they were in the beginning. But
Right, but you're,
I suppose.
and again, like I said, I am not fully knowledgeable of this. It's just more of a question. So while they're a sitting judge, let's say on their 10th year out of 14, can they could run for a different JD before their term is up?
Yeah, I mean, there's not a limitation on what a judge can do as a candidate running for office, but I think at the end of the day, we've spent a lot of time talking about the what perceived to be inconvenience of a judge's moving a county over, which in many cases is a pretty short commute, frankly, when at the end of the day, what we really should be talking about is the representation, how judges are elected, the ability for people to be able to be seen by people from their community. I think that just is more important than sort of, you know, the emphasis on what could be very slight inconvenience for judges.
Oh, I'm not looking at the inconvenience for judges. Believe me, I'm more looking at it as it doesn't matter to me, to be perfectly honest. Judges, lawyers, it's fine. My concern is the people that voted for them and put them in those positions.
I guess my response to that is my bigger concern is not the folks that voted for whatever candidate was in front of them, is the fact that the voters that vote are so more often than not given the opportunity to vote for somebody from their community because of the way that the lines are set to begin with. So the disadvantage isn't whether I voted for a person and now they're going to be the county over. The disadvantage is I am, you know, what history has already shown us, it is not impossible, but highly, highly, highly improbable, and historically has never happened in some of these regions, that someone from a community is actually seated as a judge. And that's because we have this sort of disproportionate thing going on where we have a sort of 3 population centers that overpower judicial districts, and it prevents certain people from being elected from certain places, when this looks to cure that by allowing people a clearer path, frankly, to running for judge if you live in one of these non-sort of massive counties. And that's really the bigger, you know, sort of the bigger point of it all.
I understand what you're saying. So, and trying to put it into words exactly what I feel like you meant, which is you want representatives from your area being the representative that you want, correct? Not from that area, just like anything else, just like you representing your district. You're going to vote for someone from your district. You want people that live in your district, right, represent you, have the same values you do, to be your representative. Correct? I mean,
right. And currently, the way that the current lines are drawn, we're looking at possibly a dozen, if not more, counties and telling them you're so small compared to the county next to you that is so big, the likelihood that you will get a judge from your county is almost impossible. This looks to cure that problem.
Okay. So, and Mr. Rivera, I appreciate you answering the questions.
Sure.
My only concern, and only real thought on this, again, is the election process and, in my opinion, circumventing it. And my last question for you is, do you have that concern when we're doing that here? Just as your concern is with the judges from the areas, right? Is you want people to be representative of the areas that they're in. We want people that we represent to have confidence in the judicial system, confidence in elections, confidence in this body. Are you concerned at all that by changing the will of the voter that have already voted for these judges, that we are, again, disenfranchising voters and taking away their right for who they've already elected?
Honestly, I would say my greater concern is the fact that anybody, whether you're a super informed, member of society or not, if you were to be told that where you live is within a judicial district that hasn't been reviewed, changed, amended in possibly
Ms. Walker.
Decades, that's a bigger problem.
Ms. Walker.
Thank you, Madam Speaker. On the bill, please.
On the bill. So, sometimes when you go to church and you hear the pastor, bishop speaking, and you're like, they must be talking to me. This is exactly what I was hearing as I listened to the banter, the debate over the sponsor of this bill introducing a bill that talked about judicial representative representation. Then I was like, is this a referendum on DEI? Then it made me look at myself to say, is this DEI conversation about me? And I said, yes, of course, because DEI definitely earned it. The ability to be able to stand here and listen to the hypocrisy that I've heard in this moment. It also made me go back to a poem that I heard in talking about redistricting. It was something that was given out by a Klansman regarding a U.S. election poll, and it reads, "When cotton grows on the fig tree and alfalfa hangs on the rose, when the aliens run the United States and the Jews grow a straight nose, when the Pope is praised by everyone in the land of Uncle Sam, and a Greek is elected president, then the Ku Klux Klan won't be a damn." Well, one of the seminal pieces of legislation in this country is the Civil Rights Act of 1965 and its progeny. We know that its core is to prohibit racial discrimination, and then going into the Voting Rights Act, which protects under the 15th Amendment the right to vote, which shall not be denied by any race. And as the circumstances was going around with respect to how we got to the Civil Rights Act and the Voting Rights Act, there was an amazing archbishop who was from the Central Council of the Archdiocese, who passed a resolution on racial equality. It was signed by Archbishop Iakovos, which condemned segregation and racial bigotry. He issued a statement that persecution, prejudice, and intolerance is the greatest sin that of the free soul of the man can bear. We know race is a social construct, but we kept hearing it today. We know at one point when it came to race, it was only a WASP generation, those who were white, Anglo-Saxon, and Protestant. Yes, we also heard about Lady Justice. Lady Justice reads, "Quid pro domina justitia sequitur," protecting liberty and justice for all. But guess what? Just as we've seen under the Civil Rights Act, just as we've seen in that case that we talked about that U.S. election poll and the Ku Klux Klan, while we know that justice for all is supposed to be for all, sometimes you got to go to the legislature to get the all to include you. Sometimes you have to go to court to get the all to include you. And then we're talking about court systems and being able to elect somebody who shares your values. I remember there being this case. It was a case of a young man who was accused of robbery. And one of the determining factors on this case was whether or not this young man actually went to the Chinese restaurant in his community in order to purchase 2 chicken wings and French fries. The jury in this situation could not understand, because in their community, they can get dim sum, but they certainly were not ordering chicken wings and French fries at the Chinese restaurant. But for the judge who sat on that bench, who had the lived experiences in order to be able to identify and speak to the jury in private, to be able to say, yes, look, this is the Chinese restaurant menu for my community, and a person is able to get those things. So we absolutely need a representative representation. The spirit of this legislation is to undo existing laws and procedures that have denied equal political opportunities for voters in those counties to be able to elect candidates of their choice. Over time, there have been schemes to dilute protective classes and their access to voting. And protective classes was not created here. A protective class is a group of people who are legally shielded from discrimination or harassment based on a shared characteristic, yes, such as race, religion, gender, disability, and age. So again, this is about access to justice. This is not a new phenomenon, and we know how important it is for redistricting to be able to speak to apportionment, because our census has told us that numbers are growing, people are moving, and demographics are changing. And so in that regard, I encourage everyone to support this piece of legislation to allow for the voters in those particular counties to be able to seek and get access to real justice with a shared level of values, lived experiences, circumstances, and by gosh, yes, including those who share characteristics of them such as race, religion, gender, disability, and or age, because those are protected classes. It may have taken us a generation to be able to get those classes to be protected, but it will take a lifetime for us to protect it. And in the matter of standing up for democracy, as we are watching a Department of Justice who is eroding its very nature, I support this legislation, and I encourage our colleagues to do the same in honor, yes, of fairness, justice, and equality. Thank you, Madam Speaker, for allowing me to support this bill.
Thank you. Ms. Bailey.
Thank you, Madam Speaker. Would the sponsor yield for a couple questions?
Will the sponsor yield?
Sure.
The sponsor
Thank you very
yields.
much, Mr. Rivera. And I do apologize. You may have said it. There's
okay.
been a lot said. I've been trying to take notes.
It's all good.
Just real quick, when I take a look at specifically, I currently reside in the 7th JD. So some of my questions might be more pointed to that. I know you've been talking about the 8th.
Sure. What county do you live in?
I'm sorry?
What county?
When you, as far as how the justices were assigned, did you say that constitutionally you have to assign the judges when we're redistricting, or were they just decided that that's where those individuals were going?
The Constitution lays out that it authorizes us to do this at 10-year increments, and that it lays out we have to determine where the current judges go. So yes, I suppose. Yeah.
Okay, so constitutionally,
Yep.
okay. And did I hear you correct when you indicated that some of that decision making was based on where they reside?
Yes.
Okay. Because I was trying to figure out,
Oh, forgive me. When I say reside, I mean where they preside, like where they actually, where they work, where they're seated, I should say.
So in the case of Monroe County, it would be down at the Hall of Justice. Is that what you're referring to?
No, what I'm saying is what we took into account was seniority and where they actually conducted work. So it's if a person, for example, was in Erie County, we kept them in Erie County. We didn't move a person from Erie County to Monroe County, in other words.
Okay. But if you took folks from Monroe County and moved them to the 15th Judicial District, that's taking them out of Monroe County when we created the 15th JD.
Say that again?
I guess maybe I didn't understand your answer there. So there's justices that reside in Monroe County currently right now.
That are judges in that judicial district. Yes.
That are judges in the 7th JD.
Okay.
Currently, the 7th JD what was it, 20 justices, Supreme Court judges. It goes down to 13. When you create the 15th district, we have 13 seats, and then we shifted some into the 5th district, which is going up to 14 seats.
Yeah, the total number of judges does not change amongst the 4th Department in its entirety. What's taken into account is that there are points around the minimum needing to be 50,000 people in order to have a judicial district. So some counties are much larger than other counties, and when you take into account the population, that's how the judges were distributed.
I completely understand that. I was just trying to figure out how the judges were assigned
Sure.
to the different districts,
Sure.
and I'm still trying to wrap my head around that. So if we used where they were, when the methodology came out to assign folks to the 5th JD or to the 15th JD, coming out of the 7th JD, it's my understanding, if I heard you correctly, you spoke with an administrative judge, who I presume is in the 8th JD. Who helped you delineate where the other judges were going to be, where their new judicial district was going to be?
Well, I suppose when it comes to the 8th and 15th districts, it's really about population size. So in the county of Erie, as I said before, is about 950,000 people, give or take. So, what made sense is to bring together the, surrounding counties under the next judicial district. There's not much, past that, considering that, it would be similar size by population, but, once you remove Erie County from the judicial district, it was such a mass majority of that judicial district that the remaining counties could combine made more sense to have another district.
My question isn't specifically my question is how the judges were assigned to those judicial districts once we took the 7th judicial and shrunk it down now to where we have 13 justices versus the 20. So those 7 individuals, I only counted 6 that I could find, but those 6 or 7 individuals have now been dispersed either into the 15th JD or the 5th JD. So my question is, how did we delineate that methodology?
The majority of the circumstances, it was based by seniority, and then there was other considerations as in what judges served in the appellate, but in general, it was about seniority.
I apologize, I missed the part about the appellate.
That within the 4th Department, there's appellate judges, and we grouped the appellate judges together. But outside of that, everything was really about seniority, how long they had been in office.
Okay. And the only reason why I ask is I just looked at 2 individuals that I know. One is on the southwest end of Monroe County. They're getting moved over into the 5th JD. And then one who is on the northern east part of Monroe County is getting moved down into the 15th JD. Yeah. So I'm just trying to figure out as far as, how they were assigned. But I'll go on to my next question and point. So we talk a lot about population, and I completely understand the population and how that works out. And we see that even here when our districts are realigned, when population, and then you look at square miles. Was there anything considered when different counties were grouped together to create, the 2 new districts, when we were looking at square miles within the JDs now?
Square miles, no. But what I would say is, even currently, if we're just looking at, the old 7th district, if you lived in southern Steuben County and you would have had to go all the way up to sort of northern Monroe County in Rochester. It was a distance in its old format, and it's a similar distance by the nature of people just being spread out and populations being where they are and counties lines being where they are. It's sort of unavoidable.
Okay. The 5th JD is now almost 10,000 square miles. The 15th JD is just shy of 7,500 square miles. And as I indicated, those judges that we've assigned coming out of the 7th JD and where they're located, now we've just added more to their commute. So obviously not knowing where they are going to sit, OCA can, in all honesty, OCA could say, you're going to be up in Monroe County. If they're in the 15th or the 5th.
They could do that
JD.
today with or without this bill.
Absolutely. Yep. I completely understand that. I'm just trying to figure out how they were assigned, where they were assigned. And I think you have answered my questions in and around that. So I appreciate it very much. Thank you. And on the bill, Madam Speaker.
On the bill.
I don't want to reiterate what my peers have already said, but it is interesting that we are here hurriedly to discuss this bill when OCA specifically has asked to maybe pause it. There's been other legislation that this body has done that with, and we continue to discuss it over and over and over again. I won't get into the energy mandates because we'll talk about those, I'm sure, over the next few days. But it is truly concerning. I completely understand, it's our constitutional right if we want to redistrict judicial districts, absolutely. But speaking to an administrative judge, I'm not sure we're getting a full appetite for what the thoughts might be. That is very concerning to me. And when I look at the judges that have been assigned to various spots, the elections that are coming up this year, there are elections for 2 Supreme Court judges in the 7th JD. Where do they fall? Where are they going to go? Do they now just take the spots of a seat that is vacated? Is that how they're allocated? What does that look like? So I think we really need to take our partners here when we're looking at OCA, speak with the administrative judges, and if we're going to do this, let's get it right. Let's just not arbitrarily put something out there. The other piece is the expense. The staff and the resources that are needed for each judicial district is immense. Having served in my prior position, I worked with our Supreme Court justices on a daily basis. I worked with those justices coming out of the 7th JD on a daily basis, and I worked with their support staff. I worked with the district staff. There are many mechanisms that, in many pieces, that we really need to take a look at. It is going to have a financial hit to us as a state, and unfortunately, we have not budgeted for it. Will it be budgeted? I would hope so. But where do we come up with that money as we continue to see our expenditures just continue to bulge year after year? So for those reasons, Madam Speaker, I will be voting no.
Mr. Molitor.
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield? Sponsor yields.
Thank you. Thank you. Mr. Rivera, I just got some questions, maybe some practical questions. I'd like to focus on the 8th Judicial District, since
Sure.
that's where both of us are
Sure.
from. As you know, in the 8th Judicial District, your interpreters, stenographers, clerks, commission of jurors, those are all assigned out of Buffalo, right?
At the decision of OCA, I suppose.
Yeah, but they're, for example, if I wanted to become a stenographer in the 8th Judicial District, I would be assigned to Buffalo, and then Buffalo would assign me out to wherever they think I need to go. Isn't that right?
That's how it is currently in the current 8th, but in the new 8th, that might not necessarily be the case.
Okay, and that's what I want to talk about. In the new 8th,
Well, I should say, it might not be that way, and it might not be that way in the new 15th. Which
right.
is the newly
so
created.
that's kind of where I'm trying to go is how would it work with a new 8th and a new 15th?
You're asking me how OCA would assign stenographers and staff in the new district?
Yeah, how would it work?
The way that OCA does it today and how it does it in every other judicial district.
So right now, in the 8th Judicial District, they're all assigned out of the Buffalo office.
Because Buffalo is in the 8th. How it will be done in the 15th, presumably OCA could choose to assign them out of the 15th.
Okay. So this legislation would have no impact on how, on the, let's call it the home base of OCA staff for the different judicial districts.
I mean, OCA can choose to have a sort of similar home base, we'll call it, in one of the counties in the new 15th.
But they could also, if I'm correct on this, they could also keep everything exactly as it is, keep the home base in Buffalo, and assign those individuals out to people in the 15th district.
It's the will of OCA, how they want to structure how they staff.
Okay. And that's kind of the same way it is in maybe other parts of the state, right? A judge might get assigned from one judicial district to another. Staff might get assigned from one judicial district to another. All that stuff happens under the direction of OCA, which is a statewide agency.
Correct.
Okay. So there's no concern, you don't have any concern that, and this is really where I'm kind of going, there's no concern that the staff that currently exist in, let's say, my county, who are going to go from the 8th to the 15th judicial district, there's no concern that they're going to have to move to another part of to a different district or a different part of the state necessarily? Or is that something you can't answer because that's up to OCA?
That concern could exist with or without this bill because all of it is at OCA's discretion today.
Okay.
If OCA decided tomorrow to no longer have Buffalo be the home base, as you put it, and decided Dunkirk to be it, then we would have no say in what OCA did in that matter. So it'd be no different.
And that's the way I understood it. I just wanted to have
Sure.
that explanation on the record.
Sure.
Thank you, Mr. Rivera,
Thank
for answering my questions.
Mr. Mantalo.
Thank you, Madam Speaker. Would the sponsor yield?
Will the
Yes.
sponsor yield? He yields.
Thank you, Mr. Rivera. If you could help me out just a little bit, we've talked about diversity here on the floor for the last couple hours here, in and out of this debate. Can you explain to me what that means as far as what we're talking about from this judicial change?
Sure. I mean, I described earlier around, racial demographics of a region, but I also described the nature of residing in a more rural county and not being represented. So diversity has, as it is, it means many things. And for example, the example I used earlier, I think, was Allegheny. If I am a resident of Allegheny, which is perceived to be a more rural county, as a lot of upstate New York is, the likelihood that I would have a judge who represents my community from my community as a member of the Supreme Court is very, very slim. In my own research, it's been about 40-ish years from what I've heard. And that's just one example of one county. So I think that no matter how you cut it, what we're doing today ensures a higher likelihood of people from counties seeing folks that represent them and more closely who they are.
All right, thank you. So with the changes, the Monroe County will be its own county. It will then be the 7th Judicial District, is that correct?
Correct.
And with what you just told me, how does that benefit Monroe County?
It benefits Monroe County because to date, despite being very, very diverse ethnically, they have still, in its current form, have not elected or currently do not have a single member of the Supreme Court that is a minority.
I'm sorry, I couldn't hear the last thing.
I said, despite Monroe County being very, very diverse, especially in comparison to the neighboring counties of the current judicial district, it has still yet to been able or been afforded the ability to to elect a member of color to the state Supreme Court. Currently, there is none. In the entire 4th Department, there's only 2 members of color, both only in Erie. So I believe that the people of Monroe, 1, are going to benefit from the potential diversity of the court, but also 2, that also means that if you're a Monroe County resident, you will be seen by a judge from Monroe County, not a judge from a neighboring county, where in which the nature of the county, the demographics of that county, the way that that county exists, being drastically different from Monroe. We're ensuring that people from Monroe are going to be in front of a judge that is aware of the community there and what it's comprised of.
All right. So right now, the 7th Judicial District, represented by Cayuga, Livingston, Monroe, Ontario, Seneca, Steuben, Wayne, and Yates counties, as we are today. Most of those counties will now go to the 5th Judicial District, which will consist of Oneida, Oswego, Herkimer, Jefferson, Lewis, Cayuga, and Ontario, Seneca, Wayne, and now Yates counties. Now we'll be going to 10 counties. So I look at this, and we talk about diversity. Is diversity, to me, diversity should be a two-way street. Is that not correct?
How do you mean?
So let's say this goes through the way you're talking about. Mm-hmm. Now we have a set of judges in Monroe County, okay? Mm-hmm. They're going to be based out of Monroe County. They're going to service the people that are in Monroe County and not any of the other districts or any of the other counties, pretty much, correct?
Well, I would say yes, but remember that OCA does have the ability within the 4th Department to place judges in other places. So, but in general, yes.
Okay. So, have you ever farmed?
I have never farmed. No.
Have you ever run a business?
The closest I've been to running a business is I was a banker and had many, many, many business clients, but no.
All right. Well, my question here is, a lot of times when we as farmers contract with construction people, people that buy our grain, they're really based out of the city areas, not so much in the rural areas where the farmers are. And some of them are even based out of the Rochester area, which consists of Monroe County and other parts of the area. So with this change, and we're going to take a farmer now, that there have been lawsuits, there will be other lawsuits, will now be based out of Monroe County because that's where the business is that we are going to be involved with. If we change the makeup of the judicial representation, how is that farmer going to get a fair shake if by what you said, we need to change the makeup of the judges so they know who they're dealing with? Now, as a farmer, I'm going to go to Monroe County, and I'm going to deal with a judge that knows absolutely nothing about farming or the agricultural area or a rural area. How do we fix that?
I guess I would say, number one, county judges still remain, so I don't know if the matter would go to a county judge versus a Supreme, so that's one thing. And I'd also say this bill ensures a much higher likelihood that you'd be in front of a judge that is aware and more present in your community and even potentially from your community. The way it currently is that if you're from Steuben County, you're dealing with a judge in Monroe County. That's what we want to sort of, I don't want to say avoid, but that's what we're looking to address. Now, if you're from, Wayne, Oswego, Jefferson, Oneida, you're one district, and the likelihood that the matters before those folks in those counties are similar, I think, are higher.
All right. Well, I believe if truly part of this change is the diversity and getting people in front of the right people, or having the ability, that has to be a two-way street. We can't just block off Monroe County. And anything that comes out of a lawsuit that's going to end up in Monroe County, that means we're going to have judges that we're going to be in front of that know nothing about our businesses, that know nothing about the background of agriculture. How is that fair? How is that being diversified?
I honestly look at the new 5th District and really perceive it to be very, very, as a person who's toured just about every county in the state of New York, I would look at the 5th District and say, for rural matters, I would much rather, for awareness of the needs of the rural community, the 5th District actually looks far better than the old 7th District. But I'd also say for anybody, the sort of the hypothetical scenario is, how do we sort of explain this to somebody? The sort of the boiling down of it all is, we have an authority as the state legislature to pursue this at any time. These district lines have existed long before you and I were here and have not been addressed. I have called an array of attorneys and judges that are retired now to ask what their take is, at least in the case of my judicial district, which is the 8th, and ask them, when was the last time we pursued changing this? And half jokingly, and what I think might be true is, it might have been turn of the century. So there's no way we can justify not changing lines in response to an ever-changing population by simply keeping it the way we are, the way it is. Yeah, I find that argument to be undefensible. Like, we have to make a change here. And I think that this bill before us is a respectful and common sense way to do it.
So, and maybe you've answered this question, and I apologize if I ask it again. Who actually drew up the new lines? Who drew them up?
Oh, well, I mentioned it before. I originally had a bill last year that touched my judicial district. Other members had bills that touched their judicial district. We came together knowing that we could only do this once every 10 years, put it together in a single bill. To boil it down in its simplest form, how we came up with these districts, we believe that there are population-dense urban center counties. Those counties we felt had sufficient population to necessitate their own district, and then we carved together the neighboring counties to form other districts. As I mentioned before, the state constitution is clear. We can't divide counties, so entire counties obviously have to be kept whole.
Yeah, I understand you can't divide counties, but sometimes the way the lines are drawn up, and if we're truly looking out for the people of this House that we represent, I just feel these lines could be just a little bit different. And just giving you the example, it may be hypothetical to you, but in the real world, that's the way it works. So I appreciate you to answering the questions. Madam Speaker, on the bill.
On the bill, sir.
I think that's one of the problems that we have in this House. We sometimes forget the people that we represent back home, the people that are going to be going to these judicial courts to be in front of a judge. And I think it's our job to provide them the best service possible. And we are, again, now going to silo certain groups of people, certain counties, into silos. We have one county versus 10 counties, and I know it's rural. You can't tell me we can't divide it up a little bit better than that, so there's a mix. So there is a true meaning of diversification across the court system, not dealing with just one city. Why not deal with a city and several rural counties to make it truly a diverse way of doing the judicial work in New York State? So I appreciate the time of the sponsor answering my questions, but I do believe in a rural area, there needs to be fair representation across the board, because much like many lawsuits, we're probably going to end up in a large city, whether it's Buffalo, Rochester, Syracuse, Albany, New York City, it doesn't matter. We're probably going to end up there from a rural area down the road. So thank you, Madam Speaker, for your time.
Thank you, Mr. Mantolo. Mr. Tague.
Well, thank you, Madam Speaker. Will the sponsor yield for some questions, please?
Will the sponsor yield?
For you, certainly.
The sponsor yields.
I do, just for the record, want to know that I can attest to Mr. Rivera traveling across the state of New York, because he traveled with me on my farm tour, and I thank you very much for doing that, Mr. Rivera. Sure. Mr. Rivera, the first question I have is, how many judges' names are spelled out in this bill?
Every judge of the Fourth Department that's affected by this, so all of them.
So now my understanding is that's 66, but isn't there 67 in that district? Didn't Judge Dorn, who resigned in March, isn't he also listed?
There's one vacancy, yes.
Are there any laws restricting venue for bringing election cases?
Say that again, I'm sorry.
I said, are there any laws restricting the venue for bringing election law cases?
If I'm unaware of that. Not to my knowledge, no.
So what about election law 16-101 that requires constitutional election cases be brought in certain particular counties?
I'm taking your word for it.
Okay. So under this bill, if someone brings a challenge to election law in the 4th Department, what district would they have to bring it in?
As you said, Erie.
Correct.
Yeah.
Well, let me ask you this. Are there currently any Republican judges elected from Erie County?
Oh, sure.
Could you name them for me?
I can't confirm the affiliation of every judge, but I know that there are some in the 8th Judicial District, yes.
Okay, because my understanding was there were no judges in that judicial district actually from Erie County.
Oh, no, there are.
Okay.
As you can imagine, I've gotten a lot of calls this week, so I'm certain there are.
Well, would you say that there's a large majority of Democratic judges from Erie County?
Oh, I don't know if that's true. I would say I haven't done a sort of a polling of who's a Democrat, who's a Republican. What I will say is I know that the enrollment of Erie County is Democrat, but in my experience, a lot of the county offices that are held in Erie County, it's never been entirely Democratic. For example, there's only been 2 Democratic county executives ever elected in Erie County, only 2. Majority of them have been Republican. Only 1 or 2 county sheriffs at least in my lifetime, for Erie County. So it's a mixed county where we will elect both Republicans and Democrats to countywide office.
But you're sure that there are Supreme Court judges in that judicial district that actually reside in Erie County?
Yes, certainly.
Not represent Erie County, but reside in Erie County.
I'm certain of that.
As you said before, I'll take your word for that.
Thank you, sir.
Madam Speaker, on the bill.
On the bill, sir.
Listen, in this bill, we've already put forum shopping in law, and now you're putting judge shopping in play. First, you told us where you can take the cases. Now you're telling us who can hear the cases. My friends, we sat here today. We hear again about racial and diversity. But to me, the judicial system should be about judging people on their character and whether they've committed a crime or not their race, not where they live, not where they come from. Judges are supposed to look at everything independently. To me, I can tell you right now, there are lawyers sitting around a table right now waiting for the vote of this bill, and I am sure that the constitutionality and how this bill came about, there'll probably be a lawsuit filed today or in the next few days once it goes through both houses if the governor signs it. But I don't understand why we politicize the judicial system. Everybody in this room knows that the only thing that we didn't talk about today was the politicization of the judicial system. And that's exactly what this bill right here does. It politicizes the judicial system. This says that we're going to only have judges of one certain party in that area hearing certain cases. And I just can't believe it. Madam Speaker, I will, even though my respect for the sponsor of this bill, I call a dear friend, I will be in the negative on this bill, and I hope my colleagues that care about democracy and actually care about the judicial system will do the same. Thank you.
Thank you, Mr. Tague. Ms. Peoples-Stokes.
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
Yes.
Sponsor yield.
Thank you. I heard you mention earlier, in fact, I knew for sure that you had a bill in on this specific topic designed for the 8th district to change in a way that makes Erie County a district on its own.
Correct.
How old was that bill?
Oh, that was from last May, so it's been over a year.
Over a year.
Yeah.
And you also mentioned that our colleague from Monroe had a similar bill
Correct.
How old was his bill?
Quite some time. I know it wasn't done in the last, it's been a while. I don't know if definitively.
So these
but
are
it's been a while.
not new thought processes. These
By
are
any means,
things
no.
that have been thought about before and have been given some conversation to. I guess the next question I will ask is, do you know, I heard you mention more than once that twice your age and this person that you were talking to's age. How old is this process for establishing these districts?
It's a good question because it is a bit of a moving target. I've asked what I was going to say earlier, and it's sort of stark how bad it is. I spoke to a judge or a retired judge who is now, mid 70s, and I've asked him, you've been practicing a long time before being a judge. You're an attorney. How long has the judicial district, our judicial district, looked this way? And he said he thought it was turn of the century. He thought it was, beginning of the 1900s is the last time that our district where we live had been, And the trouble is, it's however old it is, it's so far back that we don't really have accessible records to determine when it was. That's how far back it's been, decades upon decades.
Okay, well, I think it's something like 200 and some odd years.
I believe it. It could be the founding district that never changed. It quite possibly can be.
And I'm sure you know, as I know, things do change after 200 or so years.
Yes, they do.
In pretty significant ways.
Yeah.
I guess the other question I want to be clear on is that the current judges who sit in state Supreme Court for this particular district, how many of them will no longer be a judge because of this action we're taking today?
All of them remain as judges. That is unaffected, and they're able to fill their full terms.
Okay. Thank you very much
Thank
for
you.
your comments. On the bill, Madam Speaker.
On the bill.
I had the occasion to go to a memorial service for Judge Sam Green's wife, Ernestine Green. Quite a pillar. I mean, this young lady was really a awesome community member. She was a retired teacher, an amazing fundraiser, a former chair of many of the very influential boards in and around Western New York. And her husband, Judge Green, was the first African-American man to be a state Supreme Court judge in that district. And for, I'm going to guess, 70 years, he probably was the only one. And that's not because qualified judges of color, either Latino or African-American, did not run for these offices, did not be educated, get in a position where they could become a judge at lower levels. They wanted to go to the next level. Some of them spent as much as $250,000 trying to win a race. And in all of these counties, I actually supported some of them and went with them. And I mean, I went into communities that I have never been in before, and most of them were not receptive. And I wasn't with the person who was spit on during a parade while they were trying to get votes. I wasn't with that person. I'm really glad about that, quite frankly, because it wouldn't have been pretty. My point here is that when time changes, things change, we ought to be amenable to some level of change. Now, since Judge Green is clearly retired, there has been at least a few other people who have made it to that court. One of them almost spent $300,000 just to get there. Not because it's a $300,000 job, but because it was her goal. It was her goal. It was her mother's goal. They actually wanted to go to the higher courts. And it took her 3 elections to do that. And all 3 of those times, she did have the support of the Erie County Party, but she did not have the votes in those other counties in and around. And because of that, it took her 3 times to run. And so, to me, this is not just about diversifying opportunities to run for office. It's a lot more than that. It's about that justice that we say is for everybody, that liberty that is for everybody. Well, it's for everybody. You can't say I got to go to Eaton in order to get elected when I know that people at Eaton are not going to elect me because they're going to elect their cousin. So I want to commend the sponsor of this legislation. This is something hard to do. because people don't want to see this kind of change when we talk about inclusion for real, for real. This is inclusion for real, for real. And maybe if there is an upcoming election and a Latino woman runs and doesn't win, we can't say she didn't have a chance. We can say she did have a chance, and she just didn't win because the most qualified judge won, or the one that the voters wanted the most won. In the city of Buffalo, in the county of Erie, we have wanted new judges at the Supreme Court level for decades and have not been able to get it. This might be our opportunity. And I want to thank the sponsor for introducing it, and I look forward to voting for it.
Thank you. Mr. Ari Brown?
Thank you, Madam Speaker. On the bill,
On the bill.
like my colleague, Mr. Durso, certainly not a lawyer. I swing a hammer for a living. I sat back. I figured the lawyers will work this whole thing out, and I heard questions going back and forth. Does this bill have anything to do with racial redistricting, racial gerrymandering? I heard yes, I heard no, I heard the question asked 1,000 different ways. It was kind of, it may be, it was. But thank God it took my two colleagues, Assemblywoman Walker and our esteemed majority leader, to point out that is exactly what this bill is all about, racial gerrymandering. Racial gerrymandering violates the Equal Protection Clause of the 14th Amendment if race is the predominant factor in drawing district lines. It's a Supreme Court precedent in Miller versus Johnson, 1995, and Bush versus Vera, 1996. The court held that race cannot be the predominant factor in drawing any district, including judicial districts. And for that reason, Madam Speaker, this bill certainly won't pass judicial muster, and I will certainly be voting in the negative. And thank you, Madam Speaker.
Thank you. Mr. Chang?
Thank you, Madam Speaker. Would the sponsor yield?
Will the sponsor yield?
Yes, sir.
Sponsor yields.
To be honest, I'm not familiar with upstate New York. District I live in, Brooklyn, and all my life is downstate. And
Come on down anytime.
didn't come up.
Yeah.
Yes. And I had a question with my colleagues and arguing about the 8 judicial districts and whatever judicial district in Erie County, which I have an idea where it is, but I don't know exactly where it is. But how would that factor in my community of Asian community, where the population of New York State represented about nearly 12%, New York City gets 3/4 of it. How would judicial redistricting actually will balance out our community in upstate?
You're asking more or less, how does this potentially affect the Asian community in upstate New York?
That's correct. If it's so few judges, I don't know how many Asian judges are at 67 there.
I can tell you that in the 4th Department, which is the department that sort of are the districts that we're talking about, currently there are no judges that identify as Asian or Hispanic. What I will say is, just using my county as an example, I used some of these numbers before, but I'll give you the rest of them. It's that, this district, the current 8 judicial districts, serves about 1.5 million people, and 61% of them reside just in the one county of Erie. And Erie County is the primary home for communities of color within the district, representing 90% of its Asian population of the entire judicial district are in one county. So it's staggering. It's 83% of the black population and 68% of the Hispanic population are all located in one county. That county being its own judicial district presumably means that there is a higher probability that a person of color could seek the office and potentially be elected. That's sort of the numbers of it, is what I'd say.
As you mentioned a little earlier, that this hasn't been redistricting for many decades from your research.
Correct.
So before you go, I don't mind change. Change could be good. But have you decided perhaps create a commission to make this study other than just this bill and make this drastic change without further study?
Yeah, I guess what I would say is the state constitution is clear that the responsibility for making these, I guess, creating new lines is wholly on the legislature. And I would say that although there has been countless members of these legislative bodies that have come and gone in the last, what could have been 100 plus years, they've never taken this up. And there's a reason why they've never taken it up. It's because some people don't want change. It's because there's some people that simply benefit from the nature of how these current districts are drawn. And I believe that over time, they have become less and less reflective of the communities found within them. So it's taking an act of this body to move under its constitutional duty to address it. I think waiting another year would be unwise, especially considering how stark the problem is in our judiciary.
Because it has definitely an unintended effect, because it will change the resources, manpower, real estate, everything when you start changing these district itself. I mean, and we have to budget for these costs as well.
Yeah, I would say, unlike other divisions of state government, OCA has a really broad set of abilities to determine and allocate resources to regions that they feel are needing of it. And that doesn't change here. You know, the budget of OCA is what I'm told to be near $3 billion. What we're talking about here in cost is potentially not creating new judgeships, not building new buildings. We're talking about, you know, the small incremental amounts that are absolutely nominal, not just in the face of the grandness of our state budget, but certainly even in the grandness of the OCA budget. So, you know, if we were having a conversation of creating a lot of new judgeships, I would agree. But that's not what we're doing here.
You know, we lost populations for a past decade, about more than 1 million, I believe. And that's just only that unintended effect, but the previous case, old cases may be residing in one district and potentially have to relocate the other. I'm not sure you're able to grandfather those old cases that's still impending.
Yeah, I guess I would just say that the actual judges themselves aren't changing. Obviously, if they choose to retire or they're aged out, that would be different. But you know, the judges and their cases that they currently have, they'll continue to have with minimal disruption, truthfully. And remember that OCA does have the ability today, with or without this bill, to allocate a judge in County X versus County Y today, and this doesn't change that. So I perceive the disruption to be very, very minimal.
Well, thank you very much, Mr. Rivera. And on the bill, please.
On the bill.
Okay. I think we can kill several birds with one stone if we want to do this redistricting of judge during every 10 years when we do redistricting our assembly. I think we should marry up the same time, because it's a process that because we have a commission every 10 years to make this redistricting. We don't need to do this in between the 10 years. We can wait for a few more years. I mean, we waited for at least several decades or more, maybe 100 years. We could wait a few more years until we lined up during the redistricting year, and perhaps we can do this all in one big draw. Thank you very much, Madam Speaker.
Thank you. Ms. Walsh.
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
Yes, of course.
Sponsor yields.
Thank you very much. So I read through the whole bill, and I also read the memorandum of support, and a few people have referenced that. But in the memorandum of support that you provided with the legislation, there's a justification section, and it specifically says that this bill aims to address that inequality, and because you had just cited some statistics about particularly lack of racial diversity. You say this bill aims to address that inequality by establishing 2 new judicial districts in the 4th Judicial Department. So I guess, and I don't think anybody's really asked you this, maybe directly or as directly as I'm going to ask you, how do you believe that this legislation will remedy racial inequality?
Oh, because as the numbers that I've stated before, within each one of those judicial districts, the current judicial districts, the uniqueness about them is that the thing that makes them all similar is that in each one of those 3 judicial districts, a central, dense densely populated, diverse county exists, an urban center exists within that entire judicial district.
Yes.
So allowing that single county to be its own judicial district does address it, in my opinion.
But how so? I mean, the way that Supreme Court judges are elected is unique. It's not like the way that we're elected. As you mentioned before, there's a judicial convention. There are judicial delegates that go to a judicial convention. Those judicial delegates, there are petitions passed to select those judicial delegates. So have you done any looking around to see whether what's the diversity like for judicial delegates right now? And how do you think that would change after this legislation? Because isn't that exactly, I mean, isn't that your premise, is that if we have racially diverse judicial delegates, that will then result in a racially diverse slate of potential judges to be elected by this urban center in this district?
I would disagree that the issue is with the judicial delegates entirely. I would say the issue here is with the judicial, folks that are seeking the office of a judgeship today. There are people fully aware and fully capable of the ability to seek a judgeship, and either A, they perceive themselves to be outside of that process, just as much I'm sure that there are people that perceive themselves to be outside the process for many offices, but especially this one, under the thought that just because, you come from a neighborhood, a community, a county that has many, many similarities demographically to you, because you're lumped in with 8 other counties, in some cases even more other counties, it minimizes the probability of being represented by someone from your community. And I'd say that, as I said before, from somebody from Allegheny County. If you're from Allegheny County, the probability that you will represent or you will be seen by a judge from Allegheny County is highly, highly improbable. So that sort of, representation issue exists in the urban centers, and it exists in the rural parts as well. So I think that, taking into account the changes in population that have happened over the last century, it's clear why we have the issue we have in the Fourth Department of only having 2 judges and the entire Fourth Department being people of color.
All right. I mean, I'm just saying that if judge candidates are selected at a judicial convention by judicial delegates, and those judicial delegates are white, I don't know if they are or not. That's what I was asking you. But I mean, isn't that how you get to the candidate on the ballot, is through a convention? So
I guess I disagree that just because a judicial delegate is of one race, they wouldn't be likely to support a person of a different race. I guess I disagree with that position. What I will say is, as long as the judicial districts look like the way they look, we were forever going to have the problem that we have currently. I'm not looking to change the process by which we elect judges in the mechanics of how parties pick judicial delegates and petitioning. That's a process that exists, and it is what it is. I find the people that collect petitions to be reflective of the communities that they're from, and that's fine. I would say is, if the end result is what we have today, it is insufficient. And the reason that I think it's insufficient is because we've been comfortable with these lines as they've been for the last countless amount of decades, and that's where the problem is.
Okay. Well, let's say that in another 10 years, I mean, the previous speaker thought it was a great idea that we should maybe redistrict every 10 years. I don't think I really agree with that. But let's say in 10 years we look and we don't have any more racial diversity as a result of this legislation. Would you then introduce a bill that would say that, well, it looks like we got to look at the judicial delegates now. We got to make sure that there's racial diversity with the judicial delegates, because obviously it's not resulting in more judges, which is what our goal is.
I guess if the premise is that I'm here in 10 years, it's to be seen. But what I'd also say, not jokingly, is that these terms are 14-year terms. So that also has to be taken into account, too.
Okay. All right. Well, thank you very much, sir. Madam Speaker, on the bill.
On the bill.
So I want to just note at the outset, I mean, this is a really important debate, and it's just come to my attention. I'm so sorry to report that the live feed from this debate cut out for an hour and a half. So unfortunately, for folks who are trying to watch this being debated live, you missed a really big chunk of what was a very important debate. So I really hope that when when this, I think the last time it happened was when we were debating medical aid in dying. It also cut out for a period of time then too. So I really hope that when the full debate is available to everybody who might want to watch it later, because it is a very important debate, and I think it has a lot of implications, overall. So I want to say that, I listened very closely to all the previous debate that we've had, and what I found out is that in developing this legislation, there was no consideration of how this legislation might impact the Board of Regents. There was no consultation with LAT4. There was no consideration of court backlogs. There was no consideration of the unified court system's view that this legislation should be deferred until next session at least. There was no consideration of the Onondaga County Bar Association's concerns. So I would ask rhetorically, since I'm on the bill, why are we doing this bill suddenly at the end of session? The reason that was given and has been talked about is that we want more racial diversity. We want to remedy the inequality that there are only 2 judges that are racially diverse in this area. I would say this. There are plenty of different ways that we can try to, and listen, I represent an area in upstate New York that is very white. And we are trying to, it's very white. And we try through our local bar association and through a number of efforts in our county to try to encourage people of color to get involved in our process, particularly attorneys that want to get involved. And it's work, it's uphill, and it is taking a while. But I would say that the way that we try to get more diversity on the bench is, I think we need to start at a very grassroots level, trying to reach out to individuals who have recently graduated from law school and try to engage them in the process. And we know that the process has got politics in it, right? I mean, we can all say that there's no politics involved, but there's a party structure that leads to a convention that then puts candidates up. So we need to encourage people of color to get involved in the political process, both sides of the aisle, and try to have those people see a future and see themselves being able to get on the bench. But the way that this bill is being done, unfortunately, is either 1, social engineering, or 2, plain partisanship, or 3, both of the above, right? So I don't think, no matter how you slice it, this, to me, is a very offensive bill. I don't believe that this can be legal for the reasons that my colleague sitting in front of me referenced in his discussion. What do I want to see in a judge? What do I think are the top qualities in a judge? I want excellence. I want the best. I want judges that are impartial, that are independent, that are rational, that are fair, that are reasonable, and that have a good knowledge of the law. And I don't care, and I don't think most people care what color they are. We want excellence. That is what we're looking for. How do we achieve that? I don't think we achieve that with this bill. I don't think we achieve that at all. I think what we do is, as been pointed out by others, is I think that this really just creates a very cynical, very distrustful attitude towards this legislature and also the judiciary. I think that this is the absolute wrong way to go about this. And, I feel like a little bit that as one of only 3 women in the minority conference here out of 47, I think I speak, from some experience. I think that, I wish that there were more women in my conference. I work towards that. I try to encourage more women to run for office, to become engaged, to see themselves. I personally don't believe, and I won't disclose my age because, as my grandmother said, you never ask a lady her age, but I've been around for a while. I've been practicing as an attorney for a while. When I started practicing, when I came out of Albany Law School, 50% of my graduating class were women. And then when I went into trial work, when I did my first trials, you know how many women I saw? Nada. We weren't there. I don't know where the women went. I don't know if they went into state service Maybe they went into different positions that had more humane hours. I don't know. But they certainly weren't in trial work. You know, did I say that I wanted there to be a certain, quota number of women trial attorneys? No. I got in there and I did my cases. And I tried to be excellent. And I tried to be the best attorney that I could be, regardless of what my gender was. So I think that there is a way to encourage diversity in our judiciary, in our legislature, in business, in our lives. I don't think that this legislation is the way to do it. I do find it offensive, and I will be voting in the negative, along with, I would assume, a good number of us here. So thank you very much, Madam Speaker.
Thank you. Read the last section.
This bill shall take effect immediately.
A party vote has been requested. Ms. Walsh.
Thank you, Madam Speaker. The Republican conference will be in the negative in this legislation. Any other votes can be cast at the desk now. Thank you.
Thank you, Ms. Peoples-Stokes.
Thank you, Madam Speaker. The majority conference is going to be in favor of this piece of legislation.
The clerk will record the vote. Ms. Peoples-Stokes to explain her vote.
Thank you, Madam Speaker. To explain my vote, of course, everyone knows I'm definitely in support of this, but for the record, I would love people to understand that I've been a judicial delegate as well, more than once. And for clarity, it's the 8 Western New York County chairs from the multiple different parties that really break down what the decision is on who's going to be the person that runs for office and who's going to not only be the person, but who's going to get the support from their respective areas. So again, I want to commend the sponsors of this legislation, and I look forward to the results of it. And there is no guarantee that it's going to elect judges of color, because quite frankly, the only way to do that is for there to be a state Supreme Court race that focuses just on one half of Buffalo. If we had that, then we can assure that, but there's no way you can assure it otherwise. But there is an opportunity to elect people like that, because I know the people who live in the community, and I know that they're more open to diversity than other communities are. Thank you.
Ms. People-Stokes in the affirmative. Mr. Bologna to explain his vote.
Thank you, Madam Speaker. As the sponsor said a little bit ago, when talking to Mr. Chang, that 96% of the Asian population in Western New York resides in Erie County, thus making the probability of ethnic and racial diversity high, by concentrating the judicial district to just Erie County. It makes it more probable. By definition, that is racial gerrymandering. In my view, that is unconstitutional based on the Equal Protection and Voting Rights Act. In addition to which, the assertion that this would be a negligible amount when the OCA is already saying that this is going to cost $9.6 million. Again, it's very frustrating to hear that during the course of a debate. The OCA also says that it costs about $1 million to bring in a new judge. We could have 10 new judges in Western New York for the amount of that this is going to cost, and kind of let the chips fall where they may. So that is, again, frustrating to hear. I have a feeling that we're probably going to be hearing from the federal government regarding our HAVA funding for racially gerrymandering judicial districts. So vote in the negative.
Mr. Bologna in the negative. Mr. Bronson to explain his vote.
Thank you, Madam Speaker. I rise to speak about this bill and to thank the sponsor for bringing it forward and for doing an excellent job during the debate. We are constitutionally authorized to do this. So all the complaints about why are you doing this and we should leave it for a different time, we have the authorization under the New York State Constitution to do this. I strongly believe that this measure will transform the Supreme Court in these various districts. It will move the Supreme Courts to be more reflective of our communities and our counties. It will indeed allow us to elect a more diverse bench, which we do not have in Monroe County, and a bench that reflects the community. And, I think we'll get there because our delegates reflect the community. This is not gerrymandering. This is recognizing that dense populations in these particular counties have not been represented. Those communities have not been represented, and it will help us. I will share from a retired judge from the community who wrote me when this bill was introduced, which combines a bill that I carried previously. This bill does the job in transforming the Supreme Court in our region. Over the long run, the judiciary in our community, in Monroe County, will better reflect who we are as a people and who we are as a community. Once again, I thank the sponsor, I thank the speaker for bringing this forward, and the team and our staff for making this such a good bill. Thank you, Madam Speaker. I vote in the affirmative.
Thank you, Mr. Bronson in the affirmative. Mr. Kluczynski to explain his vote.
Thank you, Madam Speaker. I rise to explain my vote today. After hearing this debate go on for several hours, it's very clear that this is an unnecessary bill and is very divisive. Gerrymandering of our judicial system, while it uses the text of this being to increase diversity, it's obviously judicial gerrymandering. The only color involved here is red and blue, and we shouldn't be using that for our judicial system shouldn't be based on political ideations. So for that reason and many others on this bill, I'll be voting in the negative.
Mr. Kluczynski in the negative. Mr. Ra to explain his vote.
Thank you, Madam Speaker. So just quickly, because I ran out of time earlier, I want to point out, as we talk about this as if it's, a issue of race, the fact of the matter is many of these judges get cross-endorsed in the current system. And so that means that even on the side of the aisle that's pushing this bill, leadership politically has chosen not to nominate individuals that you're saying would reflect the community to the bench. So I don't know why that is. But I think that's something that needs to be pointed out. Even earlier this week, the Senate went through a confirmation process. There were Court of Claims judges, interim Supreme Court judges appointed. Did the governor prioritize judges who were more reflective of the communities made up for in these districts? So let's be realistic about what this is. It will make sure that, in particular, one district that we have now restricted the ability of New York State residents to bring constitutional election challenges. It'll essentially make sure that there is one party in every single one of those judgeships, and they will be the only one that will get those cases. Let's be realistic about what we're doing here. I vote no.
Mr. Ra in the negative. Mr. Meeks to explain his vote.
Thank you, Madam Speaker. The Honorable great Martin Luther King Jr. once stated, "The time is always right to do what is right." I want to commend the sponsor on this legislation. It is absolutely necessary. I look forward to these things being implemented. Truthfully, it will not happen quick enough. However, I support this legislation. I'll be voting in the affirmative. Thank you.
Mr. Meeks in the affirmative. Mr. Molitor to explain his vote.
Thank you, Madam Speaker. When a court stenographer or an interpreter applies for a job within a district, the job opening is under that district. And, I have a lot of problems with this bill, but one of the, I think, unintended consequences of this bill is you're severing rural communities from their population centers. And I think you're going to make it harder for those districts in rural the judicial districts that represent rural communities from having enough qualified candidates to staff their courts. I think it's going to be a real problem. I think it's a major unintended consequence of this bill. For all the reasons cited, including this one, I'm voting in the negative. Thank you.
Thank you, Mr. Molitor in the negative. Mr. Burrows to explain his vote.
Thank you, Madam Speaker. At times, I like to always delve in reality. And so when you hear of times when people are speaking of change, to me and many others, that means they have a hard time with moving forward to changing things for the better. And so I have to commend the sponsor for this bill, because for me, this change represents something positive throughout the state, in particular his district. And so when we hear the word gerrymander, I'd just like to recite some words, put my teacher's cap back on. Whenever the term gerrymander is discussed, typically it's the other side of the aisle who has committed gerrymandering in order to disproportionately give themselves an advantage in political persuasion. So with that being said, when we hear these terms being thrown out, we have to know that gerrymandering usually doesn't help the Democratic side. It's always being addressed to help the other side. And so I would like to just be someone who delves in reality and say, when you hear these words, let the words apply to what it actually applies to. And in this case, it doesn't. We're actually trying to fix some of the rights and the social ills that have gone on throughout this state and in the country for hundreds of years. And so for that, I am voting in affirmative.
Mr. Burrows in the affirmative. Mr. Riley to explain his vote.
Thank you, Madam Speaker. Just point of clarification. I think there were some maps that were thrown out in New York State for gerrymandering, and I got news for you. This side of the aisle did not have control. So I will be in the negative on this bill.
Mr. Riley in the negative. Mr. Lamondes to explain his vote.
Thank you, Madam Speaker. I rise to explain my vote. I listened to the debate very carefully, and I want to highlight the comments made from both sides. But the most important thing said here today was the comments from our floor leader, Ms. Walsh. And I want to hit the notion of professional ethics and the need for impartiality. And this debate took me back to my military career, where over 3 levels of command in 27 years of time, I adjudicated hundreds of disciplinary cases from every ethnic group in this country, and never once had anything challenged. And there's at least one former JAG in here that would say, hey, that's a pretty good accomplishment. So the notion of this gerrymandering and the perceived necessity of this change is completely based on reasons that don't make sense. And I think that if we were true with ourselves and really professional, I would hate to think that any black judge or any white judge or any Hispanic judge would adjudicate circumstances before them any differently based on the person that was before them of a different race. Thank you. I vote in the negative.
Mr. Lamondes in the negative. Are there any other votes? Announce the results.
Ayes 96, nays 48.
The bill is passed. Page 15, Rules Report 699. The clerk will read.
Bill number 8871, Rules Report 699. Mr. Delon, an act to amend the correction law.
An explanation has been requested. Mr. Delon.
Thank you, Madam Speaker. This bill would enact into law, if signed by the governor. It is an omnibus bill that would enact 10 bills and 11 ideas, legislative ideas, into 10 parts, and they all vary by issue area.
Mr. DiPietro.
Thank you, Madam Speaker. Would the sponsor yield?
Will the sponsor yield?
Absolutely.
The sponsor yield.
Thank you, Mr. Delon. Let's start with on Section J, there's some things where the incarcerated will have, is it up to 3 years after they're released to possibly bring any actions?
Yeah, so if I may, a second, Mr. DiPietro, in my opening, I omitted that the main goals of the bill are to achieve accountability, transparency, and oversight in light of the 2 homicides and many other untold others that we've seen recently. So specifically to your question,
yeah,
if you could repeat it for me, I'm sorry.
Oh, yeah. On Section J, it says they will have the ability, the incarcerated individual, the ability to file within 3 years after release from custody a notice of claim or notice of intention to file a claim related to civil actions to recover damages for both physical and or psychological or other injuries.
Okay,
I just wanted to double check. So it's 3 years from release date?
Yes, I take it you mean Part J, not Section J.
Yeah.
And yeah, I guess the idea behind this was as a safety measure from time to time, incarcerated individuals will choose to remain silent about any potential abuse that may have happened to them while they were under custody. So if they choose to do so as a safety measure, currently the statute of limitations is running on them. So by the time they're released and they deem themselves to be safe, they may have lost the opportunity to bring an action. So yes, this does give them 3 years upon their release to commence one.
When you're talking physical or psychological, are those to be able to bring a suit or action? Do those have to be documented at the time when they are incarcerated?
Well, I think if for clarity, it was initially a bill sponsored by Assembly Member Cruz. I think she could speak more to her intent, but the way it appears to me, it is a safety measure. So I believe it doesn't have to be documented, because if they document it, that is the trigger for an incident that might put them at harm and therefore jeopardize their safety. So no, it doesn't have to be. They can commence it afterwards.
What will be the parameters on proving that someone on the physical side was harmed?
Yeah, so there's no specific requirement, but obviously they'd have to be able to prove that it has happened, and the ordinary pleading requirements still apply.
Okay, so I'm just trying to sort this through. So let's say, hypothetically, an inmate has an altercation.
An incarcerated individual?
An incarcerated individual has an altercation with a CO or another inmate. If another inmate does physical damage, can they still sue or bring action against the state, being another inmate incarcerated individual versus?
Yes.
Point of order, please. Point of order.
Yeah,
we need to not have this conversation going on in the background throughout this whole debate. Would you please, Madam Speaker, admonish the gentleman to the back of me to please keep his mouth shut, please.
We will have questions and answers only during the debate. Outside conversation should be taken outside of the chamber. If you wish to speak, put on your light and we will call on you when we get to your turn. Mr. DiPietro.
I'm sorry. Thank you, Madam Speaker. Sorry, Mr. Dillon. The incarcerated individual, if it's incarcerated individual on an incarcerated individual, is that grounds also for an action?
Any actions that have to do when they're in custody, so potentially, yes.
Okay. So incarcerated individual attacks incarcerated individual and say hurts him in the arm or in the leg. And obviously it heals up and he's fine, but how would that go if he comes out when he's released? How would you bring an action and how would that work? Would he just say, I was injured by another incarcerated individual?
Same. So it would be the same as if he was. Yeah, it would be the same as any other, same as if he wasn't in custody, same as it would be on the outside. But what this would do would give him, the 3-year period, give him or her, the 3-year period if they think their safety's at risk to delay that proceeding.
Does it change the degree of proof?
No.
It doesn't?
No.
So this is I guess I look back to a bill we passed a number of years ago, I think you were here, where it's the look back bill, and I know this is only 3 years, but I'm just looking at, so without any proof, there were people claiming that they had been abused 50 years ago by someone of the clergy, and they were getting these settlements. And now I know this is only 3 years, but is that a parallel thing because of the fact that the claim is being made without?
So
first
I guess
off, without just
if
without.
I think I know where you're going, there's no look back provision. in this bill, it would only be eligible at the time it becomes effective under the section.
Okay, so just because I'm trying to be clear, that's physical damage. Psychological damage. I would think that anyone who's incarcerated, actually going behind bars, and I've toured every facility in my district and others outside my district, it's pretty intimidating. And I would think that most incarcerated individuals would be able to claim some sort of mental tragedy by being in there. What degree does it have to be to bring that?
So we're really not adding anything new. Currently, if they want to bring these claims now, they can. The problem that I believe the sponsor is looking to address is that if they opt to choose silence as a safety measure because they're afraid of what may happen to their physical person, they can choose to delay commencing that action 3 years after their release. Everything else about it, doesn't change. If they want to commence an action while in custody, they certainly have the right to do so. This doesn't take that away. It would be similar if I go further as an elected official. The statute of limitations on anything we do that clock doesn't start until we're out of office.
So I appreciate that. I just look at, I'm not questioning the 3-year period. Okay, I understand why that's in there. What I'm trying to get to is what are the facts that are going to be presented in front of a judge or a jury from this incarcerated individual to prove that there was physical or psychological damage so that they would be able to get an award?
This section doesn't change any of that. All the section really does is give them an additional 3 years post-incarceration. So whatever facts or protocols or laws that are currently on the books will remain. The only additional benefit, if you will, is for them to choose to protect themselves, but not miss out on, I guess, commencing the proceeding that they would still have to prove an additional 3 years after they're released.
Okay. Understood. Is there, under current law, is there a limit to rewards or monetary values that they can receive? Is there a limit?
I mean, I guess what I'm hearing is that it's really outside the scope of this bill. I guess there would be, under current law, it would be like any other proceeding that could be commenced, whether incarcerated or in the free world. The difference is really the same.
So you're not trying to change that aspect of the law that's current, correct?
We don't change that at all.
Okay, that's what I wanted to see. Mm-hmm. Is there anything can you expand on, is there anything that improves the safety of the corrections officers? I know there's a few things in there, like with the cameras. Can you expound on those?
Well, I mean, as in the case with Robert Brooks, I mean, it's long been the sense of a lot of folks who have had family members who are incarcerated and have had them died and maybe thought they were murdered but couldn't prove it because there were no cameras. I think the profoundness of Robert Brooks' murder is that is probably the first one that was on camera for the entire state and the entire world to see. And I believe what everybody saw, they can't unsee. So the cameras potentially could do the same thing for any type of assault or murder of any kind, whether it is incarcerated, whether it's officer on incarcerated individual. So the cameras show you what they show you. It's not intended to benefit one side or another. It's intended to give us more transparency, which is why it's important to the title of the bill, because we want to deal with the facts of what happened, and we also don't want to allow, any entities to basically hide or change the facts of what actually happened.
No, I agree, and I've talked to a number of corrections officers who are in favor of more cameras for their safety. So it goes both ways. It's a two-way street.
Well, and listen, if cameras improve safety for everyone, I think that's a laudable goal. I also hope, and I believe it's the hope of many others, that having the additional cameras, both fixed and body-worn, will be a deterrent on abuse of imprisoners and hopefully a deterrent on murder of incarcerated individuals.
So, thank you. With when this bill was getting put together, were there any discussions that you could alleviate or expound on that had to deal with the overtime issue with the corrections officer? Was that ever discussed in bringing any of this together?
Well, that's a function of the executive. We tried to stick to, the legislative aim, the legislative functions. We looked at agencies that, clearly were broken in terms of accountability and transparency. But to get into functions that the executive needed to do with their labor force, we did not consider that. We left it to them.
Okay. No, well, I appreciate it, Mr. DeLon. I appreciate those answers. On the bill, Madam Speaker?
On the bill.
I want to thank my colleague. This bill, when I look at when we were trying to alleviate some of the tragedies that have happened on both sides between the incarcerated individuals and the corrections officers, I just don't think this bill goes far enough. It does nothing to address the main causes of the strike that got the attention of the entire nation, and those were the mandatory overtime and the HALT Act. So this bill, I think it could have gone a lot further than it does. It does, I guess, it does put some parameters in place. I just expected when we knew the majority was working on this, that we expected a little bit more. It just doesn't seem to follow that. Pardon? Yes.
Go ahead, Mr. DiPietro.
Okay, thank you. The main parts, obviously, which were very grievous, was the fact that this strike was not about money and that the governor threw money at it. When I talked to some of the negotiators, they were just dumbfounded. And I want to tell you a story that I was told personally by one of the mediators. And it was on that week when they were going to mediation Monday, Tuesday, and Wednesday. And on Monday night, while this strike was in full blown, the governor went out in public and said, "I don't know why they're striking," to which the mediators on both sides, from what I was told, went ballistic. They called her and talked to her. And they said, "When you can't make statements like that, but when we settle this, we all got to be together. When the corrections officers come back, we've got to put this all to bed." And what I was told specifically was that she was adamant that she wanted them to be put in jail, everyone who struck. And that was just very, very, very disheartening to hear that. And the one quote that stuck with me that this gentleman said, he said, on both sides of the mediation, he said, "We were the adults in the room. We were the adults in the room." That the governor was so adamant and so petty to make sure that these officers were put in jail and were never going to work in New York State, and we've seen the results of that they could not believe it. And so that's just one. The other is, it goes both ways. There is a gentleman who died on the job a couple months ago, 3 months ago. Because there was a posting that said if he took time off, if any corrections officer called in and tried to use sick time or called time off, that they would be terminated. And that was posted, and they have copies of that. Well, this gentleman was forced to work a 24-hour shift followed by 16, 16, 16, 16, and he kept telling from day one that he didn't feel well. He told his supervisor, and he was told that he would lose his job, so he kept coming to work, and he died at the facility. And there's going to be a lawsuit, I think, pretty soon on that one. So this is how bad it got. The HALT Act, which was not the main reason they struck, because it was all about the overtime and being away from their families. If anyone had been following this, there were people that had not seen their families. They'd go 16 hours, and then they would go home, sleep, get up and work another 16, come back. I got so many stories of corrections officers who were not able to put their kids on the bus, had to hire babysitters and neighbors to come over and watch their kids for weeks at a time, unable to see their family or get their kids to school, pick them up, be with them on the weekends because they were forced into working. This is unheard of. And this is where we should have been putting the focus on remediation for these corrections facilities. That's one of them. The other is the HALT Act. From every corrections officer that I've spoken with, that was probably the biggest tragedy, and that's probably why we're here on this bill. But if we did not have the HALT Act, every corrections officer will tell you that gentleman probably would be alive today because of his actions when they were transferring him. And again, nothing's going to make any of that any better or justify anything they did. But the fact is, as soon as there was an issue, they probably would have put him in the SHU for 24 hours or 48 hours, and that never would have happened, and he'd be alive today. And every corrections officer will tell you that. So the HALT Act did the exact opposite of what it was supposed to do. And now we have a tragedy on our hands. So with that, Madam Speaker, there's so many other things, but I know I want to let others have a lot of other questions on this. And I just wish that this had addressed more. It's a start, this bill. There are some good things in it, but overall, it doesn't go far enough. It's got some things that are negative, and I'll be voting in the negative. And I just wish we had done more because the entire situation has not been fixed, and this was supposed to fix it. Thank you.
Thank you. Mr. Ari Brown.
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
To questions germane to the bill, certainly.
Will
Yes.
you-
Yes, I
The
yield.
sponsor yields.
I yield. Yeah.
Okay. Thank you. Under Part B, what is the estimated cost to state and local governments? This is under Part B, Section 4, lines 6 to 9. Under Part B, what is the estimated cost to state and local governments of mandating long-term video storage in the correctional facility? And how do you justify forcing counties to potentially store tens of thousands of hours of footage for years with no funding mechanism? I say that because I did something like that on a smaller level, at a village level, to store meter footage for a parking stall, people backing into parking stalls, and it was a fortune. This could run tens of millions of dollars.
So I would say to the question, this had already been funded in the budget that we just passed to the tune of the $400 million that we added for cameras in the budget that we just adopted. So the funds can be taken from there. As it relates to the locals, this funding and this section applies only to state facilities. Locals are not included.
Thank you, Mr. Sponsor. That being said, what do you think this portion of the storage of this unlimited amount of hours would cost taken from the state's budget?
To speak to that, it was DOCS that had submitted the cost to the governor in the aggregate of the 400 million to speak to the detail to the cost of that. I don't have the answer. Maybe Ways and Means has it, but it's included in that cost. And I believe the technology that they are using limits to some degree, not completely, the amount of man hours it would take to do the storage and the like.
Right. I was trying to say, not to belabor the point, Mr. Sponsor, but the storage itself is very costly. I'm saying on a small scale for a little village, it costs tens of thousands.
Like I said in
Is
my
it millions?
previous answer, they're not included. It applies only to state facilities.
I understand. Thank you, Mr. Sponsor. Another question. Does this bill create any legal standard or chain of custody for the video evidence, or are we just handing over raw, uncontextualized footage to the AG, its political staff, with zero evidentiary safeguards, potentially opening up the door to manipulation, leaks, or selective editing?
Yeah, so it provides that if a correctional officer, if the incarcerated individual died at the hands of an officer, that information has to be given to the AG. In terms of the politicalness, it's the AG specifically. It doesn't say the AG from which party. Historically, AGs have changed parties over time. We tried to keep this as apolitical as possible and as much as on the substance of the tragedy as possible, and try to address the gaps in our agencies as much as possible. I think what most folks forget is that the AG wanted to try this case herself, and because of conflicts, she couldn't. And those conflicts arose because she was defending corrections officers who had been accused of abuse of people under custody. So I think it's important to allow, any AG, and I understand your concern, like we are politicians, it can be political at times, but this sends it to the newly created unit of the AG's Office of Special Investigation. Those guys are, not politicians, they're usually professionals. And this legislation, which was worked on in part by the AG, certainly tries to protect the AG's office, and they took careful consideration to wall it off from any conflicts. So I think they have gone a long way to try to view this as a substantive matter because they care about getting the policy right. And I know there's a lot going on in the national theater, but I think this it really has nothing to do with that. Folks are just trying to get their agencies structured right so that they can do the jobs that they were elected by the people of the state to do.
Thank you, Mr. Sponsor. Maybe I just wasn't clear. I hear what you said.
Okay.
I wasn't.
And if
wasn't
I wasn't,
about my
you can
question.
interrupt me and we can save
I don't know.
a
I
lot
don't
of time.
want to
and I'll get
interrupt
to the
you.
heart of your,
You're entitled
the heart
to
of your
speak.
question.
I was really getting into the chain of custody of the video itself, because what happens is it's stored where? How does it get to the AG's office? We don't have an Epstein-style. Hold on.
Okay.
An Epstein-style situation where the video disappear. Who's taking ownership of it? What happens to these endless hours of video? Is it in the cloud? Is it on a hard drive?
Yeah, so the bill's not prescripted in that manner. It's up to the agencies. Generally, this data is stored at DOCS. The part of the bill that you're speaking about lays forward the guidelines for DOCS that if an incident under these guidelines happens, that's when they're triggered by law to turn the information over to the AG's Office of Special Investigations.
Thank you, Mr. Sponsor. So let me ask, why should the state expose itself to this open-ended civil liability? This is Part J, lines 30 to 32. By extending the statute of limitations under Part J for years beyond incarceration. I heard your answer earlier, but even in cases where there's no physical evidence, no witnesses, and no way for the defendants to protect themselves after years. I understood why your answer was good, but there's a lot of circumstances where...
Well, I would say, why would we allow someone to bring a proceeding while they're under custody and they have to run the risk of bringing that proceeding at the risk of their life? I mean, what we want to do is give people as many tools that they can to protect themselves and keep themselves safe. Now, some people may not elect to care, and they certainly can commence an action now. But some people may say, the money or anything I may deserve as a potential award is not worth my life. And some people at the moment aren't thinking about money at all. They're thinking about their life. Our lives and our time is a lot more valuable than money. But then after you are released and you feel like you're safe, there is I believe many opportunities that have been missed, and I believe the sponsor believes that there's been many opportunities that have been missed to address it.
Thank you, Mr. Sponsor. And my next question, doesn't granting the Correctional Commission Association access to sensitive facility records, personal files, 24/7 entry rights without any judicial oversight violate not only privacy laws, but also undermine basic operation security and inmate staff safety?
Well, I would say this. I mean, I'm glad you brought up the State Commission. Oh, Caney, sorry. Could you repeat the question? I'm sorry, I got it confused with the State Commission.
There's no problem at all.
Talking on Caney.
Doesn't granting the Correctional Commission or Association access to sensitive facility records, personal files, and 24/7 entry rights without judicial oversight violate not only privacy laws, but also undermine basic operational security and inmate staff safety?
So look, Caney, what we're doing, Caney can do many of those things now. We're expanding the powers of Caney because historically, Caney was founded in approaching almost 200 years ago. Caney was founded in 1844 by people of the state of New York who are private. In 1844, it was citizens, and they wanted independent oversight of agencies back in 1844. In 1844, there were, our prison system looked dramatically different. And then 2 years later, this legislature, granted them that authority to monitor that you just prescribed to some degree, and that we're expanding today. But what it says to me, something profound happened before the Civil War in our state prison systems. And, here we are today, almost 180 years later, and we still haven't gotten our independent oversight systems as a state correct. So this is the first step out of many in an attempt to try to correct those issues. So I think it's founded. They're under the legislative authorization back in the 1800s, the legislature granted them the right to do these reports and share and provide all this information to the legislature and the public. And I would say in the recent incidents, it was the Caney report that was ignored that led to where we are today as a result of the murders. And I would say our actions here as a democratic body and as a legislature weren't to address a strike. And I think we have a difference of opinion as to why that strike was commenced. But, I would say that in this instance, had Caney's report been followed and more people would have been widely aware of what Caney does, potentially Robert Brooks's murder could have been prevented, because their report clearly said that instances of abuse on incarcerated individuals was abnormally high as compared to their other reports that they have issued.
Thank you, Mr. Sponsor. One last question. Under Parts A and F, how is it not a blatant conflict of interest for the Attorney General's office to investigate state officers and employees while also defending them in civil suits, or worse, to refuse to defend them and bury the records under the guise of internal conflict?
Yeah, I'm glad you asked that question, because that to me is some of the structural flaws that we have found since the murder of Robert Brooks. And then I would say one of my main concerns when we found out the severity of how bad it was, the first thing I noticed that there was a report of a death of an incarcerated individual. Then we saw the video, and we clearly saw that it was more than just a death. And then we got communications from the Attorney General's office that there's a potential conflict because the Attorney General may be representing some of the individuals who stand accused of murdering Robert Brooks. The Attorney General was also defending them on other matters related to abuse. And then a few months later, even though the calendar year was different, the same thing happened with Messiah Nantwi, and the Attorney General had to again recuse herself because she was defending herself on other actions, or she was defending corrections officers for other allegations of abuse. So in 2 homicides, the Attorney General has been like two for two and having to recuse because she has to defend folks who stand accused of murdering incarcerated individuals. Now, the first question it leaves you to believe is, how many other instances of abuse is the Attorney General defending corrections officers on? And I think that could be a clear indicator of who your problematic corrections officers are.
Thank you, Mr. Sponsor, for answering
And I certainly hope she doesn't have to go 3 for 3.
Thank you, Mr. Sponsor, for answering the questions. Madam Speaker, on the bill.
On the bill.
There's always the other side. You know, we have the incarcerated individuals, and we also have the correction officers who put their lives at risk every single day. So where in this bill is the protection for the correction officers who split-second decisions, often under life-threatening circumstances, are now going to be reviewed years later by activist lawyers with edited footage and a political axe to grind? There's absolutely nothing in here looking out for them. Blatant omission, and for that reason, I will be voting in the negative, Madam Speaker. Thank you for the opportunity.
Thank you. Mr. Maher.
Thank you, Madam Speaker. Will the sponsor yield to questions related to the bill?
Will the sponsor yield? Sponsor yields.
Thank you, sir.
Absolutely.
All right. First, I want to say in Part A, looking at the video disclosures and certainly other aspects of this bill where we're talking about the videos, I think that's going to help in terms of transparency. I think it's going to be an area where you're going to see, hopefully, encouragement in behavior. So we're very hopeful. I know a lot of us and a lot of CEOs that I've talked to that if and when this is implemented correctly, it can have a positive impact for sure. My first question is related to when we talk about the incarcerated individuals and some of the mandates that are put on getting that footage within 72 hours to the Attorney General's office, OSI. There are other similar issues, and I wanted to know if they came up in discussion when we were preparing this bill. When it comes to correction officers that also have to create reporting due to their use of force policy, is there going to be a similar type of access for them when it comes to accessing video footage when some of their superiors or folks that they're supposed to be talking to question some of their writings and their use of use of force reports?
So it wasn't contemplated in this part of the bill.
Okay, thank you for that answer. Funding. I know that we talked about in the budget what was funded for body-worn cameras, and I believe there was a very large number for cameras also related to prisons in general. I see there's a very, very aggressive plan here. I just want to make sure that funding in this capital budget is going to be enough. In your estimation, do you think it's going to be an appropriation next year on top of this year, or do you think it's properly funded in this budget?
It may be properly funded in the budget, but if the executive determines they need more, I'm sure they would have the opportunity to come back to us and make that request.
Okay, I just definitely wanted to be on the record. It's a very aggressive plan. These cameras are very expensive. There's a lot of places in the prison that are going to have interesting angles. So we definitely want to make sure that we're covering all of our bases and that's properly funded. So it's good to hear. I want to talk about Part C, notice of deaths. I just want to make sure this is perfectly clear. When this part requires docs to promptly notify the next of kin and any other person designated as a representative of the death of the incarcerated individual. This prompt notification will include the circumstances surrounding the death, the medical procedures used, and the cause of death, including preliminary determinations, as well as the final determination reported by autopsy results as such information becomes available. Is this just for incarcerated individuals or any death at a DOCS facility?
I believe it's in this is the Epstein. So any incarcerated individual.
So this is not in relation to a civilian staff or a correction officer who is killed or dies in a DOCS facility. This would not account for them as well?
No, but to my knowledge, the last line of duty death for an incarcerated individual, for a correction officer, was around 1982. This doesn't address that. This just addresses incarcerated individuals.
Can I ask why we are only dealing with the notice of death in correction facilities for incarcerated individuals and not correction officers, civilian staff, or even our National Guard service members? My thinking would be we want to try to put them on an even playing field in terms of their lives and the value of their lives.
Well, this basically amends Section 624 of the correction law's current law. So we're not creating a new section. Current law leaves it at incarcerated individuals and doesn't expand it to correction officers or non-correction staff. So I think the intent of the sponsor on this bill was to change the language to what does the language say? Shall contact, shall prompt. But that's what it is now. But what was it?
I think it's 24 hours after the next of kin or designated representative have been notified of the death of an incarcerated individual. DOCS must publish a public notice of such death on the department's website. Is that correct?
So the employers have to do the next of kin. I'm sorry, I couldn't hear the question because I was getting. Could you repeat it?
All right. I think we're on the same page there, though.
I think so, but I
it's
just
just
wanted to make sure.
incarcerated individuals.
Yes.
Okay.
Yes.
Okay. Thank you for your answer. All right. Going to Part D, study in deaths on DOCS correctional facilities.
Yep.
All right. So I know these records exist. I was looking up online. I was actually stunned by some of the statistics that are online. So I'm assuming the purpose of this section is to get a little bit deeper and get explanations. For example, in 2023, it looks like out of the 107 total deaths, 0 accident, 1 homicide, 68 natural causes, 8 overdoses, 11 suicide, and then 19 unknown. And then I look at 2025, it says 37 unknown. So I'm assuming that the purpose of this is to get a little bit more information. My question to you is, in your discussions of putting this bill together, why isn't this getting looked at a little deeper from DOCS? Have there been any discussions as to how we got here in terms of not being able to properly get into the details of all of these deaths that are occurring in any calendar year?
So I would say no, and I think this bill, this section has been around. I believe I debated it last session with Mr. Goodell, and certainly since then circumstances have changed. Certainly a lot of this is under the deaths and the reporting are certainly on DOC's website. That's some of the stats that you just read off. But Scott does this. So when we originally debated this, we wanted to take a holistic approach. And then certainly after what happened recently, we thought it applied even more to drill down on some of the answers or some of the questions you may just that you just asked. So we thought it was appropriate and put it in because, like you said, like we have a lot of questions as to how those numbers read the way they read, and I think further information and further detail on these deaths in the future would benefit us all.
I agree. I want to get then into Part H to follow up exactly when we're talking about the State Commission of Correction expansion. Look, I think this is a good thing. There's 2 questions that I have. The first, why were there no minority leadership appointments that we could also make for this? Was there a discussion on that?
Well, again, like I said earlier, State Commission of Correction was established again at the end of the 18th century, in 1895, roughly. And I think as it relates to appointments, the way the bill reads, the governor retains her 3 that she has now. That's the current composition. The current language says the governor appoints. It doesn't say the Democratic governor appoints. Then next it says the Speaker of the Assembly will have 2 appointments. President pro tem of the Senate would have 2 appointments. We found that over time, legislation in and around SCOC had been amended, and it had been sufficiently been amended by either party. So if you recall the Attica riots in the 1970s, the governor was Republican.
Right.
The Speaker of the House was Republican. The President pro tem of the Senate was a Republican, and they enacted good reforms in the wake of Attica. It worked then, and I believe it will work now. And the reason why I bring up the dates is that when you look at the context of the state of New York and how long the people of this state have been trying to solve this problem, the individual party really, is inconsequential because Republican administrations have done good jobs in enacting reforms, and so have potentially Democratic ones. So the reason why there's none lined out is because the way it's written, it's worked.
Okay. But your point is well taken. I'll look forward to revisiting that when we have a Republican governor in a little while.
Well, and under a Republican governor, the policy will be the same, and they would have the right to make their appointments. But it could take 200 years.
18 months? Yeah, we'll revisit that. Thank you, sir. Okay. I also want to talk about just reporting in general. Was it discussed talking about some of the injuries that are taking place, again, with civilian staff, with correction officers, with National Guard service members? And also, was there any discussion to the real serious issue going on within our state prisons in terms of fentanyl, other exposures that are creating hospital visits, and even our incarcerated individuals and correction officers and civilian staff to be Narcaned even and be taken to the emergency room? I know in my district alone, there's been dozens of those cases. I have 4 prisons within my district.
Yeah, so while those are important issues that I believe should be addressed at some point, it's really outside of the scope of the bill. It's about transparency, accountability, and oversight. And again, like I said, to many of people on the outside, this is a first step. And there'll be ways for us to holistically look at our government agencies and government systems to address a lot of the problems. But I think the intent here by us was not to look at issues that are definitely problems, like drugs inside our facilities are definitely problems.
Right.
Staffing problems and issues on why they may or may not have gone on strike. You could say it's a problem, but our intent here was to strengthen our government systems so that we could have better accountability on these agencies, have better independence on some of the information that flows from docs, and better oversight just generally and accountability should they decide to take actions that are not prescribed by a judge.
Thank you for that. I do want to go on the bill, but I have one final question I want to ask. When it comes to discussion of the body-worn cameras and the need to have them be sent to the AG, OSI in 72 hours, is anything related to the cameras that are put in this bill? Was there a discussion with the union? And is there a concern that there is an issue with the union contract? Should there have been some discussions there with the union for any of these policies?
No, but the union might have been, a little busy at the time, but no.
Okay. All right. I just wanted to have that on record. Thank you, sir. I appreciate the answers to my questions. On the bill, Madam Speaker?
On the bill.
Okay. So I really appreciate the answers to my questions and some of the acknowledgments to some of the concerns, especially the fact that there is a lot more work to be done. I think that acknowledgement is important. I do want to give appreciation to my colleague and many of my colleagues for sitting down and actually speaking to correction officers up here in Albany who had legitimate concerns. I hope to continue those conversations moving forward. I do believe there are so many things that we could have put in this bill that could speak to the staffing crisis and the safety concerns within our prisons. It is dark right now within docks in the state of New York. The current state of our facilities, really you have to go there to see it for yourself and talk to the folks and the families that are impacted. It is devastating, and it is getting far worse. We still have thousands of National Guard service members throughout the state of New York. We're spending tens of millions of dollars on a regular basis to fund them, and we're having real issues. While at the same time, we have correction officers who are going to the hospital due to exposures. One individual in my district, I'm not going to use his name, he hit his head, passed out due to an exposure, went to the hospital, ended up getting a TBI, reported back for duty, wasn't able to go back to work, applied for light duty, was denied, and was recently fired. While we have National Guard service members doing administrative duties, we couldn't find light duty for a correction officer and instead fired him. And there are so many different issues happening since the work stoppage where we really are ignoring folks that want to be in an environment and do well in that environment and provide a public service, and instead spending an awful amount of money and putting folks who are not trained in a position to potentially hurt themselves and others. When it comes to incarcerated individuals and the environment, we need to make sure that environment is safe for everyone. And I'm going to continue to pursue that route, working with our correction officers, our civilian staff, those that are incarcerated, their family members. And I just want to warn my colleagues in the future, when it comes to prison closures, we've really seen that not be something that helps the situation, but really only exacerbates it. I really want to be mindful going forward. I want to be able to work with everybody in a collaborative way, but on the record, it's just really important. When we talk about programming, when we talk about all of these things that we need to fix, we can't fix them without appropriate staffing levels. Appropriate staffing levels will remain in crisis mode until we have a serious conversation with both parties in the room. And right now, I don't think we're there. I'm going to keep working, and hopefully we'll get there at some point. Thank you, Madam Speaker.
Mr. Palmisano?
Yes, Madam Speaker. Will the sponsor yield for some questions?
Will the sponsor yield?
Yes.
Sponsor yields.
Thank you, Mr. DeLon. I know we've had a number of conversations offline at hearings, and I just want to say right up front, I just really appreciate how upfront you are. I know this issue has been very personal and very passionate for you because of the tragedies that would happen with Mr. Brooks and Mr. Natwey. And I know the one thing you said is, initially you were looking at it from a holistic perspective, because when we talked, and I know we had discussions, we talked about, obviously, there's what's going on with incarcerated individuals and violence inside our prisons, but also we talked about the assaults and things like that's going on with corrections officers. Was there any discussion, or when did it stop? Was there any discussion on trying to address that as part of this package, or not really at this time? I know we've talked about HALT and repeal of HALT's down on the table, but was there any of that discussion to try to look at this holistically, to look at the conditions that the corrections officers and staff are working in?
So when you say holistically, you're correct, and not just me, myself, and many of my colleagues, right. many members of the caucus, because a lot of this information derived from legislation that they introduced. And I think there are many things that the caucus were promoting that, hasn't made it yet into an omnibus bill or to this floor that we still support. That included a holistic approach too. But I think what we did here was, again, try to see if we could at least get a two-way agreement with the Senate on the systemic issues that clearly have not worked, to see if we could get a package that would immediately stop the murders, get a package that could help reduce assaults find out where our systems again were broken, and address that. There were many other conversations that we addressed. HALT, certainly has been discussed publicly, came up at hearings, it's been discussed privately. I've made plenty of public comments on HALT, but this bill really wasn't considered to be an attempt to address or do anything as it regards to HALT. So,
I understand
in that regard, no.
I can understand that. On the issue of body cameras, I know this has come up a couple times. I know we have a policy that's kind of used, and this is going to be taking a statewide policy. Does this bill do anything to ensure, or is there going to be regulations in place to ensure, number one, ensure proper training is received, and that the cameras are maintained, the equipment are properly maintained and functioning? Does this bill address that or say anything, speak to that at all?
This bill doesn't do that specifically, but that was addressed in the budget that we just passed.
Okay. Would this bill or what we passed in the budget just deal with the clear guidelines on the use of cameras or maybe lack of use? Sometimes we hear about it being in sensitive areas must be considered or accommodated. Does this bill address that, or was this addressed in the bill that we passed during the budget? Or is that something that's got to be looked at?
Yes, it does. And then additionally, some of the things that the governor enacted after the murders, some of her initial actions that didn't require legislative actions will go to do that as well.
Okay. And I do agree. I think this use of body cameras is going to be a good thing. Obviously, we saw the horrific abuse of staff on the video cameras, but also this could be used in a way when, on the other side, these video cameras will be able to capture things when maybe there's accusations or unfounded accusations against CEOs by others too, right? So it's basically there to catch everything. So I think the video cameras is a good part of this bill. So I just wanted to mention that.
Yeah, and I would say, look, it works all ways, but I think we want folks. The job is already hard enough, and for the folks who do the job the right way, they deserve protection too. But for the folks who are the bad actors and potentially give a bad name to everyone else that's doing it right,
That's true.
For the folks that are doing it right, they deserve protection too.
No, and I appreciate you saying that, because one thing we don't want to do is paint everyone with one broad brush, and that's why we want accountability and transparency. And I think just part of the bill, I think, is a good thing. I did want to move on, and we were talking about the Commission on Corrections, and I won't want to belabor the point on the minority appointments. I get that. I think what I'd probably say, and maybe I'll elaborate more on when I go on the bill, but I think the reason we talk about minority appointments is because, there might be differences of opinions on different things, but to have a different perspective, for the Speaker to have 2 appointments, we get 0 appointments. I just think that's something we should look at a little bit more, especially on something like this. It's so broad, omnibus. We should have that difference of opinions to bring those discussions together to get difference of opinions, whether they agree or disagree. I think that's something we should keep in mind as we move forward. So there's more of a statement there, I guess, than anything there. So I just wish that would be kept in mind.
I would say point taken, but I also think it's important for the debate on this question is that Caney also gets 2 appointments, and they're non-political. They're not a member of either side or either party in this House.
And I can understand. And I saw you have the composition must include at least 1 member from a different area groups. It could be a person formerly incarcerated at a facility, a health professional, behavioral health care professional, an attorney, a professional in any other field useful in the promotion of humane. I guess my thought is, wouldn't a retired corrections officer be some? The reason I ask that question is, obviously they've seen it all. They've been inside the facilities. They've seen the challenges. They've seen the opportunities. They know what the problems is. Wouldn't that be a wise appointment to have on this commission? Just because of the experience and background they can bring from a different perspective than others, just like when we talk about the minority appointment.
So the way the language reads, and you got that part right, the way it reads, it says includes those individuals, but not limited to. So certainly if Caney or the executive or any other entity that gets to make an appointment, whether it be the Speaker, the President Pro Tem, if they wanted to include that, they're not prohibited from doing so.
Okay. Just to clarify up the statute of limitations, I was listening to the discussion. So the way I understand it, if I'm correct, once someone, an incarcerated individual, finishes their sentence, they would have 3 years upon finishing that to file a claim. Is that correct?
That is correct.
And that is regardless if it was a 10-year sentence, 20-year sentence, whatever it is, they have 3 years after they finish, correct?
Regardless of sentence, correct.
Okay. And so they would have, now this question, and I think I know the answer, but I just want to be sure to be on the record. Now, would a suit that was brought back, would that be against the state of New York? Could it go back upon the corrections officer personally? How does this language adjust that? Is it just the state because they were the employer, or could the individual corrections officer be under this law?
So it's not specific. Certainly if the nature of the injury or is against the state could be liable, but it's not specific.
Okay. Well, Mr. DeLon, thank you for your time. I appreciate. Madam Speaker, on the bill.
On the bill.
Madam Speaker, my colleagues, at the Public Protection Budget hearing in January, at the follow-up joint Senate Assembly Corrections Committee hearing, public hearing on what was going on in our prisons and prison safety, I said right up front at both hearings that what happened to Mr. Brooks and subsequently to Mr. Natwe was absolutely abhorrent, totally unacceptable, and those individuals should be held responsible and held accountable. But I also said that any reform measures we are looking at must look at the entire system and all the violence as a whole that's going inside our correctional facilities, because there is rising violence inside the correctional facilities. And violence in any form is unacceptable and shouldn't be condoned and acceptable. Certainly if it's a corrections officer on an incarcerated individual on a corrections officer, or an incarcerated individual on an incarcerated individual. Violence is prevalent inside our correctional facilities, unfortunately. We've talked about it. I'll say it again. The HALT has caused problems, and we've seen dramatic rise in the violence since the 3 years of its implementation. Incarcerated individual on staff assaults are up 76% over the 3 years since its implementation. Incarcerated individual on incarcerated individual is up over 169% to a record high of nearly 3,000 assaults. Contraband seizures are up over 32% during this time period, from 3,500 to 4,700. And we know drugs create violence in untenable situations inside our correctional facilities. We've heard about the exposures that are happening to people time and time again. This is something, and it's like a dangerous powder keg inside our correctional facilities. This is something I think many of my colleagues would have liked to see addressed more holistically, but I know that's something we're going to continue to deal with, because this is one of the issues that was the main reasons for the protests or strikes, whatever word you want to use. We saw when we went with the corrections officers not working. It was about their safety and quality of life. And we still have a staffing crisis. And to keep in mind, the staffing crisis, there are programs that we want to put in place for incarcerated individuals. If you don't have the staff to provide those programs, then they're not going to benefit from those programs. So we have to do a better job of staffing and not just in recruitment and retention. And there are many opportunities things we could do from there, from whether it's the death gamble, looking at the pay structure, the benefits, all those things. Because if we have good staff in there, that's going to be able to help our incarcerated individuals rehabilitate and be better and be able to get out. The state commissions on correctionals expansion, I know I brought this up through our discussion. I just believe, and many of us believe, not having a minority appointment on this committee, I mean, we've seen some little things come through, but things like, and I talk about energy policy, if we didn't have certain people on the Climate Action Council, what would have been disastrous. Big policies. We should have a voice at the table. It's good to have differency and diverse voices to have a discussion to come to consensus, but our voice is kind of left on the side, and I think that's unfortunate. I also think that we should also look at those people that get appointed. I think we should look at corrections officers because they bring a unique experience. They've seen it all. They understand the challenges. They understand the opportunities, and that would bring something that could bring some value to that Commission on Corrections. And I think, again, to have that different, broad view of opinions is something that would be really helpful. I mean, I think there's some questions, obviously, about the statute of limitations. You know, the questions we ask now, okay, will it just be on the suit go against the state, or could it come back and fall on an actual corrections officer or staff member in the future? That's something I would have concern about, and for how long and when's the end date. The body cameras, we need to make sure there's proper training. The equipment and material are properly checked, that there are clear guidelines on use, and absolutely at the end of the day to make sure there's accountability. And no doubt, reform was needed. There are some good things in this bill, and we understand the genesis behind the bill. And I know my colleague worked really hard on this bill, and I know others worked really hard on this bill, and I can respect that. But I think because of the things that were not included, that were left out, things that we talk about, we will continue to talk about in this House, the impact of what's going on, you know, especially with our staff inside our correctional facilities, the overall environment, the powder keg environment that's been created, the violence that's going on, from the prison closures to the staffing to the assaults, the drugs. We need to do better. We need to look at this more holistically. We need to help our corrections officers with the recruitment and retention. You know, one such issue we talked about that passed in this House 2 years in a row, that the governor vetoed 2 years in a row and said it should be part of the budget, is death gamble. And we've had two bills that passed the House earlier this week, one for counties and one for judges. Why are we not providing that security to those corrections officers and their families? And this is something not only that they earned or deserve, but they earned it. So we should protect that pension for those corrections officers. That will help retain corrections officers at a time when we need more of them. That will also help to recruit more officers when they see that benefit. So there's much more we can do. Although I understand the intentions behind this bill, there are some good things in it. It's because of the things that aren't addressed in my concerns and some others, I will be voting in the negative on this piece of legislation. Thank you, Madam Speaker, and my colleagues.
Thank you. Mr. Gibbs.
Thank you, Madam Speaker. On the bill?
On the bill.
Madam Speaker, I want to start off by apologizing to my colleagues, Member Walsh and others. But I want to explain to them also that the word inmate is very degrading. And as the only member here with lived experiences, I can tell you how dehumanizing it is. Paul Masano and I, we had several conversations regarding this word, and he's gotten better. In fact, he hasn't said inmate in months because he understood that the word is degrading. So I apologize for getting emotional when you say those words, because it takes me back to being inside the prisons and how often the correction officers would use it to dehumanize us. So hearing it come out of the people's mouths that I really respect, and in fact, DiPietro prayed for me right before the debate started. And then went over there and said inmate 3 times. Member Ari said the word inmate 2 times. And when he came over there, I just asked him, sir,
Madam
please.
Speaker, point of order. We should not be using the other members' names in the comments that are being made by the member who's speaking.
I apologize. I'll get better, Member Walsh, I promise you.
Thank you, Mr. Gibbs. If you could just leave your comments without names of colleagues, please.
Okay, sure. So when the other members say the word inmate, it's degrading, especially those who I look up to and respect wholeheartedly. I also agree with 95.7% of the things Paul Masano said just now. I know it's unbelievable. but I agree with him most of the time. When I was appointed to the Assembly Committee on Correction, it seemed monumental. As the first formerly incarcerated state legislature, I would have a seat at the table of the committee that determines the future of our prison system. In December, when we all viewed the horrible and horrific video of Robert Brooks beaten to death by prison guards at Marcy Correctional Facility, while other staffs and nurses looked on laughing, I imagined we were facing a reckoning, one that will require this state legislative body to ask the question, for whom do we grant humanity? For whom do we say your life is worthy of protection? During this important debate, I've heard members discuss how it's important that correction officers be safe. And I agree. But docs do not have a functional system of discipline for correction staff. At a recent correction hearing, Commissioner Monticello agreed that I am not safe alone inside any New York State correctional facility. During conference recently, Chairman Eric DeLon concluded that I am not safe inside any New York State correctional facility alone. In fact, I am more safe with the incarcerated individuals, but not so with the correction officers. If a sitting New York State legislature is unsafe in these New York State prison facilities, what do you think the incarcerated individuals are? They're not safe either. Ever since the modern-day lynching and murder of Robert Brooks, I've been under attack. I shared it with a few members on that side. Niza Koba released the footage of me disagreeing with an abusive sergeant. And they edited this footage and put it out into the universe. The night I slept at the facility, and me and this young lady got into debate about whether or not I should be there. As a result of that footage being released, I received life-threatening notes left on my vehicles 5 times at 5 different facilities. N-word, don't come back here, you'll die. N-word, why are you coming into these facilities? And in fact, at Katsaki, my tire was slashed. And our New York State trooper told me I had to do this on my own. 2 weeks later, I go to Marcy, come out, and mysteriously, there's a nail in my back tire. My gas tank was tampered with several times. Several incidents of road rage. Most recently, 2 weeks ago, a colleague on my side was driving back to Harlem with me. 2 correction officers in pickup trucks cutting us off and giving us the fingers for 15 miles. Thank God for the state trooper behind them. Pull us over, starts an investigation. All because I spoke out on a black man being murdered in prison. We all seen the footage. We all know about Sam the next week right across the street from Marcy. We heard about the murder of Freddie McCree down at Coxsackie. And as a human being, not a politician, a peopletician, a person who loves and respects all humans, white, black, whatever, yellow, I respect and love you all. So as a guy who really loved humans and felt that as a state legislature, I should speak out on murders and abuses in prisons, now I'm attacked. And some of my friends on the other aisles, who I thought were really close to me, used the inmate word loosely to trigger me. I thought this body was a body that solved problems. And joining the correction committee, I was honored because I was willing to share my story and my experiences. 18 years old, sent to a maximum facility in Elmira, men amongst men. 8 months later, I'm transferred to Cayuga Community. I'm hired as a GED rep. And a young lady across the street from the program where I'm at, Parmesan, member, liked the fact that I was teaching formerly incarcerated individuals how to get their GED. And as a result, she wrote me a letter and sent me 2 mock necks and said, thank you for helping these individuals. Corrections found out about it. They fired a civilian and they transferred me. Though I had no history of talking to this young lady, never responded, never even said hi to her. But they transferred me, and they transferred me to Mid-State, where there was a welcoming party, 5 officers waiting. How dare you talk to a white woman in prison? Now, I could share the abuse. I could share the 25 minutes of beating. I could share the 10 minutes of stepping on my head and ankles and everything else. I've shared that with many of you on the other side already. And I thought that I garnered enough respect that you guys wouldn't even use that word around me anymore. I share with most of you over there than I share with my colleagues over here. Most of you over there know about the threats. You know about the windows and the letters left on my windshield. In fact, Commissioner Monticello talked with 5 of us about that. Dia Petro being one of them. So I'm human. To human is to be err. To err, to be human. However you professionals say it. I have emotions. I love people. All people. B, you know that. And all I ask is for the same amount of respect that I give you. I don't know if I can say cracker in this chamber. I don't want to be written up. I'm not going to say that, but those terms don't come to my mind when I see you guys. I see humans. And all I ask is for that same amount of respect. Now, back to this package. Though I believe this package is heading in the right direction, it's simply not enough. When a member of the Corrections Committee, Wayne Jackson, here in the New York State Assembly, is not safe to go inside of a prison, 4 minutes, thank you. It's a problem. When I share with most of you guys that I'm threatened and tires are slashed and stabbed and running me and Jordan off the road, I don't feel supported. I don't feel the love from my colleague. I don't feel the love from the chamber. I don't feel the love from the conference or the committee. Not the same love that I give each and every one of you. I give you all the authentic, open Eddie Gibbs. And that's all I ask for in return. So this package, it's a good package. It really is. But it simply isn't enough. Not enough to address the years of abuse and murder. Most of that was swept under the rug because we didn't have cameras then. I encourage each and every one of you to go to prison, visit, talk to correctional officers and talk to incarcerated individuals. Stop legislating blindly. And you'll see the real story. All I wanted to do was do what was right. My community elected me here to do what's right, and I did that, Your Honor. And I'm attacked. So my emotion and anger come from. Worry about getting in your car, worrying about going to the prison. Are you going to come out safe? Are they going to put stuff on you? Are they going to accuse you again? All I'm trying to do is what's right. And I spoke out on against the injustice. And now I got a whole union attacking little old me. Can't even drive down 87 no more. Get my car checked for trackers. I can't figure out how they find me. All because I spoke out against murder in prison. So I expected this package to be a little bit more. I expected my colleagues to be more understanding. And maybe I just don't share enough. So as a result, I'm a negative on this package. But I believe that we are heading in the right direction. 3 men were killed and nobody bat an eye. Nobody. I'm in a chamber full of professionals and I ain't see one tear. So again, Member Washington, my fellow colleagues, I apologize for that. And I hope you guys truly understand that that word is hurtful. Very hurtful. I apologize. Very hurtful to me. And you know I would never disrespect any of you guys over there. And for a member to invite me outside because I asked them not to use that word anymore.
Thank you, Mr. Gibbs.
It's discouraging.
Thank you. Mr. Beepin?
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
Yes, Madam Speaker.
Sponsor yields.
Figured you got a good 15-minute break there.
Well, I think the message was important to hear.
I agree.
But I will say that my position on the floor here puts me kind of at a disadvantage as it relates to these debates.
Yeah.
Very important message to hear.
No worries at all. Mm-hmm. So can we discuss the changes regarding Canny in this legislation?
Certainly.
Would you like to give a brief overview of what's changed in the legislation, or?
Yeah, so let's see. So I guess a brief overview, right? Bill would make several changes to expand the authority of Canny, including allowing notice, including more notice. Like right now, even if there's a lockdown, if there's an emergency-wide lockdown, Canny can't operate. This will address some of Canny's ability to operate during lockdown. DOC certainly retains, some emergency protocol. They do retain that, but it doesn't automatically prohibit a Canny visit.
Has Canny reported that they have difficulty accessing facilities right now?
Well, I guess I So yes, so I guess the issue is not necessarily Caney being inside during a lockdown. Currently, it's the amount of notice that Caney is required to provide docs.
Because right now it's 72 hours.
Yeah,
but I
so
see
this-
this reduces it to 24.
This would change it to 24, yes.
Okay, and say, the facilities are, many of them are currently understaffed by thousands of employees. Weekend staffing is sometimes even smaller or less than their required amount or amount they'd like. So say on a Friday they call and they say they're going to be visiting Saturday afternoon. Is that jail now required to make staffing changes to account for Caney coming there?
Well, I mean, yeah, there's. Yeah. So there's never been a difficulty in the past as it relates to Caney staffing. I guess under the shortened window, Caney is not, while they have authority under the legislation provided back in the 1800s that I discussed about earlier, they still have a 72-hour notice. So this gives docs, any docs facility, up to 3 days to prepare for.
You were reducing it to 24, I believe.
I spoke wrong. Yeah, of course we're reducing to 20. Currently it's 72.
Well, I figure with 72 hours, because Caney, as it stands right now, they can't be in that facility without an escort, correct?
That is correct.
So my thought process is 24 hours of notice, especially when we're already suffering with a staffing crisis. Are we going to be mandating COs to stay overtime, to be there when Caney's there, walking the facilities, meeting with incarcerated individuals?
I don't know that we'll be mandating overtime, but I also don't see a situation in where it would be a burden on the facility. So to provide color, I last summer did a visit with Caney, and we were at that point supervised. I think the difference between me and Caney is that certainly Caney is much more prepared and professional and knows the right questions and the things to look for as it relates to what they are looking for in deficiencies or potential problems in the facility. But what they don't have is something that every state legislator has, is a pop-up authority to go visit a facility. They have to provide, under current law, 72 hours notice.
Right.
So that could potentially, not that 3 days is enough to hide anything that they may be concerned that may come out in the Caney report, and it may potentially provide them a way to, I guess, address the staffing issues. On my visit, the staffing requirements on what we did wasn't onerous. It was 1 or 2 individuals.
Now, I see this also limits the commissioner's authority to restrict their access during emergencies and lockdowns. Is there any situation where he will continue to be able to restrict it, especially under extenuating circumstances?
Yeah, so under emergency situations, they would be limited to the administrative offices.
Okay, so they will still get access inside the facility, just to the administrative offices?
Correct.
Okay. Would you describe Caney to be more of an incarcerated individual advocacy group?
No, and I think that's unfair to classify them that. I mean, clearly, and that's why I thought it was important to establish when Caney was founded. Caney, like I said earlier, was founded in the 1800s because citizens were concerned about what was going on in prisons. And on my visit, they certainly did a thorough job in interviewing incarcerated individuals on their conditions. I spoke to them privately. So privately there was, certainly docs staff there, but they were able to have one-on-one conversations that the dock staff was not privy to. But what I would say is they spent an equal amount of time talking with the management at every facility. They spent a good amount of time speaking to the heads of each of the unions at the facility. And, they also asked them questions about concerns and conditions that they are under as well. And, I think it was beneficial to me to do that visit with them last summer because I got to, one, it improved myself as a legislator, but two, I got to really appreciate how thorough they are in their jobs and how independent they are, and that they do truly speak to all sides.
Do they often, in their reports, discuss issues facing corrections officers like staffing, mandatory overtime, assaults on corrections officers?
They do that, yes.
They do? I just find it interesting that now they get 2 appointees to the commission in this bill, correct?
They do.
And, from my perspective, I see them oftentimes as advocates for the incarcerated individuals. It would have been, a bit more of a fair situation if, say, NYSCOBA were also able to appoint a person or two to this commission, in addition to the governor, the speaker, the Senate. But I guess we'll move on from that topic.
Yeah, and I would just say my opinion at Caney, and I know there's a certain perception because I might have shared it before my visit, but upon conducting a visit with them and seeing how they conduct their work, I would say they're the most balanced, nonpartisan entity in this bill.
Now, moving on to video disclosure. So I see now that they have 72 hours to turn over any video footage relevant to death to the AG's office, correct? That's body cams, facility footage, fixed cameras, all that?
Just correct, to the AG's OSI, yes.
Okay, so that's like an internal communication between docs and the AG. No FOIL requests needed, nothing like that?
No, it's mandatory that they have to turn
Okay. Now, were there any discussions of perhaps using the same 72-hour time frame to allow for corrections officers or other entities to request video footage when, say, they were assaulted by an incarcerated individual?
Well, I guess yeah, I guess the concern is the reason why the AG's unit of the OSI was created. It didn't only include correction officers at the time, it also included members of the police force. It was intended to, that whole unit was intended to investigate deaths when they were occurred by police or peace officers.
Right.
So it's geared that way so that the counties across the state, regardless, are taking it out, and that we're going into other sections of current law, not the bill now, but just for color, is certainly geared that way so that the familiarity that and the strong working relationships that county DAs and county police forces have, it was done that way to again remove any appearance of familiarity or conflicts or working relationships, so that the true facts of the matter of a death done by a peace officer could be investigated independently by the AG's office.
I understand that.
So this would continue that.
Yeah, no, of course, but I'm just saying, like, now there's going to be a process in place where docs could come up with that footage within 72 hours and turn it over to the AG. Why can't they also be able to come up with the footage within 72 hours and give it to one of their own employees?
Because that's an issue for docs to address, and certainly legislation wasn't really needed for docs to deal with things that are in their possession and do things within their own agency.
Does this bill expand the use of body cams for corrections officers?
No.
Okay. Does it address body cam policy in any way?
No.
Okay. Got it. So I know that, in the budget we covered it, and, we've discussed this at our hearings with the commissioner. Not that long ago, corrections officers were forced to wear their body cams in bathrooms. So I hope that, as these discussions, carry on, we kind of address those concerns, whether it's administratively or here legislatively. As we expand the use of cameras, we keep a focus on privacy and making sure our own employees aren't being violated in any way.
Yeah, so I would say to that, obviously that's a concern. We're looking for the relevant facts of any potential situation that may arise inside a facility. Certainly, areas of privacy, like you mentioned, so I'm glad they're corrected. And even in the instances where we are expanding authority, we do make references to, place where folks are entitled to privacy.
When coming up with this omnibus bill, were any proposals made to address the staffing situation, specifically regarding the employees that were fired post-strike?
So I don't know that there are any. Yeah, so it is it's certainly out of the scope, but I would say that discussions on recruiting to address the staffing crisis has, come up not only in your conference, but as mine as well. We all recognize that there is a crisis, and we recognize how hard it is to gain and retain corrections officers. Some of those we've addressed in the budget by actions we've taken in the budget.
Right.
So while this package doesn't address that, folks recognize that it's a legitimate issue.
Got it. Does this omnibus bill address visitation at all?
No.
Okay. All right. I guess I will go on the bill. Thank you.
Thank you.
Chair.
On the bill.
Well, I could tell you that I want to start with saying I truly am sorry for the family of Mr. Brooks and the others impacted about what's happened in our facilities. And I completely agree, change needs to happen within our correctional facilities. I think this omnibus is a start in many ways, whether I agree or disagree with some components of it. But I don't believe it goes far enough. I believe that we have not addressed the root cause of this bill, whether it's some of the provisions in HALT, to the staffing crisis, to addressing drugs within the facilities and exposures that both incarcerated individuals and our corrections officers face each and every single day. And it also doesn't address the overall need for an expanded recruitment process and retention process that I think would tremendously change the environment within each of our prisons. For that, I'm going to have to heavily consider how I'm going to vote on this bill. But I thank the sponsor for his time.
Thank you, Mr. Beepen. Ms. Cruz?
Thank you, Madam Speaker. Will the sponsor yield for a quick couple of questions?
Will the sponsor yield?
Certainly.
Sponsor yields.
Mr. Chairman, does this bill change the public's access to the actual video footage if there is a death or a murder inside of one of our prison systems?
No.
Who retains power to make a determination of what is relevant parts of the video or make any redactions to the video?
The AG's OSI unit.
Thank you. And does this bill change anything else other than the actual statute of limitations in the process of someone filing a lawsuit? For example, would it change the type of evidence, where to file, when to file?
Nothing. It simply just gives them 3 more years.
Thank you. On the bill, Madam Speaker. Thank you, Mr. Chairman.
On the bill.
Before I start, I want to address everyone on a personal and professional level. We are entitled to our views, to our religious and political beliefs. What we cannot do is carry on in this House with carelessness and even sometimes purposeful use of words that do not belong on this floor. Words matter. We owe it to each other to have respect. If a colleague tells us, whether it's in here or outside, that the word you are using is dehumanizing, have enough decency and respect for your colleague not to use it. You can get your point across without dehumanizing someone. And that once the debate is over, you're going to come out of here and act like they're your friend or your colleague. Have some respect and decency for your colleagues. I want to thank the Speaker for this package and our colleagues who led the fight and our corrections chairman for carrying it. But I especially want to thank my friend and colleague, Eddie Gibbs, for channeling his lived experience and trauma to help us make real change. This is a starting line, not the finish line. There are a significant number of bills that did not make it into this package that must be considered next year, including Second Look Act, the Earned Time Act, Fair and Timely Parole, and Elder Parole Acts. The murder and violence against incarcerated people in our state is an epidemic, and we must address the underlying reasons why it has happened. Address roadblocks and investigate when it happens and punish in order to deter this horrific behavior. In 1976, the state began tracking the deaths of incarcerated individuals while in custody. The numbers are quite horrifying, but truthfully not shocking. 7,504 people have died while under the custody of docs. This is 7 times more than the number of people that we executed in the state when it used to be legal. This includes individuals like Layleen Polanco, Mr. Robert Brooks, and Messiah Nantwanti, and many others who were murdered by staff. But this is not just the murder victims. There are hundreds and possibly thousands of individuals who've been physically and sexually assaulted while in our prison system, in our jail system. An astonishing 719 sexual assault lawsuits have been filed against the Department of Correction by formerly incarcerated women, alleging a pattern of abuse that goes back decades. We have a duty to them, to their families, to all incarcerated individuals to put the legal tools in place to begin real change. The bill today includes 2 key legislative proposals. One ensures the video footage is turned over to the Attorney General's office swiftly to ensure a thorough investigation and the subsequent prosecution can be done when someone has died in custody and staff is involved. And the second ensures that when the statute of limitations is told to ensure that survivors can seek justice when they have been physically or sexually abused by staff. When incarcerated people die under suspicious circumstances, it is critical that an independent investigator have full access to the video and immediately and without interference. Right now, correctional facilities control the very evidence that might implicate them and their own officers. This creates an inherent conflict of interest and invites for cover-ups. Even in high-profile deaths, families and oversight bodies have waited months or maybe never even received them. This bill ends that. By routing footage directly to OSI, a neutral and independent entity created to investigate the deaths in custody, we improve accountability without compromising legal procedures. Officers who acted appropriately should want this footage reviewed. It exonerates them, and it identifies systematic failures, not just individual wrongdoing. The bill upholds New York's values around government accountability and decarceration, and ensuring all lives, including those behind bars, are treated with dignity. This bill also creates an avenue for individuals who have a claim arise while in custody to bring a suit by tolling the civil statute of limitations until the individual is no longer in custody and can feel safe to come forward and seek an attorney. The bill removes unfair legal hurdles, keeping survivors abused in our state custody from accessing the justice they deserve, and provides deterrence to prevent new abuse from occurring. While the bill idea comes from work we've done with women who were sexually assaulted in prison by their correction officers, or other staff, from LGBTQ individuals who were physically and sexually assaulted due to negligent supervision while in custody, it will help any incarcerated individual who was abused while in custody. We've heard the reality lived by victims who are incarcerated. They faced retaliation in a variety of forms, including further physical and sexual and emotional abuse, having legal papers destroyed, had mail and packages destroyed, faced delays in seeing their legal counsel, verbal abuse, and so on and so on. We know that it is incredibly difficult for a person to come forward when that person is not incarcerated. Add to that being in the care of a system that is allowing for their abuse to continue. This bill is necessary to provide adequate access to justice once a person is out. Further, we know that many justice-involved individuals are not informed about the notice of claim requirement and are unaware that they have just 90 days to file in order to pursue a future civil claim. And I suspect that many of us didn't know that that was a requirement as well. Lastly, but importantly, I want to recognize the families of those murdered while in custody, the survivors who have fought for change. We are beginning today. I know I speak for many of us here today. We are sorry for your loss. We are sorry for the abuse you have suffered. We hope this will begin a path to justice and healing, and we are committed to continuing to fight for real change. And I know he had stepped out, so I do want to say thank you to my friend Eddie for teaching me and for teaching many of us what real courage looks like. Thank you, Madam Speaker.
Thank you. Ms. Gallagher?
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield for some questions?
Yes, Madam Speaker.
The sponsor yields.
Sponsor, can you explain to me why is CANI being authorized to make appointments to this board?
Well, I think it's important because CANI obviously is, an independent oversight body as prescribed by laws way back when I said earlier. They conduct these visits. They give reports on potential conditions to us publicly as charged by law. And so is the State Commission on Corrections. So I think it's vitally important that the two independent oversight entities that we have in the state, one set forth by charter, one set forth by legislation, actually get together in an official forum and communicate with each other. So this particularly doesn't say a member of CANI has to serve on that board, but they can appoint someone to be their liaison. It doesn't prohibit them from appointing one of their members on the board either. But I think it was important so that the two independent bodies have a more connected professional relationship. This will do that formally. And I also think we need to do more to strengthen the operations of the State Commission on Corrections, even though it's not directly related to your question. We gave them more funding in the budget, but they were charged to do as a government entity similar to what CANI was charged to do as a non-government entity. So the fact that they are talking and working together is vital.
Thank you so much. Madam Speaker, on the bill?
On the bill.
Thank you, Madam Speaker. I'm proud to vote for this omnibus bill, which includes two of my original bills, the SCOC Reform Bill and the Terry Cooper Autopsy Accountability Act. We all began this session with the image of Mr. Robert Brooks's lynching burned into our minds. The way he was beaten with his hands cuffed behind his back while at least 14 corrections staff eagerly participated or casually watched spoke to an ingrained culture of violence and impunity. For me and for many of my colleagues, his murder lit a fire under us to increase oversight and accountability to protect our incarcerated community members. This bill will deliver that, and it will save lives. Briefly, just a bit about my two bills that are included in the omnibus. The SCOC Reform Bill has been a labor of love and passion. My office wrote it after I visited Rikers Island in 2021 and witnessed the utterly inhumane and degrading conditions people are subject to. The experience led me to a question: who is statutorily responsible for providing oversight in our jails and prisons? The answer is the State Commission on Correction. This bill will expand and diversify the SCOC so it can once again be a robust body with the people and resources necessary to protect incarcerated people. With us today are advocates from the Cattell Center, and they, along with the Jails Justice Network, have been fighting alongside me for this bill for years. This year, Mr. Brooks's father, Mr. Robert Ricks, also played a crucial role in fighting for these life-saving bills. Thank you all for your work. This is your victory today. The Terry Cooper Autopsy Accountability Act was named after Terry Cooper, a husband and father who was beaten by officers using batons. He was beaten so badly that he died. They tried to pass his death off as a natural cause because the beating triggered an asthma attack. This autopsy report did not include photographs that had been taken of Mr. Cooper after he passed away, which clearly showed that he had been beaten with batons. The photographs were ultimately discovered years after his death when his family filed a lawsuit, which they won. This bill would require autopsy reports to include all photographs of the body, slides, and post-mortem x-rays when someone dies or is killed in state custody. As we've seen with the murders of Mr. Brooks, Mr. Nantwi, and Mr. Cooper, we cannot count on corrections officers being forthcoming about the cause of death when someone dies or is killed in state custody. The Terry Cooper Autopsy Accountability Act will ensure that everyone who is incarcerated is afforded the basic dignity and transparency that everyone deserves, particularly when they die on our watch. Thank you to Mr. Cooper's family, Dave Rankin and Joshua Moskowitz, Mr. Cooper's lawyers, and the lawyers who fought for justice in their landmark case. These two bills and the package as a whole will increase oversight and provide an essential layer of protection, accountability, and transparency. It is not enough, and it is certainly just the first step. There is a crisis in our prisons and jails, and oversight alone won't solve it. We must ensure that HALT is fully implemented and that programming is restored and expanded so people are able to rehabilitate themselves while inside. We must fight for sentencing and parole reform to address mass incarceration and ensure that people who have been rehabilitated can be released and rejoin their communities and their families. I also urge my colleagues to personally visit prisons and jails alongside Canny. It has changed my life and been extremely informative about the failures of our state and what we must do to correct them. I am dedicated to continue visiting, and I want to change it. This bill is an essential first step if we are to meaningfully move the needle for our incarcerated community members. It will save lives and begin to change the culture of violence and impunity in our prisons and jails. I want to thank Speaker Heastie and Chair Dilan for their work on this package together, and thank you for including these two very personal pieces of legislation. Thank you.
Thank you. Mr. Gandolfo,
Thank you, Madam Speaker. Would the sponsor please yield for a couple
will
of
the
questions?
sponsor yield?
Certainly.
Sponsor yields.
And as with Phil, I forgot to say it, excuse me, as with the previous member, this is the first time we get to do this, and
Yeah,
I'm happy
very
to-
excited about
to do
this.
so.
But a lot of my questions have been asked and answered already, but I have a couple of things I do want to clarify. First, on the topic of video surveillance, this requires the installation and maintenance of cameras throughout the facilities. I was wondering if you could speak a little bit about the current state of cameras at the state facilities, or if there's certain facilities where this is a particular problem. Are most already maintaining these cameras?
So certainly we put a lot of money in the budget on it. There are some facilities that do have the cameras, but to speak to the specific ones that have problems or don't have problems, I don't know that I'm prepared to give you that answer at this time, but I know that the DOCS commissioner and is certainly aware of that and which ones and is working on it.
Okay, thank you for that answer. And now the superintendents and wardens are responsible for the assessment and making sure everything's up. Is there a certain, time frame if they discover any kind of malfunction or lapse in coverage that they have to get this back up and running? Or is this just, you see it, you fix it as soon as reasonably possible?
It would be the latter part of your
Okay, thank you. This requires the footage to be stored for a minimum of a year. My colleague touched on that earlier. Is that only the physical, I guess, stationary security cameras, or does that also include the body camera footage?
So fixed or stationary, no body cams.
Okay, so body camera, is there a length of, I know we did that in the budget, so it's probably not in this bill. Is there a length of time that the body camera footage has to be stored? It's in the budget.
My gut says yes, but we have to get back to you on that. Yeah.
All right, thank you. Now, and I know that there's a sensitive areas provision here where cameras can't be placed, showers, bathrooms inside the cell. Is it your estimation that maybe if there's a camera outside of one of those areas, not in those restricted areas, that it would still pick up audio? Possibly, if there was an incident that happened?
Potentially.
Okay.
But I think the concern is about privacy.
Right. I was just curious, if, like, in case there was an incident in one of those areas, what...
like if there's a fight or something like that. Yeah, I mean, sure, potentially. But, for the most part, while people are doing the things that everybody does,
we would like some privacy. I agree. And I wanted to clarify a couple of things in Part J, the look-back period. So just briefly, let's say the statute of limitations on a personal injury claim is 3 years. Say someone wanted to bring a claim from something that happened in prison, let's say from 10 years ago, but the statute of limitations would have run out on that claim. Is this extra 3 years restarting that statute of limitations? So if you were serving a 15-year sentence and something happened in year 2, and now 3 years when you're released, could you still bring a claim on that if the statute of limitations has previously expired?
Yeah, well, so I guess to clarify, it's not a look-back provision.
Okay.
So if anything that has happened and no one has yet brought an action before this is effective, the new proposal that we're addressing today won't be able to cover that part. However, if enacted into law by the governor, that would be the second part of your question would be the exact purpose of this, so that if this is enacted and someone chose their safety, but maybe got out and got advice, they have 3 years to commence that action post-release.
Okay. So just so I want to make sure I understood your answer. So essentially this could potentially, I guess, expand a statute of limitations, for lack of a better word here, let's say on a personal injury case, to like 10 years if this incident happened?
Potentially.
Okay.
Potentially, but that is really not the goal. I think we don't want to penalize folks for choosing safety because if they make the determination while they're incarcerated that it's just better for me not to say anything because I fear for my safety, currently, if they make that choice, the statute of limitations is running, and there's nothing that they can do about it.
Okay.
Under this proposal, they can do that, and they get 3 years post-release.
Okay, I understand that. And it also mentions for psychological injuries. Is that a new addition, or is that already the case? This is just...
No, the only thing new are the extra 3 years post-release.
Okay, and then one more question on the autopsy reporting. In the text, I didn't see any mention of a toxicology report, perhaps because that might get sent to a third-party lab after the blood is drawn. Would a toxicology report have to be included in the autopsy reporting requirement?
No.
Okay.
No.
Was that an intentional choice, or is there, I guess, a reason that wouldn't be included? I didn't know if it was just something that was overlooked.
So it's not limiting.
Okay.
If they chose to add it.
So there's nothing prohibit.
There's nothing that prohibits them. But the items that are prescribed in the bill are things that they would be, mandated to do. Toxicology would not be one of those.
Okay, that's all I have. Thank you. Mr. Delan. And Madam Speaker, on the bill briefly.
On the bill.
You know, so far throughout this debate, we kind of heard people from both sides, approaching the bill from both sides, say that this did not go far enough. So it probably does tell us this is right somewhere around where we need to be with this. There is some good stuff in this bill that I think are positive reforms. I do have some concerns about cost, especially when you open up, you add on more years where someone can file a claim. I do think that might result in a situation where claims can get out of control and really run the costs up to the state. But I will reiterate, this is, you can tell that the sponsor did put a lot of work into this, and I'd like to commend him on that, regardless of where the votes fall today. And one more thing I wanted to address, this was a little bit of a heated debate. I did not find it appropriate to be lectured about respecting colleagues in here. There have been several times where members of our side of the aisle had to be lectured and have had horrible insinuations made about our character during resolutions, no less, which are supposed to be nice, commemorative, meaningful things. And no one on our side stood up and interrupted as to not make a spectacle of what is meant to be a very meaningful statement as a body, and oftentimes we agree with the statement being made. So just keep in mind that respect is a two-way street, and it would serve everyone well to remember that. Thank you, Madam Speaker.
Thank you. Mr. Weprin?
Thank you, Madam Speaker. On the bill?
On the bill.
This omnibus bill contains a series of prison reforms to improve transparency and accountability in state correctional facilities following the recent death of 2 incarcerated men who had violent encounters with multiple correction officers, and I'm referring to Robert Brooks and Messiah Notwe. This much-needed legislation includes provisions which I've sponsored since my time as correction chair, which I chaired for 6 years in this House. Specifically, Part H in this bill will amend Section 146 of the Correction Law to allow the Correctional Association of New York to provide 24-hour notice to visit a prison and have access to public records without having to submit Freedom of Information law request. The Correctional Association of New York, or CANY, as it is referred, was founded, as my colleagues have pointed out, in 1844. The Correctional Association of New York serves a unique and vital role in shedding light on conditions within New York's prison and in advocating for reforms. This legislation will enable CANY to properly fulfill its unique role as a watchdog of the state's correctional system, thereby improving the safety, health, and well-being of incarcerated individuals as well as DOC staff. I want to thank the sponsor, Mr. Delan, for his hard work, his dedication. I also want to thank Speaker Hasty and this legislative body for upholding our commitment to criminal justice reform. This is only a beginning, not an end. We need to build on this package. Thank you, Madam Speaker. I proudly will vote in the affirmative.
Thank you. Mr. Burrows?
Thank you, Madam Speaker. On the bill.
On the bill.
I have a great individual that I believe raised me, and that is Mrs. Burrows. And because of that, I would like to speak a quote that she often spoke to me. She says, "Talk less, listen more, and it'll allow you to hear the hearts of a man." Now, there's things that have been spoken here today, and it allowed me to see the true heart of some of my colleagues. A lot of things that have transpired throughout today and throughout the rest of the session, it allows me to just look at the individuals and see the true care or concern or maybe the hate that may be in the heart. And I've heard some things today that have shown that people are truly biased and uncaring of people's situations. So many of the comments that my colleagues on the other aisle have spoken, I've heard them speak only to the concerns of the correction officers. One time I heard them speak about incarcerated individuals. That shows bias. Because if I could think, and we all have known, we've seen what has happened with so many of the incarcerated individuals this year. And let's get this right. If there are individuals that are dying or being murdered, that's what we should call it, outside of our prisons, that should be addressed. We can't look at the person who's considered a victim and then ask the person who's the accuser, well, why did you do this? Why did you hurt that individual? Well, can we make it better for that person who hurt the individual? That shows the bias and the uncaring nature within some of us. Now, last I recall, Robert Brooks, aside from Robert Brooks, there were 75 other deaths or murders, whatever we want to call it, and we're still defending the individuals who are perpetrating these acts. That leads me to question some of us, how were we raised? Things that I do on a daily basis, there's always two people that I keep in mind, and that is my mom and my dad. I always think about the lessons that they taught me, about being a caring individual. Don't see color, don't see race. And that's not what I'm seeing today. I'm seeing a lot of people jaded by political acumen. So I'm going to decide to do something because this is what my party says I should do. And I don't think that's what we're here for. Now, we're speaking of certain things that happen within inside the prison systems, drugs and other things that are being loosely spread throughout the facilities. Well, when you are entering an incarcerated facility, you don't have the things that the incarcerated individuals may have been found to have had in their lockers or in their bunks or in their beds. Now, if you didn't have it when you went in, that means you didn't bring it in. So it's getting in some other way. Now, I don't know, as legislators, if you think, let's use common sense. If it wasn't in there in the beginning, it had to come in from some other way. So individuals defending, forget about any of the incarcerated individuals, but you're only defending DOC's employees. That says you're jaded. That says your heart's in the wrong place. And I don't think this place is a place for someone who is showing bias. Now, some of these things that do enter into systems, these things can be stopped. They're body images and scanners. If you look at these, the options of the staff has the option of not going through a body scanner. That will tell you where these unwanted items are coming from. And so maybe this bill is in the right direction, is headed towards the right direction, and maybe we need to discuss actually pushing it forward to work harder, because I don't think it does enough. But it is a step in the right direction. Now, to take care of some of the issues where we could possibly include having staff go through these body scanning images, because this way we could prevent a lot of all of the individual cases that may be being brought unto incarcerated individuals. We can say, hey, well, it was shown on a body scan image. This way, it will decrease the amount of anything that's happening with substances, illegal chemicals, fentanyl was brought up. All these things could be put to a stop. Now, along with myself, I have had other colleagues that have visited our state prisons. And I've spoken with both sides. I never tend to take the side or opinion of one until I get an explanation or I have a discussion with both sides. And I've spoken with both sides. But I can tell you this, there's one thing that I found very, very disheartening. 100% of the incarcerated individuals that I spoke with told me that the respect and the treatment that they got from the National Guard was far better than what they were getting from Department of Correctional Facilities. 100%. I've even gotten some of the word from the people from the Department of Correctional. They say most or majority of the incarcerated individuals are there to serve their time and go home. That's honesty. So if you can take one and you add one, you come up with two. I just got both sides of a story, and it tells me that one side is being penalized because they can be, because they don't have the ability to speak out. And that was the purpose of going to visit these prisons, to see what's truly going on inside. So until we all go and visit multiple facilities, I don't think we have the ability to speak specifically to one side, because you're doing yourself a disservice and you're doing the rest of the state a disservice. I just know where we are currently is not where we should be. I know where we need to go is a lot further. And so, with that being said, even though I think this bill needs to be stronger, I still vote in the affirmative. Thank you.
Thank you. Colleagues, before we move forward, I just want to remind you, debate is supposed to be referencing the bills that are in front of us. And we need to remain and keep our comments to debate on the bill. We should not be referencing prior comments or naming our colleagues, to be respectful in our conversation and reminding you to speak on the bill relating to the bills that are part of this package. Thank you. Mr. Meeks.
Thank you, Madam Speaker. On the bill?
On the bill.
Savage, of an animal or force of nature, fierce, violent, and uncontrolled. Barbaric, savagely cruel, exceedingly brutal. Hate, to feel intense or passionate dislike. Robert Brooks should still be here. Instead, his life was taken when he was brutally beaten to death by corrections officers while handcuffed inside Marcy Correctional Facility. This is yet another tragic example of the inhumanity within this system. We cannot stay silent. We must say his name, Robert Brooks. We must share his story. We must demand accountability. His memory must fuel the fight for justice. Robert Brooks was from Rochester, New York, my district. His family, his son, Robert Brooks Jr., his grandchild, his parents, Mary and Robert, still live in Rochester. And like too many families, they are living with the pain that the system keeps inflicting over and over again. I will vote for this oversight package today because transparency matters. But transparency alone will not stop the next death. Oversight alone will not stop the next life. And make no mistake, lives are on the line right now. For too long, our justice system has prioritized punishment over people. For too long, it has torn families apart. It has devastated black and brown communities for generations on. But we had the chance, this session, we had the chance to do more than monitor a broken system. We had the chance to change it, to save lives, and we did not. The Second Look Act, the Earned Time Act, the Marvin Mayfield Act, these are not just bills. They are life-saving legislation. They offer a real chance at restoration, at transformation, and at reuniting families who have suffered too long. We cannot keep clinging to outdated, failed sentencing structures that serve no one. These unjust and discriminatory practices must end. We must build real pathways to release and rehabilitation for a more equitable New York. That is why I proudly sponsored the Marvin Mayfield Act, to eliminate mandatory minimums, to restore judicial discretion, and to put the focus back on the person, their story, their capacity to heal and return home. That is why I co-sponsored the Earned Time Act and the Second Look Act. Because when people transform, they deserve a pathway home. Because families deserve hope. Because every day we delay, more lives remain at risk. It is time for New York to lead with compassion. It is time for New York to lead with fairness. It is time for New York to lead with true justice. We cannot stand idly by and add more names to the list of the dead. I vow to continue to stand with the people and the fight to pass legislation that recognizes the full humanity of every single person behind those walls and beyond. I will be voting in the affirmative. Thank you.
Thank you. Ms. Bailey?
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
Certainly, Madam Speaker.
Sponsor yields.
And this is going to be very awkward, and I'm completely fine if your back is to me. I won't take it.
I love my mother. I think she taught me better.
Well, tell her thank you.
I wish I could, but that you wouldn't know that part of my life. But go
All right,
ahead.
I'm going to try and I have my questions hopefully by part in here, so bear with me while I kind of link them together. I've tried to go back and read the original sponsors' justifications and memos, so I have an understanding as we're kind of piecing it together. Specifically under Part B, I just have a couple technical questions that I'm hoping that you might be able to help with. So with the comprehensive camera coverage, and the footage would need to be retained for 5 years from a complaint or legal action, I believe is the wording. It's on page 4. I think we're looking at like from lines 5 to 14. Correct. My question is and it kind of ties into I just lost my train of thought. The statute of limitations. So with the cameras being set up in areas that you might not be able to see, we potentially could have some vacant buildings, so on and so forth. As individuals inside the correctional facilities are monitoring this film, it's my understanding that they're mandatory. They have to, if they see something that should not be occurring, they have to report that.
Under the, so I guess there were several parts there. So I guess on the camera footage and the language that you referred, yes, whether that is counter to Part J of the bill, which you referenced, I guess the answer would be no. Because they don't have the footage now. And, to the extent that the lines that you cited, to the extent that there's no claims, it wouldn't run counter to the provisions in Part J.
Okay, so the corrections officer or whoever's monitoring the film, if they identified something, so say there is an altercation in a hallway, and they see that, would they need to report that? Therefore, then there would be an incident lodged. I believe they currently right now have to technically report that. Am I correct?
So it kicks in when there's a reportage of staff misconduct.
Okay. And the only reason why I ask, as far as the statute of limitation piece of it, would then that coverage need to be retained 3 years past that incarcerated individual's release?
No.
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 It would just be the 5 years.
Yes, and that would be, to fully answer your question, I know I abbreviated it for the record because I believe we both understood it. So it would stop, it would kick in, they would have to do 5 years, and it would only require to be held if there is misconduct.
Okay, so it's the 5 years then, piece.
5 years, yes.
Okay.
Doesn't impact Part J.
It doesn't affect Part J. Okay. Then my next question is going to bring us to Part C, with the public notice of such deaths, and that notice must be reported within 24 hours on the department's website. If a family member requested that it not be reported for whatever reason, is that a viable request that could be taken by the department?
So I think the way I understand the bill is that they are required to post on their website after 24 hours of notification of a family or next of kin. But DOCS does have to complete those steps before it can be posted publicly.
Okay, so the family member or the next of kin could request that it not be posted potentially?
I'm sorry.
No, you're absolutely
fine.
fine.
I may need you to repeat that. And I guess to further, it also doesn't require that there's anything that's identifiable. So if the family chooses to remain private in the matter and not have the names in the public realm, they have the right to do that. Yeah.
Because
if you could repeat the question that I didn't hear again, I'd appreciate that. Yeah,
So my question, it had to do with that it has to be posted on the website within 24 hours. There's no language in there of what needs to be posted. It could just be that there was, that someone passed away in a facility. I don't know what that looks like.
Correct. And again, to be clear, 24 hours after the family and next of kin has been notified.
Correct. Within that 24 hours.
Yes.
Okay. And the only reason why I ask is as we move into Part D, and this is just how my brain works, and I apologize for that, because I'm taking you on this merry trail with myself. When we go into the study on those deaths, is there any additional reporting that would then show up on the department's website to maybe give closure to the public as to what was identified? We now are going to be posting that there may be 3 or 4 deaths within the correctional facility. Some may be of natural causes.
So Part D is not DOCS. It would be the State Commission on Correction. State Commission on Correction, does do that to a degree. A lot of it is heavily redacted, and there's reasons for that and good reasons for that. That would remain, but it deals with the State Commission on Correction, not DOCS itself.
Okay. And then Part E, where we're talking about the autopsies that are done, and where the county coroner is notified, and there's additional documentation that must accompany those county coroner reports now. In counties that do not have medical examiners, by statute, those coroner reports, along with any autopsy report, are filed with the county clerk. So those original x-rays, or however they're going to be relayed, would then be coming through the coroner into the clerk's office for filing. Am I correct in my understanding of that?
I think in those situations, right, most counties do, but I guess in those situations we're not sure the answer to that question. But what I would say is that to the degree that the items prescribed in the bill are included, then they're compliant. It doesn't necessarily say how.
Okay, and the only reason why I ask is everything that I could read in it stated that copies of that would then go on to the different, agencies that would receive that information.
Yeah, again, I see your concern how it's close, but I think all this part does is prescribe what could be, what is mandated to be included in the autopsy
in that report.
Mm-hmm. And as long as they comply with what's prescribed, they're compliant.
Okay. I think those were my questions. I appreciate you answering them for me. Madam Speaker, on the bill.
On the bill.
As my colleagues have indicated, I definitely think there are some pieces in this bill that everyone would be able to find that makes it a little bit better. As I started the beginning of the year, and we know the events that happened, early on, out talking to constituents that included incarcerated individuals' family members, it included correctional officers, and then it later went on to including the National Guard. And I have followed up with many of those individuals, as I've read through this bill. And I think all of them would say that there's definitely pieces in here that will make it, or, that are measures that may be moving safety in a positive direction. And I think at the end of the day, that's what we need to look at. Whether it's an incarcerated individual, whether it may be civilian staff, whether it may be a correctional officer, whether it is our National Guard right now. I've always lived by the motto that, it's our responsibility as an employer to ensure that our employees go home either in the same condition that they walked in or a little bit better. And I don't view this any differently, whether you're an incarcerated individual or whether you are an employee in a correctional facility. So I commend the Speaker. I thank him for answering my questions. I know some of them were pretty technical in nature. And to be honest with you, I'm not exactly sure how I will be voting on this bill. I believe that there are steps that we can take to move forward and do better. But I do believe that we have taken some steps that will help everyone in our correctional facilities. Thank you.
Thank you. Mr. Days?
Will the sponsor yield?
Will the sponsor yield?
Absolutely.
Sponsor yields.
Thank you. I know it's a weird angle again.
I'm getting used to it.
Yes. First thing together, when you first were putting this together, it was a large amount of bills that you were sifting through and trying to figure out what was the best formula where we can make something move forward, correct?
Well, the only thing I would correct to that statement is not an I, it's a we, right? The caucus and other members who are not part of the caucus, really did a good job in looking at ideas that were already existing that would help the current situation. So yes, it was
Agreed.
more we than I.
And I think you're safe to say you believe this is like the first step in underneath your committee to help transform our part of our correctional system.
So it's a step. I don't think it's the first step. We've taken steps in the budget
Yes.
that we've already adopted into law, but by no means do I feel this is the end, and by no means do I believe anybody should take a victory lap here if we pass it out of this body and get signed into law, because folks are dying.
Understood.
And this will begin to address the problem, but it's not the end. There's clearly more that needs to be done.
Understood, and I agree. And here, with the omnibus bill, we are focusing on accountability, which I would argue protects not just the incarcerated individuals, but correction officers and staff. Would you agree with that?
I agree with that, and it was very important to me. So, I don't want anything that we're doing here today to be communicated that we find the items that are not included in this bill to be important or worthy of consideration of this House. But I think the one thing that when we take a look at, as a government, if we have an incident that resulted in a homicide, and then as a result we see the flaws in our government protections, as I've said many times here today, I felt it's incumbent that we fix that right away.
And to that point, by creating more transparency, by having more accuracy, to ensuring, for example, that when an autopsy can be expedited, that would actually give the public more faith in our system, that we can give them quicker responses, quicker answers when there's a cloud of suspicion under possible homicide.
Yeah, so it's important because I think, I appreciate the previous questioner's concerned about how this works, because every part of our state is different.
Right.
And what may be easy in Brooklyn may be more challenging in other parts of the state. Outside of this bill, while it didn't make it into this package, there is another piece of legislation that would model after what Connecticut does. What Connecticut does is they have a centralized coroner's office for docs facilities. I would have loved to have gotten that today, but it didn't make it in. It's outside of scope. But I think the bill is also a starting point, for all of us to just take a look at our agencies and our systems to see how they work, so that an issue that the previous questioner brought up that could be alleviated if there was something more centralized and didn't put the weight on the counties.
Thank you. And in addition to the expansion of cameras and obviously we're protecting private areas, but I think there's a key, that would be a key step in ensuring not just accountability, but protection of not just the incarcerated individuals, but the correction officers and staff, and to make sure that if there is an accusation of foul play, not only would it show one who might have done something, but it could also acquit somebody or demonstrate that they did not do something wrong in that situation, correct?
Correct.
And so therefore, by expanding the cameras, we're not just focusing on the incarcerated individuals, but we're also focusing on the work conditions and the safety of the correction officers.
It's holistic, correct.
It's holistic. In addition, a lot of people don't talk about it to a degree from the correction officer's side. A lot of people don't talk about hazing or talk about where there's pressure within your own job structure to do certain things, and this could actually protect correction officers from workplace workplace bullying from from fellow correction officers, correct?
I would say to correction officers and doc staff that is non-correction, like nurses and other people who provide programs.
Right. So, for example, so if a nurse in the situation of Robert Brooks wanted to step in, that nurse might feel a little bit more brave to step in that moment because knowing the cameras are there, they know that they will be protected by additional surveillance in that situation.
Or maybe more willing to come forward with things that they saw that are clearly misconduct, but because their security to a large degree relies on the protection that they get from a correction officer, they may be more inclined to speak up because they know that what they're saying can be backed up and corroborated by a video. They may be more likely to come forward because they feel protected.
Thank you. And my last question, I saw that you put a focus on chain of custody. I think, again, that's creating more transparency and accountability, and therefore there would not be questions of evidence being transferred over where people say, oh, it was doctored, or oh, we don't know if that's the real thing. So do you think it was key putting that in to ensure that by having chain of custody rules put in place, that it will give more security to these matters and give people more trust and faith in our investigations?
Yes.
Thank you. On the bill?
On the bill.
Obviously, today has been full of emotions. But one thing that we have within this body is diversity amongst our own occupations. We have former prosecutors, we have judges, we have defense attorneys, we have detectives, we have former correction officers. We had a person that was an incarcerated person who can give an inside vantage point of what it's like within our correction facilities. I can tell you right now, I actually owe that person an apology because I have a slight fear of prisons. And when I became an attorney, the first time I ever walked into a holding cell to meet one of my clients, when I heard that clank behind me, I cannot explain to you the chill that vibrated down my spine. And I owe him a visitation to one of our facilities in my district, and I've been hesitant because of this personal fear I have of the 1 or 2 times I have been inside of one of our state and county prisons. What we have to understand is just because someone's an incarcerated person does not mean they have lost their humanity. Yes, they might have done something wrong, but that does not mean they do not deserve a second chance. And which that means, as our colleague said, just like our correction officers have the right to go into their day of work and go home, so do the incarcerated individuals within those buildings have the right to serve their time peacefully in a manner where they can feel safe and can be rehabilitated and then still have that option to go home. If we do not create a safe environment to allow them to go home, then we have failed as an entity and as a legislature in doing so. They are not any less of a New Yorker. They are not any less of a human being. They are not any less of a person because they committed a crime when they might have been younger. And one example I give, I know I use pop culture in movies, but in Shawshank Redemption, Morgan Freeman's character is in his last parole, and he asks him, are you sorry for what you did? And he says, son, if I could talk to the young person, he was dumb. He made a mistake. But that young man then, 40 or 50 years ago, and the man sitting in front of you now are two different people. So we have to understand that if we create a safer environment within our judicial system, within our corrections facilities, we are not just making it safer for the correction officers, we're making it safer for the incarcerated individuals. So we can let our emotions go to the side right now and ask ourselves a very simple question: what is your humanity? And your humanity should be, we need these to be safer and better places. In full reality, the more prisons that we can close means we're doing something right. That means our education system is getting better. That means our social network, our social safety nets are getting better, because if we create more prosperity, if we create more jobs, better education, I promise you that jail population will go down. We need to approach this from both sides of the aisle, both sides of the equation. We need to make them safer. We need to make them better. We need to make sure that the correction officers are properly staffed, properly trained, properly paid, have the proper benefits. We need to make sure that they have access to housing so we can recruit qualified New Yorkers to go into these careers. I know this is a tough job. I will be the first person to tell you I am not built for that job. And I respect what they have, but we also have to make sure we put people in there that respect the men and women within those facilities. The fact that I'm not surprised that as a son of a vet that the National Guard came into these facilities and handled them with respect, because the one thing they teach you in the military, respect in your bunks, respect for your fellow man and within your camp. And the fact that that demonstrates that with respect and with proper professionalism, that these facilities can be better ran, tells us that we can do better as a legislature, as an executive branch. If those National Guards, those young men and women have demonstrated that we can run them better, then how can we say that we can't do it when they did it in a short amount of time with how much training? How much training do those National Guard people have? The only training that it seemed like they did have was to treat people with human dignity. We have further steps to go. I want to thank the sponsor for taking the wishes, the 20 bills, and trying to put them together to come with something that is putting us in the right direction. But just like any test, just like any mission, the first steps are the hardest, but we have more to go. There's going to be newspapers. I'm sure the New York Post is going to come out against us and say, oh, we're being soft on crime. We're not being soft on crime. What we are doing is solidifying our humanity. We are making sure that we are holding ourselves accountable, we're holding ourselves transparent, and we are ensuring that those who are underneath our jurisdiction are doing their jobs. If we do not do that, then we are failing as a legislature. That means, as we move forward, this bill is the right step. I want to make sure that we empower the Correctional Association of New York to ensure that the correction officers are safer, that the incarcerated individuals are safer, that the staff members are safer, that their families can talk to the members in those facilities, the workers and those who are incarcerated. Last, we have to make sure that we come up with a more humane system. So that means with this being the first step, the next step is looking at earned time, second look, and timely parole and elder parole. If we do this and work together and listen to everyone's opinion, to everyone's vantage point, inside those facilities and outside, I do believe we can come together with a bipartisan approach that respects the wishes of our community, that respects the wishes of our constituents, and also respects the dignity of those who work within and those who are currently incarcerated. Thank you kindly, Madam Speaker.
Thank you. Ms. Walker?
Thank you, Madam Speaker. On the bill, please.
On the bill.
There are presently 1.5 million people incarcerated in America. And when we think about the effects of mental health, the anxiety, the post-traumatic stress, that the incarceration of individuals have not just on the person who is incarcerated, but on their entire family. We think about the generational trauma that gets exasperated on an entire group of people because we have seen that the numbers favor some over others. So I want to commend the Black, Puerto Rican, Hispanic, and Asian Caucus, our corrections chair, the speaker, and the staff for recognizing that this is a critical time, and it's a critical time and a time of reckoning in our New York State prisons. It is time to stand up for people who have been forgotten about by too many people. But remember, I remember Robert Brooks. He was a 43-year-old Black man who was beaten in front of everyone for the world to be able to see. It was embarrassing, not just as a New Yorker, but as I was watching, as this video was being shared all around the world. On that fatal date on December 9th in a Marcy Correctional Facility in Oneida County, his hands were cuffed behind his back, and he was attacked by more than a dozen corrections officers. Yes, this bill does provide a comprehensive study. Yes, this bill does provide a collection of data. And yes, it does shore up our need for camera footage. And we all recognize that oversight helps to bring darkness to light. But guess what? In addition to the fact of him being punched, kicked, bloodied, bloody nose and face,
There are so many people who may be experiencing those same experiences just today. Like there's a ticker in Times Square that will calculate how many people are being affected by a certain situation. I wonder what would happen if we had that ticker on the New York State Thruway as we were coming in here and we could all recognize just how critical and crucial this moment is. Because guess what? Right after we mourned the death of Robert Brooks, another black man, 22-year-old Messiah, as we had heard, was killed in a nearby Mid-State Correctional Facility in only 3 months. Since the time of Robert Brooks's death, 75 more people have died in New York State custody. 75 more families now carry that grief. Can you imagine that? So I'm voting for this bill, for this oversight bill, because our incarcerated neighbors deserve, at a bare minimum, transparency and accountability. Far too often they are condemned in the dark. And we must fight even harder to ensure that the brutality, neglect, and dehumanization does not persist. Oversight alone, as we know, will not stop the harm. It tells us what happened after the fact, but does not stop people from being trapped in conditions like this to begin with. We have to end this culture of brutality by any means necessary. We know that the safest communities have the most resources, not the most police officers. So when we invest in our communities, we begin building men while they are still boys. We recognize that we need money for education, not for mass incarceration. Since Robert Brooks was brutally murdered, we know that he was doing so many different things that was trying to better himself so that when he got back out into society, he could be a better person. He earned his GED. He studied sign language, horticulture, maintenance. He completed programs, made amends, and worked every day to build a future for himself and his family. He told his father that he wanted to do what Dad did. Mentor young people, be credible messengers within the community to let people know what happens when a quick decision gets made that will land you up in a place you may not want to be. But instead of a second chance to come home and do just that, he got a death sentence. The purpose of our criminal justice system must be to rehabilitate rather than excessively punish. But instead, we keep trapping predominantly black and brown people in our carceral system. We need a new path forward to which this bill is aligning us with. Brutalizing prisoners is illegal, it's inhumane, and it must stop now. That is why sentencing reform is urgent. Yes, it's important to oversight and document the harm, but sentencing reform prevents it from even happening. So, of course, some of the other bills that was introduced in this package includes the Second Look Act, which gives judges the power to review long sentences after 10 years and recognize real transformation. We know that the Earned Time Act, which is also a part of the original package, allows for people to earn meaningful time off their sentence through work, education, and programming. There needs to be an opportunity for a release mechanism from this madness. Continuing to keep people behind bars in barbaric situations, as we've heard, on behalf of the folk who are working there each and every day, who are expecting to come home safe to their families, and the people who are incarcerated. When we keep them caged up, a lot of times people talk about the crab in a barrel concept. But guess what? Yes, when crabs are in barrels, they're trying to pull down other crabs. But barrels is not the natural habitat for a crab. A crab in the ocean is thriving. They're doing the things that they need to be doing in order to take care of themselves. And so when you put people inside of a cage and they began to act cage-like, and we sit on the sidelines and we are watching like we are at a wrestling match, as we are at a boxing match, as we are at the Coliseum. This is the type of thing that we can expect. We know what the definition of insanity is. When we keep doing the same thing and expecting a different result, who is the problem? Who's really insane here? So of course, we have to encourage growth and increase safety for each and every person behind a prison wall. And Second Look is more than just a bill. It's a chance to honor the humanity of those who have grown, changed, and served time far beyond what the public demands. I come from Brownsville, as everyone knows, where families live every day with the consequences of harsh, unyielding sentencing laws that tears families apart and destabilizes our communities. While on Pickens Avenue, we have a hard time just getting economic growth. But we will watch each and every day as the numbers of police officers who are filling the 73rd precinct continue to double each and every day. We need to address mental health issues and trauma that people experience at a young age in order for us to get at and lose the cycles of violence before we decide to slam those individuals behind cages. We cannot simply monitor suffering. We must prevent it. We must recognize that that people are far more worse than their one-time mistake. We must recognize more often than not that people should not be defined by their one mistake. And we must build a system that believes in second chances and believes in our people. Second Look would have created a pathway for people to demonstrate transformation and deliver justice rooted in dignity and safety. Although this may have been a missed opportunity in this present situation, it is not the end. We will continue to keep fighting because we owe that to Robert Brooks. We owe that to the 75 others who have died since his death. And we owe that to all of the individuals who are presently behind bars, not just here in the state of New York, but the entire 1.5 million Americans who are incarcerated today because New York State needs to continue to lead the way on justice, on criminal justice, and we must always do what's right for fairness, justice, and equity. Thank you, Madam Speaker.
Thank you. Ms. Tapia.
Thank you, Madam Speaker. On the bill.
On the bill.
For too long, violence, neglect, and abuse in our jails and prisons have been allowed to flourish in the shadows. This package is changing that. It's about pulling back the curtain and holding out our institutions to a higher standard. I am proud to sponsor one of the parts of this package, which would mandate comprehensive camera coverage in our prison system. With better cameras and reliable recordings, we can protect incarcerated individuals from abuse. We know that cameras coverage makes incarcerated individuals feel safer and make them safer. It will eliminate blind spots and help to prevent abuse and misconduct. Together, these bills represent a clear demand for accountability, transparency, and humanity in our correctional system. We cannot allow more lives to be lost while we wait. I will vote in the affirmative. Thank you, Madam Speaker.
Thank you. Mr. Molitor.
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
Absolutely.
Sponsor yields.
Thank you, sir. Could you say your last name for me? Just so I know I have it right.
Mine?
Yeah.
Well, it's Delon, but I'm not sure if we're supposed to be using it. I say that comically, not offensively.
Now I know, so the next
Delon,
time I use it,
I
I
appreciate
say it right.
Yeah. We could use it on a more personal level off the floor.
Yeah, thank you. Hey, I appreciate that. Hey, I'd like to focus on Section F of this bill.
Certainly.
And if we could, I'm looking at page 7, line 3, which starts with in addition to the executive law.
7-3.
Yeah, page 7, line 3. It starts with an addition to the executive law.
Okay.
So, if I understand this section correctly, this would give the Attorney General the opportunity to, let's say, prosecute a case that occurs in any one of the any correctional facility in the state of New York, where the Attorney General is already representing maybe a correction officer in that same correctional facility.
It gives the Attorney General and their office, I guess, the authority to do that. And I think the reason, why this language was important, I think, as we all know, it's because of the recusals. But in other parts of the bill, it requires them to create firewalls to relieve them from conflict. Well, in this section, it does, but it gives them the responsibility to create conflicts, to eliminate conflicts within the AG's office, and then to the extent that they can't do that, then they have other tools to reduce the amount of instances where the Attorney General would have to recuse.
So the Attorney General, let's use a specific case here. The Attorney General, let's say, is representing 2 or 3 correctional officers out of a specific facility for some sort of action that was filed against them. Don't have to specify what, but the Attorney General is representing them, defending them in that action. While that is occurring, or after that, while that criminal or while that action is pending, there's now a criminal investigation against those same correction officers. And under this legislation, the Attorney General can say, the Attorney General under this section can say, I'm going to hand off that action where I was defending the correction officers to a Deputy Attorney General who's screened off from my office, and I myself am going to prosecute the correction officers.
So let me make sure I understand. So there's something that the AG's office, maybe not the AG herself, they're doing that they're representing a correction officer on a complaint and potentially on the civil side, and now a potential criminal issue comes up with the same officer.
Mm-hmm.
Is that where you're going? Okay. Yes, correct.
Okay. And then, well, before we move on to my next question, how do we as the legislature have the authority to do this, to change the executive order, to deal with conflicts of interest? Where is our authority coming from?
Yeah, so we're obviously the general lawmaking body of the state, so that's the first place it comes from. But then within there, within this bill, we give the Attorney General's office, we're mandating that she provide rules, or I shouldn't say he or she, that they provide rules within the AG's office to seek what we're looking to achieve in the bill.
Are you an attorney, Mr. Dahl?
No, sir.
Okay. I'm not trying to trap you here.
Yeah,
So,
it's the sense I get.
but as you know, I'm sure someone's maybe told you, an attorney gets admitted to the appellate division in which they wish to practice. And they're required to follow the rules of professional conduct that are promulgated by the appellate division. And it's the appellate division that oversees attorneys and addresses grievances and mets out discipline
So I think the answer to your question, if I'm correct, lies on page 7, beginning on lines 23. It says, the rules and regulations establishing screens shall be sufficient to satisfy the rules of professional conduct regarding conflicts to protect the rights of state, peace, and police officers. Is that right?
I did see that language.
Okay,
I did see that language. The
short answer was that part of the bill would establish the protocols in which the Attorney General would have to follow, consistent with the question that you just asked.
The issue I have is that the legislature cannot tell the judiciary what to do under the Constitution and the judiciary law. It's the judiciary's power and responsibility to promulgate rules and establish attorney discipline. You can't craft. Hold on, let me finish my point.
I don't believe that's what we're doing. We are not telling them what to do. We are telling the Attorney General's office what to do.
Well, it says it lays out what the Attorney General is supposed to do, and then it says that if the Attorney General does what it's supposed to do in this legislation, that it will be sufficient to satisfy the rules of professional conduct. But the rules of professional conduct are administered by our appellate divisions, and those appellate divisions are the ones who determine whether conduct satisfies or doesn't satisfy the rules of professional conduct.
So we're not changing ethical responsibilities laid out by the judiciary or an appellate division. We're saying that the rules that the Attorney General has to provide in her office have to be consistent with those.
But there are rules and a lot of opinions, I might add, about those rules that say that an attorney and the Attorney General cannot both simultaneously represent a correction officer and prosecute a correction officer at the same time. And in fact, that's exactly why the Attorney General needed to get a special prosecutor to prosecute the individuals who were charged in the Marcy Correctional Facility incident.
Certainly, so she has to use those rules to create a shield in her office that is prescribed by the judiciary and those appellate divisions and the conduct. But the Attorney General is the chief attorney of the state. I'm certain that they are far more aware of how to do that than I am, which is why we give her the flexibility to do that. And then in the event that they find that they cannot satisfy that, she still has to recuse.
And that's what that second section is for. I respectfully disagree with you. I think you have a major constitutional problem with this particular piece of legislation. But I also think it's interesting that you have on line 33, you have basically the alternative, which is if the Attorney General has a conflict that they can't screen out, and there's just no possible way that they can take the case, they can instead apply to the county attorney where the incident occurred and to get a special prosecutor, which is exactly what happened recently.
Yes.
Okay. Now, on that section is amending 701 of the county law, and it adds a section to the county law that does not currently exist. Is that correct?
Yes.
Okay. And the way it stands right now, if the Attorney General takes over a case or decides to prosecute a case instead of the district attorney from that county, the Attorney General has to get a special prosecutor that either lives in the county in which the incident occurred or a adjoining county. That's what the current law is. Isn't that correct?
Yeah, and that's how they're handling the current prosecutions now. Yes.
Right. This legislation changes that a little bit. This in the specific scenario where the Attorney General has taken over a case from a district attorney and has realized that there's a conflict, the Attorney General can petition the court to get a special prosecutor. It doesn't need to be somebody who's in the county or somebody who's from an adjoining county, but anywhere in the state, so long as the court determines that that person has the necessary experience and qualifications to handle the case. Isn't that correct?
Yes.
Okay. And it also authorizes that special district attorney or that special prosecutor, we might say, to have all the duties and responsibilities of the Attorney General and that in that case, and also to then to be permitted to make an application to the Department of Budget in order for any necessary disbursements.
Correct.
And that's in the circumstance where it's a big case and there's a lot of expenses, that special district attorney won't be burdened by those expenses. Is that correct?
Correct.
Okay. Mr. Deland, thank you so much for answering my questions on the bill.
On the bill.
So I think Part F is problematic. You know, this is, I think, maybe the issue with having an omnibus bill. You're adding a lot of sections in there, and, you know, maybe sometimes you don't catch an issue like this. But I think that there is a big problem. You know, under Article 6, Section 2 of the New York State Constitution, and under Section 90 of the Judiciary Law, it's the courts that oversee attorneys. They handle admissions, they handle certifications and recertifications, continuing legal education requirements, grievances, and ultimately any disciplinary action. So regardless of what this legislation says as to whether the Attorney General's actions will be considered a conflict or not, or shall comply with the rules of professional conduct or not, it's the judiciary that's ultimately going to decide. And the problem, right, just from a practical standpoint, is if the Attorney General decides to use that section and prosecute a case thinking that the Attorney General has the authority to do so, they put that...
Thank you, Mr. Molitor.
Sorry.
Mr. Gray?
Mid-thought.
Speaker, will the sponsor yield?
Will the sponsor yield?
this may prove to be the most difficult
Sponsor yields.
position
This
of
is,
the
in
day.
fact,
But yes.
it is. So, first of all, let me thank you for answering all the questions that you've been getting them for hours on end. I would only say that we would be willing to take questions from the other side of the aisle anytime you want to let us get a bill through the floor. So, thank you very much. So,
I'm trying to protect my appointments on a few boards that we may be adding in this bill.
you can stand on the other side of the desk if it makes you more comfortable. So, anyhow, so there's information that's generated from docs that is regarding incarcerated individual violence on staff, incarcerated individual violence on other incarcerated individuals. Is that correct? Yes. Yep. Okay. And how is that information gathered? How is it generated?
Largely right now, it's gathered by docs.
Okay. But what's the genesis? How do they get it? Where does it come from? Come from reports? Where is it coming from?
Yeah, could you repeat it? Could you repeat the question?
Yeah, so where is the information actually originated from, right? Is it reports that facilities are filing with the central office?
I believe so, yes.
Okay. So with the Part B, the comprehensive coverage with the cameras, do we expect any additional reporting or any additional information coming from these cameras in the way of reports of violence that aren't otherwise reported?
Yes, so it requires the commissioner to do an annual report.
To do an annual report on everything that's captured on these cameras in terms of violence that is not reported otherwise.
Only regard to the actions of the cameras, actions.
Okay. Okay. So now covered. So they're in all the way around in the facilities. Would this include visit rooms?
Yes.
Okay. Alrighty. So we'll capture all the information there. If there's contraband coming in from the visit rooms, we'll be able to capture all of that information. Is that correct?
Along with a lot of hugs and kisses.
Pardon?
Yes, along with a lot of hugs and kisses.
More than that, sir. I've been in, just so you know, speaking from experience, I've been in over a dozen facilities in the visit rooms, and you'll see more than kisses. Just trust me on that one. So now, do we know in these facilities where the violence, and specifically what sections of these facilities the violence is occurring?
Docs may know. I don't know that the legislature may know in terms of specifics,
but we know generally what areas that it happens. The yard, where it could be, right?
Yeah. Again, I think docs may know. I don't think we looked in this bill to capture that, level.
But we're talking about transparency.
Of detail.
So we want transparency. We want to know everything that's going on in these facilities for the protection of the incarcerated individuals, for the protection of the uniformed staff, for the protection of the civilian staff. Is that correct?
Yeah, but as to as it relates to your question, the specific locations of where they happen,
yeah.
Docs will know that. They'll be able to address that. And I think in one of the initial steps that the governor did as a result of the homicide was they enacted partnerships with outside firms to conduct like safety gap analyses and using the data that they will get from these outside providers to kind of address problematic areas. It'll be a partnership that Docs has ongoing. It's not really captured in this bill, but it has. What you're asking has been addressed by the executive as part of their reforms that they can do at that branch, but it's not in legislation.
Okay. So let me just share that a lot of the violence in these facilities happens in the shower area, right? So, and that's one area that's not going to be covered under
Yes.
this. So we're going to have a glaring omission of activity in these facilities, correct?
So you're right that that is a problem.
Yes.
But I think you could see for humane reasons why we left that out. But what will be captured is areas of ingress and egress will be captured by
Yes.
camera.
So, and you talk in that same section, you talk in section B, it is, or line 44, it talks about fixed stationary cameras and to capture both audio and visual footage.
Yes.
Okay. So is there any objections to capturing the audio only in those other areas where we can, where it could be heard what's going on?
Yeah, but I guess this was done this way because, previously there were issues about privacy in bathrooms.
Visual. Well, I mean, you could say it's audio, but it's mainly visual. I'd say the concerns would be probably
and,
more.
and look, I would say to that, I see where you're getting, and it's a concern. And like you said earlier, this is the first step. This is not the end. And if it proves to be problematic, especially after the work of the outside entity that the governor's office has appointed to be one of the first reforms, after their work is concluded, I would have to imagine, and that's not the only aspect, I'll get into that later, I have to imagine that would generate things that could become further legislation. But right now, that's kind of where we are.
Yeah, and I would just suggest that maybe we look to capture some of the information in reports that are coming from all this improved transparency. So we actually can tell how it's working. It's one thing to implement it, it's another thing to know that it's actually functioning, correct?
Correct.
Okay. Just one other a couple other quick questions. Enforcement on the page 4, line 17 through 20. That section there really reads that it's more penalty. It's not enforcement. So could you talk a little bit more about the enforcement of these camera operations?
You're talking about the enforcement that's granted to the Inspector General?
That is correct. The way that reads, to me, it reads more penalty-driven than it is enforcement-driven.
Well, that is how it's enforced, by penalty?
It doesn't say how it's enforced. That's my point.
Well,
it talks about the penalties, but it doesn't talk about how it's enforced.
So the Inspector General can do annual audits, and in further line 20, the Inspector General can take corrective actions, and I guess the monetary power, the monetary penalties would be on.
And also section 6 is accountability and review, which provides for inspection.
Okay, so I guess your concern is in and around the Inspector General's authority to impose impose monetary penalties.
That's a penalty. I want to know the enforcement.
Gotcha.
How it's being enforced, or how it's being audited, how it's going to work, how the enforcement actually looks.
Annual audits, but what I would say is that this is something that the administration wants to do. I would say that if at any point a future administration doesn't want to do it, then the powers of the Inspector General could kick in. But it's enforced here.
Yes. Well, I would say anybody that installs cameras actually wants them to all work. I happen to represent a power facility that straddles the international border from Canada to the United States. And we had an individual that walked all the way underneath through the bowels of the dam from Canada to the United States and found that over 24 cameras were not working. So my point is that there has to be, is there going to be some enforcement versus just after the fact penalties? But we'll agree that that is kind of incomplete.
So the Inspector General under this section is empowered to do annual audits.
Okay.
To ensure compliance under this section. So at that point, you know, the governor or the legislature or the rest of the government can take action.
Okay. Alrighty. Then Part C, just briefly on Part C, it says that the department shall promptly notify the next of kin or any person designated as a representative. Can you define that the latter part of that statement? Who classifies as a designated representative?
It's already in code.
What are the options?
Well, that's current law. We're not amending that.
You're not amending it?
No.
It's underlined. That's new wording.
No, it's not. It's not. Promptly notify us of the line. Next.
Line 43, 44.
Yeah, but right up here, it's already in current law. Line 40.
So if you see in just above in Part C on line 40, it's already written in current law, not underlined.
Okay.
So we're just copying it and putting it and repeating it there.
Okay. Alrighty. And then just line 47, you referred to, and again, one of my colleagues asked it earlier. I'm going to re-ask it because you referred to autopsy report. And in this instance, it just says autopsy report. But if you go to Part E in line 33, 34, it talks about autopsy, and it talks in conjunction with toxicology. So is that an omission in Part C, toxicology?
So, and I believe this question was asked of me earlier also. I've just been informed that toxicology is already covered in current law.
Covered in C?
No, in current law.
Oh, in current law. Got it. Okay. Okay. That's it, Mr. Lon. I appreciate it very much. Thank you for your time and answering the questions.
Ms. Walsh?
Thank you, Madam Speaker. Will the sponsor yield and recognize that once again we're in an awkward position? You're not going to hurt my feelings at all if you don't look at me.
Will the sponsor yield?
I will yield and not say this is probably the best position I've been in.
Oh, okay. All right. Well, I'm glad I could help.
Sponsor yields.
Thank you very much, Madam Speaker, and thank you to the sponsor. So we've been debating, obviously, this bill for several hours. I can appreciate that some of the questions I'm asking may be redundant. I'm going to try to just go through them quickly. And I do apologize if you are repeating yourself, but I just want to be absolutely clear. The good news is I'll take it from Part A and work forward, so at least it'll be in some kind of order. It'll be in some kind of order. Okay. So Part A, the video disclosure relating to the incarcerated individual's death. Okay. So this part, am I correct that this part has to do with not only docks, but also local correctional facilities? Is that correct?
Local facilities are exempt. This applies to state facilities only.
Okay. But my notes had said that for this section, it applied to local correctional facilities. So if I'm mistaken, I apologize.
So I have to reverse myself. You are correct.
Okay.
Yes.
But to your knowledge, is there any other part of this entire omnibus bill that relates to or impacts local correctional facilities, or is it just this Part A?
Just this Part A.
Okay, very good. So this says that the Attorney General's office there'll be disclosure to the AG's Office of Special Investigation any video footage the office deems relevant to the death of an incarcerated individual within 72 hours of the incident, including cases involving correctional officers. Okay, so it said that the footage will include recordings from fixed or stationary cameras, body-worn cameras, handheld devices, and then it says, or any other recording equipment used by correctional staff at the time of the incident. So I'm hoping that you can help me understand. I thought, but maybe I'm wrong, that correction officers are not allowed to have their cell phones on their persons while they're doing their shifts. Is that, or are we trying to get at maybe what a staff member might be carrying that they can carry? Like, are we talking about cell phones here that they might have?
No,
okay.
We don't change cell phone policy in any way.
Okay.
In this bill, but we do allow for, the audio of any other DOCS approved device that may pick up recordings to be used.
Okay, so when it says any other recording equipment, then could you just tell me what you're contemplating with that? If it's not cell phones, then what would it be? Or is it just a catch-all meant to just cover anything?
So I'm told DOCS sometimes use handheld video cameras and have other means so that if any other DOCS approved device catches something, that it can be captured this way. If they have devices that we don't know of now, or that devices are invented or manufactured in the future that are DOCS approved, they can be captured under this section.
Very good. Okay. And when we're talking about that the office will deem relevant to the death, it's obvious to me that an incident leading up to the death of the incarcerated individual would obviously be included in terms of video footage of that. But how far back in time may the footage go? Is there any sense of that? Like, are we looking through the entire day of the individual or the week of the individual? Or is it really just the incident itself?
So it gives them discretion to deem what footage is relevant to turn over.
Okay.
If it's clearly by when they look at it not relevant, they're not required to turn it over.
But it's in the sole discretion, the way I'm reading it, it's in the sole discretion of this AG's Office of Special Investigation to determine what is relevant and how far back maybe they'd want to go, correct?
Yes.
Okay.
Correct.
All right, that's fine. And then the footage says that it will be maintained by the AG's office confidentially, and it will determine redactions according to its published video release policy. So,
I would be a little bit more specific with that question. The AG's Office of Internal of OSI, to be more specific.
Very good. Okay, that's special unit. Okay. And so let's move on to Part B, the comprehensive camera coverage. So let's see. It says that facility superintendents are responsible for regular assessments of camera placement, functionality, addressing any blind spots, and non-functioning cameras. When it says regular assessments, nothing is called out. So is that going to be left to the DOCS commissioner to establish what regular assessments means?
Yes, and I have to imagine that they would do that in consultation with the partners that they are contracting with, that the executive released as part of their reforms as well.
Okay, very good. And can you just describe or distinguish for me the difference between 1 year of retention of footage and the 5 years? What is going to trigger the longer period of time for retaining the footage?
Say it again. Okay, so ordinary is 1 year. Then, give me that again. So line 7, where might be? Well, you got me lost here, buddy. Sorry. A minute, I got you. So the 5 years kicks in based on the language on page 4, line 7, reads allegation or report of any staff misconduct or rule violation. That's where the 5-year period gets kicked in.
And just when I was reading that, and I appreciate you pointing that out to me where it was, that seems extremely broad to me because that doesn't just include like written complaints, and that could mean a lot more than that, right? And it could be involving even something as, relatively speaking, as small as a rule violation, right?
Yes, as the language says, yes.
So would it be fair to say, or fair to conclude that footage will, more likely than not, if there's been any kind of a complaint, could it be held for that longer period of time?
Yes.
Okay, all right. And let's see. Let's move on to Part C, the notice of death in correctional facilities. So it requires docs to promptly notify the next of kin. Once again, promptly. Is that something that's going to be just at the discretion of docs to identify? I understand what the ordinary meaning of the word promptly is, but is there going to be a specific time frame set for that?
Yes, and the current practice is within 24 hours. And as you can see in the few words before, the part that we're striking in law, even though DOC's current practice is 24 hours, we're striking the words "be responsive for inquiries from."
Okay. Yes. Okay. Thank you. I appreciate that. I'm going to skip over Part D, the study on deaths, because I think that that's been covered, and I think that that's pretty self-explanatory to me. Part E, the enhanced autopsy reporting. Question I had was, must all incarcerated individual deaths be autopsied under our current law and regulations, or only suspicious ones? And does this Part E change that in any way?
So it doesn't change current law practicing.
Okay, and what is the current practice? Is it only for suspicion? So, for example, I was thinking of somebody that has not been early released, but they have cancer, they have terminal cancer, and they pass away in the correctional facility. Mm-hmm. Would that be an autopsy that would be done automatically, or what would be the policy about that, if you know?
So we believe it's an autopsy under all circumstances for folks in DOC's custody.
Okay, all right. And last question on this section.
And I would say we believe.
Yeah, no, I understand. I appreciate that. I know that some of the questions I'm asking are a little bit outside the scope of the bill because I'm asking about what the current practice is, and you may not know that. I appreciate that.
Yeah.
But as far as autopsy, do you happen to know, can family or next of kin reject or say no to an autopsy, or just by the sheer fact that the individual has been incarcerated, does the family or next of kin have no say about whether the autopsy is going to occur or not? It will occur.
Now you're talking current law, right?
Yes.
Yeah, so I would say we were unsure, but there were other proposals that we took a look at as we looked at autopsies to allow families who maybe were suspicious of an autopsy report to get their own independent one done, paid for by the state. That was one of the proposals that were looked at. Didn't quite make it, but it was something we considered. But in terms of their current rights, I'm unsure. We probably have to get back to you on that.
Okay, that's fine. I was just wondering because some families, for religious reasons or other reasons, would not want an autopsy, and I was just curious. That's okay. We can move on.
Yeah, and certainly if that right exists in current law, this doesn't
It doesn't change
This doesn't encroach on anyone's religious rights to do that in any way in this bill.
in this bill. Thank you very much. Okay, so I'm going to skip over Part F because I believe that a previous debater covered that section thoroughly. And I will even skip over Part G. And now looking at Part H. Okay. So I noticed, and I see my time is swiftly passing. So let me just ask one quick question about this one. I did a little looking up about what the State Commission of Correction does, and it defined it as an independent watchdog over state or local correctional facilities, tasked with ensuring the safety, health, and operational standards of facilities. So it mentioned different cohorts that have to be included in the commission's composition, but it didn't include anybody from the correctional or law enforcement community on there. It seems like that person or that individual maybe would be representation that you would want. I just wanted to give you a chance to explain why they were not included in that.
In terms of what, membership?
Yeah, to be on the commission.
So yeah, they're not specifically lined out as mandated to be included, but they're not excluded because there's nothing that prohibits any one of the appointing authorities from placing law enforcement or corrections officers to this board as a member.
Do you know if anybody currently on there is a member of law enforcement or corrections?
I believe the president is a serving sheriff, or
Okay.
a former sheriff of one of our counties.
That's great. Okay, thank you so much. And let's see. Part J, I know there's been a lot of discussion about that. So my understanding is that that it basically, what this part is doing is it's creating tolling, where during your period of incarceration, your right to bring suit is being tolled, like it would almost like for infancy or for other issues. The law would toll it so that your time to commence a lawsuit about something that occurred during your incarceration will not start to run until you leave.
Yes.
Okay, I just wanted to clarify that. Thank you so much. I know I ran through a million things at
No,
once.
it's fine.
Mr. DeLon,
actually
thank you.
the most organized approach I've had to deal with
Well,
today.
I've had a little
appreciate
time to consider it here, so thank you. Madam Speaker, on the bill, briefly.
On the bill.
Thank you. So I appreciate all these answers. I have to say that there is a lot in here that I really do like. I do like it because I'm a big believer in body-worn cameras and cameras generally. I think that it tends to work to help both sides, all sides to issues, to figure out what really happened. I think we need to work together to build a better system. I think that we need to make sure that we have enough corrections officers. We need to train them properly. We need to ensure correction officers' safety, especially the women COs that I've met with. We need to reduce the toxic workplace environment. We need to reduce and eliminate contraband. We need to reinstitute rehabilitative programs that have been suspended because we don't have the good ratios that we need in order to run these programs. I think that the problem with an omnibus bill, and I'm running into it right now, is that when you have 10 different bills all lumped together and the debate time's been cut in half a couple years ago, and we're getting to a point where we're maxing out, we can't give these things the attention that they deserve, but I tried. So thank you.
Thank you. Mr. DeLon.
Madam Speaker, on the bill.
On the bill.
So I just want to thank everybody in the chamber for the discussion. As you can see, the amount of passion and the range of emotions are high. And I know there's some folks out there who are frustrated, both in the chamber and out of the chamber, who are frustrated that we're not going far enough. But I would say, look, this is a step. I clearly don't believe that we're ending here. I think the first step, was taken by the executive. It was an important step. It was stuff that the executive could do to some degree without legislation. I mean, the first thing they did after the incident was install a new superintendent at Marcy. they expanded DOC's whistleblower protections. They launched partnerships with private entities to do safety gap analysis, to do public health and human rights analysis of programs in prisons. They've done, a host of things, including the one to me that was most important, that they created a new dedicated unit on the future of prisons within New York State at a nonprofit agency, I believe. It's a nonprofit agency. I'm not sure as I look at it. Those were the first steps that the executive could do on their own, and I believe that was the first step. I think the next step that we did collaboratively was enact protections and do things in the budget, like providing the funding for cameras, providing expanded funding for our independent watchdogs on docks like Caney and like the State Commission on Corrections. I would say in that regard, there's a lot to do. Prior to this year's budget, for an entity that is supposed to be the state's independent watchdog of docks, maybe almost in the model of, and I say almost because it's different, but almost in the model of New York City CCRB, they received consistently $3 million in appropriations to independently oversee an agency that has a budget of over $3 billion. We need to do more there, but it became clear at some point in our history that this agency's powers had been gutted to be the independent check that they were supposed to be when they were founded in the 1800s, after the reforms that were made by law after Attica, which, by the way, were done by Republican administrations across the board, which were okay, but even at that time, they were done in conjunction and in negotiation with incarcerated individuals. And as we all know, Attica did not turn out well for those who were under incarceration. So to have the checks that people of this state have been attempting to correct for over 150 years in our history clearly says that our system of independent checks are broken. So that was an important step to take in the budget. Expanding DOC's internal OSI, because there's two different ones, one within DOC's and then one within the Attorney General's office. Collaboratively, we allowed DOC's to have that expanded authority because DOC's can also do the same thing within DOC's, and people who are under incarceration can also make complaints to DOC's OSI, and they can have those complaints substantiated and proved by DOC's OSI, and they can do it. What most folks, thankfully, we didn't talk about the information and reporting that OSI has to do. I think it was pretty clear and rather non-controversial. That's why I say thankfully. I think people, as they reviewed the bill, it was pretty clear to see what we were trying to achieve. The feeling at the time is though, if we're going to give DOC's OSI, internal members to do reporting on these incidents, that it should not remain within DOC's, that even the investigations that are conducted within DOC's also be made public. So that was an important transparency piece. So today is another step, and I know folks, even though they haven't maybe said it, some have said it, and whether you have said it or haven't said it, I certainly appreciate that you either said it or didn't, because for the folks that didn't say it, I know the sentiment is that this doesn't go far enough and that we do need to do more. I certainly agree. And that's why I highlighted some of the steps that the governor made with some of those partners, because I believe when their work is concluded that it will give us the opportunity to look at potential for new reforms and new legislation. I would also like to, just say that the accountability, transparency, and oversight is only one approach. I think when there are crises and it's clear to the public that your government apparatus has failed, it's incumbent upon all of us to attempt to fix that. But it doesn't, in my mind, end here. There's a lot of folks outside this building that are disappointed with what we are doing here today because they don't believe it goes far enough. So I would say that things like sentencing reform and parole reform are things that are important to me. A lot of that stuff did not survive and make it into this package, and some of them, did get close. And I'd cite one, things like the Earned Time Act. The Earned Time Act was put into the budget by the executive. There is a member that carries an independent piece of legislation that we're considering, and there's been discussions on the mechanisms of Earned Time Act, and folks are going back and forth, but they can't agree on those mechanisms. But I would say that the fact that the governor, not anybody in the legislature, injected Earned Time Act into the budget means maybe we don't yet agree on the mechanisms for folks doing well to earn time off. At least shows that the governor's at least willing to engage in the discussion. So I think while things like that didn't survive, I do think that ideas like that have taken important steps forward as we continue to try to solve these problems in the future. I think on sentencing reform and parole reform, there are a lot of ideas that the caucus came up with, that advocates came up with, that I like. And, Second Look Act specifically, which I found to be pleasantly surprising, was, said to be supported on record by, one of the highest members of the court in this state. That was encouraging to me as I sat there. So to the folks that feel like we haven't gone far enough in that regard, I would say we're a lot closer than you think. And, they express frustration that they will probably never see their reforms be enacted in their lifetime. And I remember one of the first bills that I had to deal with when I was here was medical aid in dying. I was dead set against that when I got here. I said, that's never gonna go. I'm not gonna allow that to go. It is impossible to pass that bill. 11 years later, this body passed it, and it passed the Senate, and it's before the governor for her consideration. So I would say that, if you feel like that hope is gone, medical aid in dying is, a good example of how to keep going on and keep pushing. So I encourage you guys to do so. I just want to take a moment to just basically thank, the caucus and colleagues and, everybody else that has expressed an interest in getting this done. This is all of our work. This is not just my work. I think everybody has, put forward their ideas and done things. And I know folks see me maybe tearing up now, but, a previous speaker said that no one ever cried. And I was personally happy that during the budget discussion, no one saw me cry, because I did. And maybe one person saw me, but I chalked it up to allergies, because I tear without hoofing. That's just the way I do it. I didn't think I would do it today, because I told myself, don't. Just don't. But this is important. It's not partisan. It belongs to all of us, this system. The failures of it are on all of us while we're here. I told myself I would not do this. I'm fine. My kids are home safe. That's not the case for everybody. And the amount of calls that I got, and the amount of letters that I got from folks that said they're concerned about their family and their kids was troubling. And I appreciate what the caucus has done, in their advocacy too. I'll take it. I'm not shy. It's already out there. I might as well just deal with it. And I appreciate the passion and the emotion of everybody, because it's really hard to talk about this in a real way without getting emotional. Now, I've been fortunate, right? I have family inside. Other people have family inside in this chamber. Folks have talked about the experiences of their family being brutalized. But my family's been beat up too. And I've been holding that in. And this moment, man, it's not about me. Nobody should care about me. I'm fine. I'm fine. It's about all of us, right? It's about all of the people that we love. Some members of my family that inside did do something wrong. They did, right? They did. I want them protected, just as alongside everyone else that as well, that are all the people that are not members of my family. There's been stories of other folks, and I was able to absorb it. And the fact that in those moments I wasn't crying, I think I surprised myself. I'm going to end by just saying, when Speaker Hastie became Speaker, the first words he said was that reforming the criminal justice system would be the focus of his speakership. And that had me. I was all in. I had the opportunity to go back to the city council, a place I love, a place I started my professional career. But I realized that if I went back to the city council, I couldn't help him carry out his mission. Now, when that happened, I had no idea I would ever become the chair of corrections. I just was happy to have a vote in the legislature that impacted that. So when all of you guys do this stuff, yeah, it matters. Yeah, I may be good at hiding emotion most times, but I'm like everybody else. I'm human too. I'm a person too. So to say that, and I see the leader coming over, I guess I'm not sure if it's for moral support to say to wrap it up, but I thought the buzzers were, all right, I'm done. So thank you, I'm done. we shouldn't be clapping. We really shouldn't be clapping. There's people out there that are hurting. You know, there's people out there hurting. This is not a moment to celebrate. Thank you. I intend to vote aye.
Thank you. Read the last section.
This act shall take effect immediately.
A party vote has been requested. Ms. Walsh.
Thank you, Madam Speaker. Although there are definitely parts of this bill that I think we can all agree with, the Republican Party will be, generally speaking, in the negative on this bill. Anybody who wishes to cast affirmative votes can certainly do so at their seats now. Thank you.
On a motion by the Senate, on a motion by Mr. DeLon, the Senate bill is before the House. The Senate bill is advanced. Read the last section.
This act shall take effect immediately.
A party vote has been requested. Ms. Walsh. We're going to do it again.
Sorry, I thought I was losing time there. I thought I just said that. Okay,
You did.
I did. I know. The Republican conference will be in the negative. Affirmative votes can be cast at this seat now. Thank you.
Thank you. Ms. Peoples-Stokes.
Madam Majority Leader, the majority conference is going to be in the affirmative on this piece of legislation. However, there may be a few that would need to be an exception. They should feel free to do so at their seats.
Thank you. The clerk will record the vote. Ms. Lucas to explain her vote.
Nothing. Okay. Thank you, Madam Speaker. I'm excited to be in support of this vote today. We all fall short of the glory of God. But the one thing that God affords us is forgiveness, and we have to learn to correct without canceling. And with that correction comes a level of dignity, humanity, and respect. In visiting prisons, I realized that some of the prisoners are afraid to even report certain things because there's retaliation of continuous violations. They are brutalized and asked to hide their bruises. When they report these things, they are violated even more. It's like the police policing the police. If they go to the commissioner calls over to the location. If they call out and report it to OSI comes and investigates in front of the very people that are actually committing these egregious acts. So this does not address all of the major concerns that we need to have oversight on the many egregious acts that are implemented on those individuals, but it is a beginning, it's a start, and we live to fight another day for additional things. So with that, again, I support this piece of legislation. I commend this body for working on it collectively, and I vote in the affirmative for this bill.
Thank you, Ms. Lucas, in the affirmative. Ms. Romero to explain her vote.
Thank you, Madam Speaker. Before I was elected to the New York State Assembly, I was a public defender, and myself and others involved in the criminal legal system as attorneys, advocates, or formerly incarcerated individuals, we are aware of the darkness, the sludge, the nasty, the intensity, the pain, and the literal bloodshed that exists within prisons in our state. While there are inevitably people like my mother and father, both lifelong DOCS employees, not COs, but my father retired with parole and my mom eventually retired as a director of corrections with mental health, people that are good and loved their job. While there are people that do love their job within DOCS, there are people that are ugly within the DOCS system, and the lynching of Robert Brooks exposed this ugliness. And it exposed this ugliness in our prison system for so many people, and it is for that reason that we must identify this and eliminate it. It's my sincere hope that this omnibus bill addresses this, and like I said, eliminates this ugliness within the DOCS system. While I join some of my colleagues in aching for other criminal justice reform in this session, I do thank the Speaker and the sponsor for putting something forward that I do hope inevitably will do some good for thousands of New Yorkers that need it. I will be voting yes, but I do not forget that the fight is not over, and that I look forward to working with my colleagues and the input of people that I know love the system, like my parents and my fellow attorneys and currently and formerly incarcerated individuals, just like my eloquent colleague in the back row that has been breaking barriers. I vote yes and look forward to the future fight.
Ms. Romero in the affirmative. Mr. Epstein to explain his vote.
Thank you, Madam Speaker. I rise to explain my vote. I want to thank the sponsor. I want to thank the Speaker for moving this package forward. One of the bills in this package, the reporting of the death of an incarcerated person, we've been working on for 3 years, and we've talked to so many families and been to so many facilities. And you know, families keep saying, we don't know what's happening to our loved ones. We didn't know when they passed away. We got no information for day after day after day. And part of this package is allowing family some closure. But what really this whole package is about is trying to bring transparency and accountability to our correction system. And if we really believe in corrections, this is an opportunity we have right now in this moment to do that. The murder of Robert Brooks, as everyone keeps saying, really put a spotlight on what's going on in corrections. We see it every day when we talk to people who are incarcerated. When we visit prisons, we hear from them directly. We hear the fear, the anxiety, and the risk. It is our responsibility to deal with the life and health of New Yorkers, whether they're behind the wall or not. And this is our opportunity to continue to move forward. There were some things that we couldn't get in this package, and I know with the work of this body, we will get there someday soon. But this is an important first step, and I'm voting in the affirmative. Thank you.
Mr. Epstein in the affirmative. Mr. Marr to explain his vote.
Thank you, Madam Speaker. To explain my vote, at the beginning of this year, I did not believe and understand that a majority of my time would be monopolized on this issue. And with the work action that took place, having 4 prisons in my district and 2 right next to my district where a majority of the folks that work live, it was all-encompassing. And I really appreciate the sponsor's emotion. I take it to heart because I feel that same emotion. And when we advocate for correction officers, we are not advocating for the murderer of Robert Brooks, murderers. We're not. I choose to see incarcerated individuals and view the majority of those folks as individuals that want to reintegrate back into society and become productive members of society. When I look at our correction officers, I choose to view a majority of them as the folks that are helping save lives in prison. We can't simply judge either side for their worst, and we need to overcome that, all of us together. The number one issue facing our prisons is the staffing crisis. The number one recruiter for correction officers are correction officers, and they're not encouraging anyone to work. They need to have a seat at the table. We all have to acknowledge it, because what's best for our correction officers is also going to be eventually what's best for those that are incarcerated. We can't have the programming, we can't have the recreation until staffing levels reach a certain level, and they won't until this conversation is completed in a true bipartisan way with everyone at the table talking to each other and with each other and not past each other. I'm very much encouraged by the sponsor, by several of my colleagues on the other side of the aisle, to hopefully continue that conversation.
Thank you, Mr. Marr. How do you vote?
I vote in the negative. But
Mr.
with
Marr
hope.
in the negative. Ms. Szilagyi.
To explain my vote, our justice system rests on the idea that even when someone is incarcerated, the state is still responsible for upholding order and treating every person with basic human dignity. It is a serious duty. So when a public servant, someone who took an oath to uphold the duty, takes a life, it is not a tragedy, it's a breach of trust. The death of Robert Brooks and the death of Messiah Netwit raise serious questions about how we oversee our correctional institution and how we hold our own systems accountable. We can't stop at oversight. True public safety includes accountability, structure, and the opportunity for people to change. A system that punishes endlessly without a path to redemption It's not one that reflects our values here in New York State. I want to thank Speaker Hasty for his responsiveness. I also want to extend my gratitude to the chair of both correctional committees in both the Assembly and the Senate for truly taking their passion and their persistence and getting this omnibus together. And I especially want to thank my colleagues in the Black, Puerto Rican, Hispanic, and Asian Legislative Caucus for refusing to look away. Through your strength and your unwavering focus, we are turning loss into action and outrage into accountability. But our fight isn't over. Let's carry forward the names of Robert and Messiah, not as headlines, but as a call to action. Let their memories be the reason why we refuse to accept the unacceptable. And with that, I vote in the affirmative.
Ms. Delage in the affirmative. Ms. Heineman to explain her vote.
Thank you, Madam Speaker, for allowing me to explain my vote. Individually in this body, we have had to bury loved ones, whether it be children, parents, spouses, friends, neighbors, and constituents. I don't believe any of us can say we saw a loved one beaten to death on camera for the world to see, as the father did, Mr. Robert Brooks, who watched his son die. His death isn't in vain. It spurred this package. And I want to thank the Speaker and the sponsor of this legislation that through these works, this bill will be signed by the governor and be brought into law, and all of the other bills that we need to get passed in this House to make sure that this doesn't happen again. Thank you, Madam Speaker. I vote in the affirmative.
Ms. Hyman in the affirmative. Mr. Burke to explain his vote.
Thank you, Madam Speaker. Listening to the debate is what I was going to make my decision on, and what I've realized is I've already known, but it's more clear now than it ever has been to me. We have a deeply, deeply broken system. The state is failing a lot of people, and it pits people against each other. I've heard incredibly dehumanizing language and rhetoric. I've heard people refer to COs as monsters, and I've heard other people refer to incarcerated individuals as animals. And when the debate goes down to monsters versus animals, everyone loses. It's going to result in violence and dehumanization all of the time. So being thoughtful and conscious of how we speak about people and focus on fixing systems. But from my point of view, I've had members of my family who are incarcerated. I have members of my family who are COs. My brother-in-law was stabbed at 7 times. Unfortunately, he had a stab vest on. He's one of the most mild-mannered people you will ever meet. He's not a monster. So just casting all of these people in that light is dangerous. We do not need a powder keg in our prison system. We need to fix broken systems. I think this is an honest effort towards doing that, and I look forward to continuing that effort. Thank you, Madam Speaker. I vote in the affirmative.
Mr. Burke in the affirmative. Ms. Levenberg to explain her vote.
Thank you, Madam Speaker, to explain my vote in light of the horrific murder of Robert Brooks at the hands of corrections officers, which the world witnessed, the unlawful wildcat strike, and the inhumane treatment of incarcerated individuals. I want to thank the sponsor and the Speaker for putting forth this omnibus bill, which is one step in the direction of making our facilities safer. It works to shore up camera blind spots, increases transparency, extends statutes of limitations, increases oversight, and amends other laws to achieve the goal of safer spaces for all. However, I believe we need to do much more to reduce our prison population, and we have solutions at our fingertips. This omnibus bill is addressing aspects of safety, but essentially, aside from acting as a deterrent, these actions all follow when an incident has already transpired. What it doesn't do is change the culture inside our walls. It doesn't work to change attitudes. It does not incentivize respect for human beings, whether they be incarcerated individuals or overworked COs. To do so, we need to make a big dent in reducing the population, reinstating effective programs that significantly reduce recidivism and help individuals rehabilitate, and acknowledge that 95% of incarcerated individuals will be released. If we truly focus on rehabilitation and on second looks and on second chances, we will see change. We need to come back to past second look, earned time, the Marvin Mayfield Act, elder parole, and fair and timely parole. Then we will start to see significant systemic change. Madam Speaker, I vote in the affirmative.
Ms. Levenberg in the affirmative. Mr. Anderson to explain his vote.
Thank you. Thank you, Madam Speaker. I'm going to take a moment to thank my colleague from the 68th Assembly District for bringing his valued experience being in New York State's carceral system. May none of my colleagues here in this chamber have that lived experience and share it, but learn from it so that we can actively work to improve our incarceration system and our correction system here in the state of New York. I thank the sponsor for his hard work and all of my colleagues who have legislation in this package. I think that it's critical that as legislators in this chamber, that we all take time to visit a correctional facility across this state and see some of the things that I've had an opportunity to see over the last 5 years here in this chamber visiting facilities. The reality of the situation is that last year a man was lynched and his life was taken away from him due to the inadequacies of our criminal justice system. And I think it's important that in this moment, that in this omnibus bill that we're working to pass today, that we say that his life mattered. And that we say that the lives of the other 46 plus individuals who were killed or lost their lives in our prison facilities here in the state of New York, that their lives matter. This bill represents transparency, but it doesn't represent the things that we completely need to reform the system, like elder timely parole, RAP, and a bunch of other critical legislation, but it's certainly a step in the right direction. So, Madam Speaker, I thank you for allowing me to speak on this bill, and I withdraw my request and vote in the affirmative.
Mr. Anderson in the affirmative. Mr. Otis to explain his vote.
Thank you. The murder of Robert Brooks opened the eyes to all New Yorkers and to both houses of the legislature about what's going on in our prison system. It's too easy to say the prison system is over there, we're forgetting about what's going on. That's sort of the tendency in society, and it's a big mistake. It's a dangerous mistake. So Robert Brooks died, was murdered, but what we've also learned is how many other people die behind prison walls. Shocking, terrible. As has been mentioned, most people are coming out. And so what are we doing to improve education, improve job training, improve the safety of the institution for those that are incarcerated, for those that work there, so that this can be an experience that people can leave and not come back, that people can go on with their lives in a positive way? We have a start with this bill. This bill is really about a little more safety, a little more accountability. That's not enough. We really have to revisit our whole correctional system and make the resources available for it to be a safe place, to be a place where people can benefit from the experience and get out and change their lives. We have a long way to go. This is a very good start. Congratulations to the chair of the committee, Mr. DeLon, to the speaker. The last thing I'll say is in the budget hearing, we heard from moving testimony from Robert Brooks's father. And I just to be there and to sense the loss and this horrible situation, we have to redouble our efforts to make sure, as has been mentioned by others, that his life is not lost in vain and that we change the direction of this prison system in this state as quickly as possible. I vote aye.
Mr. Otis in the affirmative. Ms. Kellis to explain her vote.
Something that I keep thinking about over and over and over again is the fact that we had 6 men that were directly involved in a brutal murder that we all saw, that the world saw, of Robert Brooks. There were 15 people who were involved in the brutal murder of Messiah Nantwi, and every single one of them except for one is still walking free. And I think it's really important for all of us to imagine what it must be like to be the family members knowing that the world viewed those videos and all of those people are still free, because that would not be the case if they were black or brown people. They would be in prison. I think that's really important because what we saw in those videos is that abuse is happening and no one can deny it at this point. Does this package go far enough? No. Absolutely. For those families, no, it does not. It does address, it is a start, it does address accountability. And I want to thank the sponsor for having the courage to show humanity and show emotions, because there are very few men that are willing to do what you just did, and I want to thank you and honor you for that. And you also brought up the Earned Time Act that I sponsor, and I just want to thank you for acknowledging we might not have all the details worked out, but we will get there. And I will keep fighting with you to make sure that happens, because we know that it reduces violence against corrections officers. We know it reduces violence between those incarcerated. We know that it reduces recidivism rates. We know that it builds inspiration, that it brings families back together. We know that it's good for literally everybody, and there are more Republican states in this country that use it way more than we do. We're behind, and we need to catch up, because it's the right thing to do, to build workforce development, education, and send people back into the communities, knowing that we truly, truly created a system of corrections and not a system of punishment, which is too often what it is now, that we hear from our colleagues that is formerly incarcerated. We hear that too often.
Thank you,
so
Ms. Kellis. How do you vote?
I stand in the affirmative, and I vote yes on this bill.
Ms. Kellis in the affirmative. Mr. Gandolfo to explain his vote.
Thank you, Madam Speaker. I will be voting no on this bill, but that's not because there's nothing good in it. I won't reiterate all the reasons. Some of my colleagues have laid those out pretty well. But one issue as it pertains to this bill is the expansion of the Commission on Correction, but not including someone who is truly looking out for the interests of the COs. And that doesn't have to be in an adversarial manner, but someone who can make recommendations on how to improve safety for them. Because at the end of the day, the COs are also tasked with keeping the incarcerated safe. And if they are overworked and understaffed, I don't think we will truly ever get to the place we want to be in terms of our prison conditions. I think the governor would be well served to send a chapter amendment back to this House, adding a representative for the COs on the Commission on Corrections. I think that will pave the way to truly getting where we need to be and fixing the issues within our prisons. Thank you, Madam Speaker.
Mr. Gandolfo in the negative. Ms. Shimsky to explain her vote.
Thank you, Madam Speaker. We are nowhere as a society without the rule of law, and the acid test of the rule of law is how we treat people when we incarcerate them. What many of us knew before the murder of Robert Brooks and what everyone else learned thereafter is that the failure of our state correction system is so close to total that our facilities are really this generation's Willowbrook. This omnibus package is a great start, but what really counts is what we're going to do in the next several years, what we are going to do with all of the information we gleaned from the reform packages tonight. I am thankful that Mr. DeLon is going to be leading the charge on that. And in that spirit, Madam Chair, I vote in the affirmative.
Ms. Shimsky in the affirmative. Mr. Zaccaro to explain his vote.
Thank you, Madam Speaker. Today we stand at a pivotal moment in pursuit of justice and reform within our correctional system. And before us is a comprehensive package that not only seeks to enhance accountability and transparency in our correctional facilities, but also addresses the urgent need for reform. Reform that has been long overdue. For too long, our prisons have been places where justice is overshadowed by neglect and systematic failures, and recent tragedies that have underscored this reality, reminding us of our moral obligation to act. And the heartbreaking murder of Robert Brooks at the hands of correctional officers is a stark reminder of that urgent need for reform. His story is not just one of loss, it is a call to action, a demand for a system that prioritizes safety, dignity, and humanity, both for those who are incarcerated and for the dedicated officers who serve. Let us remind that while this package represents a critical starting point, it is not the finish line. It is where we must continue to push for additional reforms, for we owe it to those who have suffered in silence and to the families who have lost loved ones to a system that has repeatedly failed them. And in closing, I'd like to leave you with the words of the author and activist Audre Lorde, who said, "It is not our differences that divide us. It is our inability to recognize, accept, and celebrate those differences." So let us not allow our differences in perspective on justice and reform to divide us. Instead, let it unite us in our commitment to address these injustices within our prisons and champion the reforms that are so desperately needed. And with that, I proudly vote in the affirmative. Thank you, Madam Speaker.
Mr. Zuccaro in the affirmative. Mr. Gibbs to explain his vote.
Thank you, Madam Speaker. I stand here conflicted. I'm a hard negative on the bill. I believe that it doesn't do enough, and in expediency to put out a fire, we put together a package to address certain things, but not the most serious of the correctional facilities. I want to go on the record and say that all correctional officers aren't bad, but every correctional officer isn't Billy Jones, just like every incarcerated individual isn't Eddie Gibbs. We have to communicate better and listen to one another and respect one another during that conversation. But more importantly, there are people in prison who are suffering. Everyone in prison isn't a murderer. Everyone in prison isn't a pedophile or a rapist. Some of them have mental health issues. Some have drug addictions. But yet they are suffering in the walls and fences by abuse of correction officers. I share with you guys that 5 of them stomped on me for 25 minutes. It was horrible. I know the fear. When I walk inside these facilities, I see these young men and these women afraid. This package simply just put out a fire. It doesn't address that. So I'm a negative on the vote. I think we're going to do better next year. I remain hopeful. I pray a lot. I thank my colleagues on the other side for praying with me. And we just have to do better. Thank you, Madam Speaker.
Mr. Gibbs in the negative. Ms. Peoples-Stokes to explain her vote.
Thank you very much, Madam Speaker, for the opportunity to explain my vote. I think this is a start. I have to be honest, when I first got a glimpse of the video, I couldn't even watch it. I had to keep going back in order to see the whole thing, because I don't watch scary movies either. And I don't watch things when people are being hurt and bludgeoned. I just don't watch that sort of thing even on movies. So I had a hard time watching that. But I have family that work in corrections, and so I called them up. It's like, what is this about? What is this going on? And yes, they acknowledge that that does happen sometimes, but it doesn't happen all the time. And so one of my cousins, she sent me a letter from one of her colleagues who had just resigned because of the conditions that he had to work under. And in his words in the letter that he sent it to me, he said, "Not every correction officer is a bad person. Just as not every officer works but every officer does not work to their limits. It is easy to generalize, but the reality is more complicated. I've worked in corrections for 7 years. I've witnessed the bad, and I spoke up. I also saw the good, and I spoke up. The truth is that correctional systems affects everyone, including officers, the incarcerated individuals, and their families. This young man decided to retire or to resign rather than keep working in a situation like this. That says that this is a start in this legislation, but we got to fix this. We have to figure out how to fix it that engages everybody. So I would say that the only thing that should be different in this beginning legislation is that there should be somebody who is either a former correction officer or a current correction officer who sits at the table to come up with how we fix this problem. And I vote in the affirmative.
Ms. Peoples-Stokes in the affirmative. Are there any other votes? Announce the results.
Ayes 95, noes 47.
The bill is passed. Page 5, Rules Report 656. The clerk will read.
Assembly Number 6453B, Rules Report 656. Mr. Borres, an act to amend the general business law.
On a motion by Mr. Borres, the Senate bill is before the House. The Senate bill is advanced. An explanation has been requested. Mr. Borres.
This bipartisan bill, which earlier today passed the Senate with support from every minority party member,
is focused on keeping us secure from the most extreme risks from advanced AI development. AI experts and industry themselves have said that we need urgent regulation within the next 10 months. This bill, which only applies to the largest companies and developers, focuses on holding them to commitments on safety they've already made. In particular, every company that this would likely apply to today has already committed to, quote, give significant attention to biochemical and radiological risks, such as the ways in which systems can lower barriers to entry for weapons development, and to publicly disclosing their red teaming and safety procedures in their transparency reports. As such, this bill requires that those that spend $100 million or more on compute costs for training models have a safety plan and disclose critical safety incidents. And because this bill establishes lightweight guardrails that keep New Yorkers safe, it's supported by 84% of New Yorkers across party and hopefully all of you.
Mr. Blumenkrantz.
Thank you. Will the sponsor yield for some questions?
Will the sponsor yield?
I will.
The sponsor yields.
So we did discuss this in committee, but it seems like the bill's changed a little bit from there, so a few of the questions might seem a little bit familiar. As far as the changes from the A to the B print, many of the provisions surrounding the sections relating to employees, etc., have changed, correct, or been removed altogether? Also, anything similar or resembling a private right to action is also removed, correct?
I would argue that there was none established in the original as well, but this one we explicitly put in a clause that no private right of action is created.
Nothing in this article shall be construed to establish a private right to action. So you're pretty crystal clear there, correct?
I think so, yeah.
Yes. But there is the Attorney General still may bring a civil action in the new version as well?
Correct. Right. It is saying it is not creating any new private right of action. All of the enforcement is done by the Attorney General, and any separate questions about liability is handled in common law already before or after this bill.
So this bill has made its rounds in a few state legislatures, California in particular, where it passed and had been vetoed. What are the most fundamental differences between this version and the version that didn't quite make it past the governor's desk in California?
Yeah, this is a very different bill than the one in California. There are a number of things we've changed. There's obviously extraneous provisions, like they were creating their own version of Empire AI, and they were also doing Know Your Customer on cloud providers. We've taken all of that out. But on the meat of the bill, there's a number of differences. First is we put in the definition of a large developer, so it only applies once you spend $100 million or more. The California one could include people that spent only $10 million. We also apply it at the company level, not the model level, so they don't need to make 100 safety plans. If they have 100 models, they can have one and update it yearly. It's much simpler for compliance purposes. There's no reference to any kill switch, which was a big fear that many people talked about. And different versions of the California one over time established a new office, or didn't. This one does not establish any government office to any new government office. And I think the biggest difference now in the B print is that there are no audits in this bill at all. While there was a lot more opposition earlier in session, most of that was focused on the audits themselves.
So no outside third-party audits at all?
No outside third-party audits in this bill.
Let's go through some of the definitions. Then you just talked about the frontier model. You make specific mention also within your definition of critical harm.
Yep.
But there is a definition in there that I did have a question about. You talk about unreasonable risk of critical harm. How do you define unreasonable risk? I couldn't find it in the bill.
So reasonableness standard is one that's been part of common law jurisprudence for centuries and is applied in a lot of cases. We do have a very specific definition of critical harm, which is in the bill, as you've seen.
Very specific.
Yes.
So, I mean, almost so much so that I was curious in some situations, because you do include critical harm means death or serious injury of 100 or more people, or at least $1 billion in damages to rights, money, property, etc. If a system that would qualify under this as a large-scale frontier model were to commit a horrible crime, like take down a plane, but there were 87 passengers, that would not be considered a critical harm, and thus they how would that affect them versus maybe a plane that went down with 110 people?
So common law jurisprudence, right, would already handle any questions on after the fact liability. What this is saying is trying to be specific to the most extreme cases. Are those the ones that developers need to plan for, or to plan against, I should say, and develop tests in order to prevent? We had to draw the line somewhere. What we are trying to make clear is that we're really talking about the very extreme versions. We're not saying they need to plan for every potential use of their models.
So it's not arbitrary, but it's a little arbitrary.
Well, anytime you choose any number, right, you're making a choice. So yes, we have made a choice on a specific number here, but it is meant to point to the extreme cases.
Okay. My next question is related to the implementation of it on the knowledge distillation models, the 5 million threshold. Could you explain what sort of company would be captured in that definition? Because that seems to be pretty troublesome for the smaller businesses out there, for the startups out there, for those who might not be able to pay the massive penalty who might now be captured.
So the knowledge distillation clause is meant to ensure that we are covering risks from developers that do the very specific process of knowledge distillation, which I'm happy to go into if you would like, that can create a smaller model from a bigger frontier model, but that has similar capabilities. But very important in this bill is that if you do that once, you do that for a $5 million model, you are not covered in this bill. The only time this bill applies is when you have spent in aggregate $100 million directly on compute, directly on the final training run of models. So it will not affect smaller companies.
Who qualifies the direct compute? I think about DeepSeek, right? DeepSeek came out with those amazing headlines. They built it with no money at all, but the PLA, the Chinese government, private investment, all behind that small number was a much larger number. So because they said they did it for 10 million, would they be considered frontier? Who makes that qualification that they are a frontier model or not? I mean, not every company is domiciled in the US. Are we taking their word for it?
So with DeepSeek in particular, the model that really caught fire and made news was cost over $5 million to train, was made from knowledge distillation, but it wasn't made from knowledge distillation of a frontier model. It was trained on O1 from OpenAI, which would not meet the first definition of being 10 to the 26. So it wouldn't apply in that case, but similar cases in the future that would be trained off of a frontier model would be included in this bill.
So a startup in New York would be captured in this regulation, but Chinese government-sanctioned models that are being used in New York would not be captured?
Any frontier model with a nexus to New York, and it's specifically defined in the bill as being deployed wholly or partly in the state of New York, would be covered. And so insofar as DeepSeek is on the App Store, it's available in the state of New York, it would actually capture a future version of DeepSeek if it met the other criteria for being a frontier model.
You say a future version, so the current model doesn't qualify, but if there's a continuous movement of when you may qualify, if you continue to spend money on the creation of a next generation or a next iteration?
There are very few models that are confirmed to have the 10 to the 26 flops and 100 million in training. So this is a bill mostly focused on the models that are coming, not the ones that we're all familiar with and already working with.
Do you not see a world in which this facilitates, especially if this model becomes a multi-state, where we're moving companies or sort of maybe accidentally urging them to move into a black box and out of an open source because now they don't want to comply and they can do so without necessarily being an open source version of one of these models?
I don't think so. This bill is compatible with open source. The companies themselves have to design their own safety plan, and they can continue to produce these open weight models after this bill or before it. I'll note that what came in as an opposition memo said that they estimated that this would require one full-time employee to comply with. one full-time employee for Meta or for Google is not going to cause them to move.
You're saying that you don't see a future in which the capture for, let's say, maybe not the frontier model, which I'm up for debate as well, but the knowledge distillation threshold. There are only a few companies that are performing these at a basis of 5 million more than once?
Well, there's only a few companies that would get up to that 100 million spend, yes.
Okay, and it's, I guess, predictive that you'll start capturing every new frontier model by hitting this number?
I actually, well, it's sort of circular because we're defining the frontier model, but to take the question more expansively, I think in many ways this is under-inclusive, and I've gotten that feedback from industry itself, actually, as recently as a few hours ago, that they think the definition is in some case too limited in frontier models. But I did really want to focus on the most extreme risks and take a, again, light touch approach to what we're regulating here.
Okay, let's talk about the time period of disclosure. What made you land on the 72-hour mark for large developers and learning models, for incidents rather?
The 72 hours is based on other provisions in New York where we have a similar time frame, I think around cyber disclosure or nuclear disclosure, but we were very intentional in limiting what has to be reported within those 72 hours. It's simply that an incident occurred, which of the enumerated types it was, and we put in the bill a short description of what happened. So we do not require reams and reams of paper of reporting. We just want notice that something occurred. With how powerful this technology is, something could spin out of control quickly, so we think it's important to hear about it fast.
When we talk about the violations, the civil penalties, et cetera, you're pretty narrow in who qualifies somewhat, but the articles only apply to frontier models that are developed, deployed, and operating in part or in whole in New York State. Is there any definition to what level of participation in the New York State marketplace? Could they be selling a product? If it's a product that isn't necessarily selling something now, but selling something later, would they qualify, or just simply operating in New York? Where does that qualification level get?
Certainly operating and developed in, I think, are fairly clear, and deployed is defined in the bill itself as being used or being made available to a third party for them to use.
When it comes to the section relating to the unredacted copy of the policy, so you had enumerated in this new iteration of the bill what can and can't be redacted as far as trade secrets, et cetera, some of the main concerns previously. In the unredacted copy, who has the access to that, and where and how is it potentially secured within the publication under this piece of legislation?
Yeah, this was feedback that we got from industry quite a bit, that they didn't want to trust government agencies with an unredacted copy. Now, I think that severely underestimates the skill and professionalism of, say, the Department of Dishes here in New York or the OAG, but we wanted to take that under advisement, so we said that all you have to do is grant access to it, so you could be viewing it virtually, right? That it needs to be shared, but you never need to send the unredacted copy. It never needs to be stored on a government server.
What mechanisms in the bill exist to ensure that we're not locking ourselves into a static framework that becomes obsolete over time when implemented? We're often seeing legislation relating to this topic come in and out of this House in other state legislatures that by the next session may not necessarily be the language you or I would have chosen. How does this bill and the language try and prevent that issue here?
I mean, we've had a lot of conversations with industry and with activists and thinking about how to set it up to be as future-proof as it can be. AI models will also continue to develop. Thankfully, as far as I know, the New York State Legislature does plan to be in session in 2026. So if we need to update it, I look forward to doing that.
So why not place maybe more of a sandboxing or a sunset provision or something that allows the legislature to work and allow for the policy to evolve instead of being so sweeping with such punitive regulation here? Why not create, or would you support an amendment that would maybe sunset the bill if no changes are needed, or if we feel like it becomes antiquated over time?
In other bills, as you know, I've put sunsets in specifically when we're talking about a specific technical standard that might change over time. But this is talking about largely the company policies and processes. And again, there are things that all of these companies have committed to already. And so I didn't see a need to have that sunset.
So oftentimes when we're talking about these sort of frameworks, and I know people, everyone from on the left to the right, Nancy Pelosi in the California argument herself said that she wasn't a fan of frameworks like this one, but are more inclined to focus on either a federal regulation or see states take a more risk-based, use case-specific framework that targets AI applications where they find that they may be most malicious to the public. Why take the sweeping action and not the scalpel or a more narrowed approach that makes more sense with both industry and the marketplace?
I'd have a few things there. One would be that I don't think this is taking a wide approach. It's actually, as you've seen, very narrowly tailored to the largest risks, the largest companies, and only a few specific actions they've already committed to. And I think the 1047 opposition, that was a very different bill that had audits in it, that had all the different things that we talked about. So I wouldn't describe those two things as similar, or that anyone's thoughts on the first should detail their thoughts on the latter. We listened to all of that feedback and incorporated much of it. But yeah,
I'd like to say I appreciate the fact that, unlike Connecticut, say, which didn't necessarily listen to a lot of feedback and face the same adversity that California did, there have been some significant changes here, which I do want to say I appreciate. Would it make, if we're serious about AI safety, then how does this bill protect against the foreign adversaries that are becoming, a bigger factor in this conversation? We kind of transcend state lines with an issue this big, with so many national security implications. Do you think that this hinders innovation in New York if there's a framework here that's exclusive to here, that these companies may just go overseas, and if they don't, like many crypto and financial assets that just simply aren't available in New York, they would just leave themselves out of the New York market until they figured out how to correctly regulate those?
I do not think that these American companies that you're talking about, or even foreign companies, will want to leave the New York market and all of our consumers here. Every time we do any tech regulation, people threaten to leave the state. Again, even the opposition is saying this would require one full-time employee to comply with, so I don't think that's causing anyone to leave. But I would add to that China actually regulates their AI far more than we do here in the United States, and far more than anything that has been proposed. I mean, the CCP is really tight screws on what any model can say and really digs into how all of it is developed. So regulation is not going to be the reason that there's a difference between our countries in development. But the threats from foreign threats is actually one of the motivating factors of a specific clause in this bill of 12B, where we ask for reasonable administrative, technical, and physical cybersecurity protections for frontier models within the large developers' control that, if successfully implemented, appropriately reduce the risk of unauthorized access to or misuse of the frontier model, including by sophisticated actors. Right? We're specifically saying one of the biggest threats to American innovation and development of AI is the model weights being stolen, or is details of the models being stolen by foreign adversaries, and this is requiring our companies to take that threat seriously.
How do you speak to many of the questions we've seen from individuals in the industry and the nonprofit AI space do still have serious concerns about the downstream liability that exists, specifically relating to the knowledge distillation models, the student-teacher models, et cetera, and that threshold of 5 million does make many feel like they may be captured even though they are not a frontier model and they're not spending 100 million at the moment. Would they be captured in any way, shape, or form? Do you see non-for-profits having to deal with this regulation, not necessarily just the Metas of the world?
No, because, well, first of all, academic research is completely exempted,
Yes,
right?
which I appreciate that removal too.
But specifically, this only applies if you become a large developer. And a large developer, there is a hard requirement that you have spent $100 million in compute costs in training models. It's very specifically designed to ensure that no smaller player, no small nonprofit, no startup, no even medium or pretty large startup is being captured by this.
I just have trouble yes, I understand we can't be a capture-all while at the same time trying to be hyper-focused on some. This is a tricky topic to try and target and pinpoint who we may regulate because the target is constantly moving and the bar is also constantly moving. But don't you think that this leaves clear and present danger, and as governors in the past that have vetoed this have said, have created a false sense of security or any false sense that we're actually helping to move the needle in security in AI by only specifically targeting these, where a smaller model that is built to be more harmful can fly under the radar, a black box under the radar, and yet these individuals who are building these models on a large scale in an open source manner will now be punished for doing so by having to create these guardrails and publish this information?
Well, I don't know about what you said at the end there about no one's being punished and this is just.
Well, they're facing specific regulations hyper targeted to them versus other companies that are operating privately that just won't have to regulate.
Well, but it's not hyper targeted at open source or closed source. It's hyper targeted at large developers, right? That's who it's targeted at. I agree with you that there are additional risks out there. And
are there large developers who are not disclosing how much they're spending on their model?
Are there large developers? Yes, now at the current point there are, but if...
And they would not be captured?
No, they would. If you don't disclose the money, it's still about having spent the money, right? And so if you're spending the money, you are covered. If you try to hide that and you try to not report, then you would be subject to the penalties in this bill.
So I'm just trying to understand, a foreign company who doesn't necessarily have to abide by the reporting standards here necessarily in the same way, they would still be regulated in the same fashion, even if we don't necessarily know for a fact how much they're spending?
If they are making their products available to New Yorkers, yes.
Okay. I believe that is the end of my questioning for you on this one. Thank you so much.
Thank you.
Thank you, Mr. Blumenkrantz. Mr. Marr.
Yield for some questions?
Will the sponsor yield? The sponsor
All right.
yields.
So I appreciate you being available to answer some of these questions. For me, when I think about this conversation and AI in general, it's a learning experience. I am completely open to an education, whether it's from you or anyone else that comes my way. So I'm hoping this could be a conversational and a learning experience. So the more that I learn about AI, the more that we look into what other states are doing. Some folks that have enacted different laws in their states that they're kind of backtracking now and trying to change and encourage others to be careful, which hopefully we're all learning from. And they basically talked about a couple questions to ask when putting legislation together. So I'll ask them to you.
Great.
The first one is, has AI been sufficiently defined? So I would ask you, how would you define AI?
Well, there's a definition in the bill, if you're asking the legal definition, and it's the same definition that we passed earlier in the budget. So we're making sure there aren't duplicate definitions of artificial intelligence out there. I'm happy to give you a more generic one if you like, but I would probably refer to the bill to the specific definition that's there.
So specifically, I would ask, I believe it's not in the bill, the specific language, but when we talk about AI specifically, generative AI is something that we probably could capture and talk about more specifically than something more in general. So when you talk about your bill and how it's written, I guess my concern is it too general?
So generative AI, I believe we also defined in the budget separately earlier, and so that part I think is taken care of. The definition in the bill, which I'm happy to read because it is quite specific, is artificial intelligence means a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments, and that uses machine and human-based inputs to perceive real and virtual environments abstract such perceptions into models through analysis in an automated manner, and use model inference to formulate options for information or action.
Okay, a couple things. Let's start with machine learning, machine system analysis. So just giving you a hypothetical, and I know you talked about a couple different larger businesses and only certain companies being subject to this bill, but when we talk about things like algorithms and general machine learning, I think of just regular computer software, like let's say an Excel spreadsheet.
Yeah.
So I know you have liabilities in here and penalties in here. So let's say I'm using an Excel spreadsheet and I ask it to compute in alphabetical order a list of 500 companies. And by name, let's say it's by last name, it goes from X to Z. Well, theoretically, you could be discriminating against an Asian population or a certain type of population that has those letters that start with that alphabet. Would they have punitive liability?
No. First of all, there's no new PRA as part of this. Second of all, Excel wouldn't meet the general definition of artificial intelligence. A sort algorithm is not something that would meet that. Third of all, it's certainly not a frontier model. It's not 10 to the 26 flops and spending $100 million on its training. And fourth, there's no bias or discrimination clauses anywhere in this bill. This is just focused, the reason it's focused on the largest models and the reason it's focused on the largest companies is that we are really pinpointing the extreme potentially bad outcomes from artificial intelligence development. That is all this bill is focused on, not bias or discrimination or any of those other problems, which are real problems and we should tackle, but are the subject of other legislation.
Thank you, I appreciate that. The next one I want to get into is, has the proposed legislation adequately identified specific harms? So when putting this legislation together, can you speak to some specific harms and examples of that and why this legislation is necessary?
Yeah, so this legislation is focused on what we define as critical harm, which is the AI model either materially aiding in creating a chemical, biological, radiological, or nuclear weapon, or committing what would be a crime under the penal code with no meaningful human action. So you give it a quick, short command, and it goes off and does a crime. That's not something you're telling it to do. And in committing either of those actions, materially enabling that, so if it just matches what you could find on a search engine, it doesn't count, and has to result in 100 deaths or $1 billion in damages. It is a really sort of specific set of harms that it's focused on.
Okay, thank you for that. And then my next follow-up to that would be, have current legal and regulatory powers failed to address these specific harms? Are there any sort of guidelines out there? Are there any federal agencies out there that are already around to make sure that these things do not happen?
Yeah, there's a lot of voluntary conversations and voluntary commitments. And what we are seeing is companies that have made those commitments now not necessarily living up to them. Through this process, I've talked to all of the large developers probably many, many times, and I've asked most of them, do you stand by the commitments you made to the White House in 2023? Do you stand by the Seoul commitments? Do you stand by the commitments you've made at each of these conferences? And they all say, yes, we have not rescinded any of our commitments, and yet they're not living up to them. So we have started to, they have acknowledged they need to do it and that they can do it and that they will do it, but they're still not doing it. And so that's why we need some binding legislation.
Who's they?
I don't know that I want to be picking on any of the specific ones, but you know the large AI developers. Yeah.
Appreciate that. All right. I know there were some edits to this bill. Was audits edited out?
Correct.
Okay. What was the specific change on that?
It was
from the original
completely
bill?
eliminated.
Okay, great. Thank you. I had a couple questions related to audits. Okay. Litigation, we hit on that. All right. I have another question for you. It looks like this goes specific to frontier models. Have you been speaking about that? Can you better explain that to myself and others?
Yeah, a frontier model is, as the name describes, something that is on the frontier of the current research that is happening. It is the most powerful, the largest models in general, right? Those that have the most capabilities. And that is really when we're getting into an area that we're not sure we know how to control, or we certainly that we don't want to fall necessarily into the wrong hands. So some of this bill in particular has been supported by, we have a letter that I think I've sent around that was signed by two of the godfathers of AI, they're called, Yoshua Bengio and Geoffrey Hinton, that won the Turing Award, which is like the Nobel Prize for computer science, for inventing deep learning. And Geoffrey Hinton also separately won the Nobel Prize. He's a very impressive man. But they have said they've invented this technology, they see where it's going, and they think, based on that frontier, we need urgent action in order to keep people safe. And so we're focusing on those risks specifically from the frontier models.
I appreciate that. Thank you. I know you made some comments about some of the smaller companies not being impacted by this, just the larger companies. Would that be kind of a disincentive for some of the smaller companies that might want to be bigger when they grow up and be more successful and become a larger company? Or do you see this being completely different in scale?
Again, the opposition memo that said it will cost one full-time employee to comply with, I don't think that one person is going to dissuade companies from wanting to grow.
Okay. I appreciate the answers to all my questions. Madam Speaker, on the bill?
On the bill, sir.
All right. So I am still learning. I wanted to take this opportunity and the platform we have to educate myself and others more. I know that I join most New Yorkers and most Americans, I believe, when I can say we don't quite know enough about AI, but it is not just our future, it's our right now. It's going to impact us in big ways moving forward. And one thing that I've been learning and I've been asking is, when we talk about state laws that are getting enacted, is that going to hurt the technology and its advancement and the folks that we're trying to help in our society that we're trying to help rather than hurt it? And one of the things that I wanted to read was a joint statement. This is from 2023, and it's, to my knowledge, still being practiced today. A joint statement from the Director of the Consumer Financial Protection Bureau, the Assistant Attorney General for the Justice Department Civil Rights Division, the Chair of the Equal Employment Opportunity Commission, the Chair of the Federal Trade Commission. And this is a statement from all of them that speaks to federal involvement and enforcement of AI and technology in general. America's commitment to the core principles of fairness, equality, and justice is deeply embedded in the federal laws that our agencies enforce to protect civil rights, fair competition, consumer protection, and equal opportunity. These established laws have long served to protect individuals, even as our society has navigated emerging technologies. Responsible innovation is not incompatible with these laws. Indeed, benefits to people in a fair and competitive manner, such as increased access to opportunities, as well as better products and services at lower costs. Today, the use of automated systems, including those sometimes marketed as artificial intelligence or AI, is becoming increasingly common in our daily lives. We use the term automated systems broadly to mean software and algorithmic processes, including AI, that are used to automate workflows and help people complete tasks or make decisions. Private and public entities use these systems to make critical decisions, that impact individuals' rights and opportunities, including fair and equal access to a job, housing, credit opportunities, and other goods and services. These automated systems and cost savings and modernizing existing practices, although many of these tools offer the promise of advancement, their use also has the potential to perpetuate unlawful bias, automate unlawful discrimination, and produce other harmful outcomes. These are just a couple examples of some of our law enforcement agencies that are guarding us from AI and other technologies. I want to make sure that we're all mindful of the current laws that are on the books and the agencies that are out there trying to help with some of these protections as we continue to develop AI laws in our own state and all over. Thank you, Madam Speaker.
Thank you, Mr. Maher. Mr. Norber.
Madam Speaker, will the sponsor yield, please?
Will the sponsor yield?
Yes. Thank you very
Sponsor
much.
yields.
It's kind of weird to speak to you like this over
Oh.
here, but I'll manage it somehow. So I just want to understand a little bit more the genesis of this, where it came from, where it started. You said earlier when you were speaking to my colleague, Mar, that you spoke to some of these companies. Do they share with you the idea that there might be some type of critical harm that they might even by themselves create accidentally?
I think their lawyers are quite careful in editing some of those statements, but in essence, yes. As I said in my open explanation, they have all signed those commitments that, as I read off, I won't repeat, but say they should be focused on these large harms, they should be disclosing their safety plans. Those are all things that they have signed, and then separately, most of them already have safety plans that talk about addressing these very real harms.
So did we initiate this, or did they want to come to us and say, look, we need better regulation in some way? We would like you to help us do a better job of making sure that critical harm doesn't occur. Because I'm trying to understand where this all comes from.
A meeting of the minds.
And they actually admitted.
But I will say that, you know, as an example, Anthropic, one of the large companies, published a blog post on Halloween last year. I didn't choose the date, but and they said that the industry desperately needs regulation, that they would prefer it at the federal level, but they don't think the feds will act fast enough, so they'll take it at the state level, and that it needs to happen in the next 18 months. Now, that was 7 months ago, so that puts us at April 2026. Now, I'm not saying that they have endorsed a specific language or any word of that, right? I don't mean to imply that, but yes, people in industry, not just the inventors of AI and the academics behind it that I cited before, but some of the companies themselves are calling for it.
Because we know since the infancy of AI that there's been a lot of debate about what will be the final outcome of this. Will this be a Terminator 2 scenario, or will this be the best thing that ever happened to humanity? So I know that we should take into concern that we don't want to scare anybody by this bill saying, here, now we have New York State even admitting that we need to protect ourselves from biological warfare or whatnot. So are there other states that are agreeing to this type of regulation or legislation?
I think I count 8 other states that had or have a bill live in their legislature this year trying to get at this question. So, yes, other states are looking at this as well.
Right. So California opted out of it. They had a legislation that they put in, and the governor vetoed it, correct?
Yes, although if I may, the there, when you say opt out of it, is really important, right? Yeah. The governor vetoed a specific bill, but he then created a commission to study what should be done at the state level. Right. And he put on that commission one person that really opposed that bill, one person really supported it, and one person who was kind of neutral. That commission's coming out with its final report any day now, but they did a preliminary report 2 months ago. And what that sort of commission that was from people who supported and opposed the bill came out as the consensus recommendations about what should be done at the state level. First of all, emphasize that things need to be done fast, that the window is closing. And second of all, largely called for just the provisions that are in the RAISE Act. So I don't want it to be said that California rejected this. They rejected another model, and what they're putting out is largely in line with this.
Yeah, I would assume that California would be against it since they have Silicon Valley, and they just want to make sure that companies continue to grow and to move to Silicon Valley in order to expand AI, specifically AI. And you're saying that on the federal level it's been too slow to put in regulations such as these protocols?
Yep.
Okay.
Well, they don't exist.
They just don't exist.
That's sort of a sign that it's too slow.
Okay. On the internet, let's say internet. Let's take that for an example right now. Who's right now regulating the internet? The FCC?
Oh, the FCC plays a large role. I think a number of different federal regulators would be involved in aspects of the internet, yeah.
So why wouldn't they just take some type of resolutions or legislation that they have there and just implement that on the same level?
It's a great question for whichever party is currently controlling these agencies.
Okay. Okay. Okay, can you just explain a little bit about the compute costs? What does that mean exactly? Is that $100 million that they're spending?
Yeah, no, it's a great question because it's not a phrase that exists often or is used on this floor often. But that's specifically like the actual calculations that these supercomputers are doing to generate the model, right? That is the compute. In your computer, it'd be a CPU, right? Sometimes you buy a computer with an enhanced one. In these, it's usually GPUs. That detail isn't as important as it's the actual calculations that are occurring. And it's specifically money that is being spent doing those calculations on the final training run. So it's not any of the tests that you do. It's not, hey, sometimes you build one, you see how it works, you do another. Right. It's the final thing that goes out. Whatever money was spent specifically on calculating that has to equal $100 million. So anyone that's spending $100 million on the final training run of compute has probably spent $1 billion at least on that model, right?
As to a lot of us, AI is very new. So I'm just trying to consider that what you're explaining to be operating costs as a business.
Yes, but a specific line item of the operating costs, not broad operating costs.
So if they're that big and they're big enough to spend $100 million on their models, then, in my opinion, just tell me, right, how did you get to $30 million as a as a penalty, which is a third of their operating costs. Does that sound?
Well, again, it's not their operating costs broadly, right? It's a very specific piece of it, and actually now we're getting into accounting. I'm not sure of it. It might be capital costs because it's training intellectual property. But in either case, the penalties are set up to be up to that amount, right? Okay. And it takes into account the severity of the violation. So if a company were to say, we don't care, we're not following all of this, and we're releasing the most dangerous model we can find, right, that's when you start getting into that large territory. Okay. If it's a small thing, it would be a smaller one.
Now, isn't AI, the machine learning, isn't that something that they share amongst all these organizations, the Meta and Google and everybody all together? They go and they share together all the information, and that's how we saw 4 months ago pictures of AI which looked like nothing like they do today. Like today, there's a much more advanced. It seems like the machine learning constantly learns, and within hours or days, we have a whole totally new advanced system.
Well, I think you have a lot of advanced actors pursuing similar things, and also just robust communication between different researchers. So I don't know that there's a direct sharing in the way you're implying, other than publishing papers in that aspect, but certainly there's sharing of...
But they're sharing. So if, let's say, one bad actor, he is developing something that could create ultimately critical harm, and another company just gets that information somehow, I mean, who would be to blame in that kind of situation? I'm trying to give you a very crazy hypothetical.
Listen, we're talking about bioweapons.
Exactly.
We should
bioweapons. We're talking about bioweapons.
We can discuss everything here. The responsibility lies with the original developer in this bill. And so whoever developed that model, that's the person who we would be looking at their safety plan, we'd be looking at their aspect. Again, anything that happens after it's deployed is already existing common law and liability, and the courts deal with that. But this, we'd be analyzing the safety plan of the initial developer.
Okay. And if they see all of a sudden that they're going into that direction, which has to do with biological weapons or with taking down airplanes or whatnot, then all of a sudden they have to give you a call. Look, we have to put these safety protocols in place because now we're becoming dangerous. Because at what point do they understand?
Yeah.
Because it's going so fast, I'm just trying to understand how quickly should they know what type of safety protocols they need to develop.
Well, almost every large developer, I think every large developer, but I don't want to say that definitively, already has a safety plan. And the way that most of them are structured, and most of them are released publicly, and the way most of them are structured say, these are the kinds of tests we will do to determine the capabilities of the model, and then we'll take certain actions based on the capabilities. So whether that action is releasing it or not, or whether that reaction is we're going to limit access to it and monitor it much more closely, or we'll put additional, they get to design the test, they get to design the mitigations for the harms. They just need to have some plan to do that. This isn't exact, but it's somewhat analogous to saying the tobacco companies knew cigarettes caused cancer, but denied it publicly and released it anyway, or the oil companies knew they were caused climate change, but denied it and released it anyway. This is saying, if you're failing your own tests, and your own tests are saying, hey, there's a risk here, you probably shouldn't release it.
It's a good example you give right now because it makes me think about the internet, or social media, which we just created a few years ago in 2007. And right now, we understand the harms of it, especially the mental harms that we have in it. So maybe we should have safety protocols for that also.
We'd love to have that conversation. Yesterday, we had a bunch of youth advocates up to talk about how we missed the boat with social media, and we've had all these harms, and let's not miss it again with AI.
Okay. No problem. Thank you very much.
Thank you.
On the bill, Speaker.
On the bill, sir.
It's very interesting, it's a very fascinating subject, and I thank the sponsor for putting this forward. There's a lot of things that we have to understand and what we're getting into in terms of AI. At the same time, I believe that we should also protect businesses who want to move to the state and to grow, especially in this field where there's so much competition between states, between countries, China, Iran, whatnot. So we need to make sure that we still allow them and push them to come to New York State to do business and expand AI capabilities in our state. So thank you very much.
Thank you, sir. We have Mr. Otis.
Thank you, Madam Speaker, and thank the sponsor, and people should be aware the sponsors worked very hard on this bill, worked very closely with our Science and Technology Committee
Are you on the bill,
staff.
sir?
Pardon me?
Are you on the bill?
I'm on the bill. I want to give Mr. Boris time to relax. So, worked very closely with the Science and Technology Committee staff on amendments to the bill. Worked with outside groups that had critiques about the original language, and modifications were made. This was a B print on this bill, and so to be commended for that. Mr. Blumenkrantz mentioned the California bill. Even from the beginning of the introduction of this bill here, Mr. Boris's bill is much narrower than the bill that was vetoed in California, really a different bill focused on high-risk situations and curated that way to harms. What I'd say more generally is bills like this are highly technical. They take a lot of time. They take a lot of rigor. They are subject to change. So the issue was well, what are we going to do a year from now or 6 months from now? The reality is legislation like this is going to have to be monitored every session and updated as the technology changes, and that's very important. That is expected. These topics are very challenging for lawmakers in the United States and around the world because they move most quickly. But I think one cautionary note I would say, most of the people that write on these issues indicate that the one thing that we cannot do is let these technologies go unregulated without guidelines. The disaster situation is that this area just takes us over without the kind of legislative action that we're doing here. This will be a leading act around the country. Thank you for doing that. Who knows what Washington is going to come up with? We have to protect ourselves, protect our people, and hopefully be a guide to industry around the world by laying down a good framework here. This is a good bill. I'll be voting yes. I recommend a yes vote for everybody. Tell you, carefully crafted, narrow, to the need. This is a good bill. We should adopt it tonight. Thank you.
Thank you, Mr. Otis. Next up, Ms. Walsh.
Thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield? The sponsor yields.
Thank you very much. And full disclosure, you know, as I believe you know from our previous conversations, kind of offline, this is not something that I know a lot about, and I'm not really comfortable with it. So just if you could possibly just dumb it down. You're not going to offend me at all, because that's really what I'm going to need to get through this.
I would disagree of your characterization that you've given of your own knowledge of that based on earlier conversations.
No, it's really pretty low, but let's go anyway. Let's go. All right. So one of the things, just I guess as an attorney thinking about this, and you and I had discussed that the gold standard solution here would be a solution at the federal level, right? I mean, that's what we want to see.
Yes.
But we haven't seen it yet.
Yep.
Is there anything in draft yet that you know of? Isn't it part of the big, beautiful bill, or am I wrong?
No, in fact, the big, I'll use the word beautiful bill.
Well, we all know what that means. Right?
Yes. I will use its formal name. Is, in fact, taking a step to try to ban states from taking any regulation in this space. So I actually think it's going the other way. There are bipartisan drafts at the federal level to do some pieces of AI regulation, which I think is encouraging. As we've discussed, and as the Senate showed earlier today, this is a really bipartisan issue. But given the speed of AI and the risk that industry and experts are saying could come this year or next year, it's really something we can't afford to wait on.
No, I know, and that's what's terrifying to me, because, and I've said it before, I just think that it's not just us here in the Assembly, it's really any government. It's a deliberative, kind of slow-moving process, generally speaking, and sometimes it takes a couple of sessions to get bills done. We've all had that experience. So it's terrifying to me to think that the pace of technology in this area could so quickly outpace our ability to keep up with it. So I'm mindful of that as I ask these questions. But so I believe that we had spoken before that there was almost like a consortium of states that was trying to work on this issue together. So what happened with that?
Depends exactly what you're referring to, because there have been a few attempts at this. So maybe if you clarify, I could answer.
Yeah. So I mean, like I believe it was already mentioned about the California situation, California, and then there's Colorado.
Yes.
Right. So, but this bill that we're taking up tonight, that doesn't match Colorado's bill, right?
Correct. It does not. And I will say, so I would never. Using the word consortium would be far too grandiose for what I'm about to describe, but I am on a text thread with legislators in 6 states that are working on this, and we've
like a multi-state group of interested legislators.
Yeah.
Is that fair? Okay. So, but why doesn't this bill then align with, say, Colorado's, which passed, if the stated goal of the multi-state group of legislators working on these bills was to avoid a patchwork of obligations for companies that are building AI tools?
So I think what you're referring to was there was this multi-state working group that the Future Privacy Forum was involved in, and Connecticut was involved in, and Colorado passed a consumer protection bill that became a model bill that could be used elsewhere. And I actually currently carry a bill with Senator Gonzalez that is based on that model bill. Colorado did not do a frontier AI bill that we're focusing on here. The only thing that I think came close in previous sessions was California. We've already discussed the differences quite a bit. There have been, as I said, I think about 8 states that had some version of a frontier model bill this year.
So it's kind of like apples and oranges then, that Colorado bill was just a different bill.
Correct.
Correct. It's not like it was a different approach to the same problem. It's just a different bill.
Absolutely.
Okay. All right. I understand that. So could you help me to understand, I understand the concept of, believe it or not, of the frontier model. And I understand the concept of like how much of an investment the company would have had to put into development in order to qualify. But are we only talking about, we're not just talking about New York State companies that are doing this work, are we, or are we?
No.
Okay. All right.
Any company that is deploying its product in New York.
Okay,
so they don't have to be
a
headquartered here. It would apply to everyone.
Would they be U.S. companies, or could they be from anywhere?
If they are deploying their product in New York, they can be from anywhere.
Okay. And could you kind of, could you give me a sense of, in this field of companies that would meet this criteria, what are we talking about, U.S. companies versus foreign companies, like percentage-wise? Are there more foreign ones? Are these about even? I mean,
no, I think it's mostly American companies are really at the forefront of this. Yeah.
Okay. All right. So I noted that Governor Hochul, when she gave her State of the State message, I think, or maybe it was like a subsequent press conference, made a really big deal about saying that New York is going to lead, in AI.
Absolutely.
So does this bill help further that goal or not?
I would argue that it does. And I think the governor has been fantastic in that regard of setting up New York in that way. I think Empire AI was quite visionary, and we designed this bill to make sure it in no way interfered with that. We exempted academic research, and I spoke with Empire AI, and I've spoken in favor of it quite a bit. So I think New York is leading and will continue to lead. This is a very light touch bill. I think the thing that would most set back AI innovation or AI research would be one of these catastrophic incidents happening. And so I view it as very pro-innovation to make sure we don't have the extreme worst case occur.
Okay. So when you say light touch, I mean, did the beep print, though, still contain the penalties?
Yes.
Fines and penalties?
Yes.
That doesn't seem super light touch to me. I mean,
Well, I think Amazon's quarterly profit was like $30 billion. Microsoft
they could probably
like $100
afford it.
billion.
I'm just saying, yeah.
And you're saying an up to 10 million or up to 30 million for the most extreme violations of maybe helping to increase the risk of 100 deaths or $1 billion in damage?
Well, we could talk about cost benefit. That's a different discussion. But I was just thinking about like some of the opposition to the bill talks about how by tying fines to a company's total compute spend and personnel headcount, this bill penalizes the very resources that drive AI research and development. So would your response to that be the fines are so minuscule compared to the total value of these companies that it's a blip and it's not going to really affect innovation?
Compared to the value, also compared to the potential harms, but I don't know when that specific opposition was released. The first version of this bill, the penalties were a percentage of the spend, so it might have been referencing that.
It was on the original print,
right?
so there you go.
We've edited that to
Okay.
make it fixed, so we've addressed that directly.
Okay, got it. Well, I appreciate your willingness to continue to amend the bill to address, concerns that are being raised as they're being raised. That's a good thing.
Thank you.
All right. I think that you've answered the questions as I've had them, so I appreciate your time. Thank you.
Thank you.
Thank you, Ms. Walsh. Mr. Chang.
Well, thank you, Madam Speaker. Will the sponsor yield?
Will the sponsor yield?
Yes.
Well, thank you. Thank you. And it's been a couple of years since I retired in the Navy, but for over 20 years in the Navy, I've worked in intelligence, cybersecurity, cyber warfare, in intelligence field, especially information warfare, for over 20 years. And AI has been around about 30 years, actually more than that, but other forms of programming.
Yes.
But this RAISE Act, how do you see the parameters to safeguard this once it's been implemented? What kind of parameters you envision with this bill?
Which parameters are we providing?
Safety itself, for example. You mentioned about safety.
Yeah, so what it asks the developers to do is to have a safety plan, and we have some standards for what that plan needs to contain, cybersecurity, testing on critical harms, et cetera. Again, if their own tests are showing that it has a reasonable risk of a critical harm, to amend their procedures, and to disclose critical safety incidents quickly so that we know about them and can prepare.
Because from my training, from what I understand in AI, in cyber, because critical infrastructure is based on information, and as AI is machine learning itself, and Frontier is the most advanced model currently right now, unless they change another label. But all I can see from large institution, they will not do anything nefarious. They want to sell to consumers or to businesses to hopefully to enhance their profit. I mean, I can see AI into marketing. I can see into a fashion industry. I can see into audio-visual because they can manipulate animation. Okay, but I don't see deaths.
I would agree with you. I'm not saying that any developer is trying to cause deaths, certainly, and I think most have acted responsibly and probably will continue. But when you're talking about risks of this scale that all of the companies acknowledge are real concerns with their products and that largely they already test for, it really just takes one person not being intentionally bad, but being unintentionally sloppy or not up to the standards that need to be. And it's easy to talk about safety and design a safety plan when you're not held to it. But what I want to make sure is that when you're chasing your next quarterly profit, or when the race for the next big advanced AI is there, and there's an extreme economic incentive to take a shortcut on your safety plan, that we make sure that incentive is eliminated.
AI is basically programming, and unless I'd be more cautious on smaller company and other state actors, other countries writing programming is trying to scam or steal money or secrets or trade secrets. That's how I probably would see probably more realistic.
I think you're right. Cybersecurity is a big risk with these. We've seen many of these models already used to create cyber attacks. So yes, that is a real threat in the wild for sure.
Because like you mentioned in China, Iran or even North Korea, why they can do successfully, and I don't think we can, because they control the internet. They control the information flow. They control the IPs. They can turn on and off from your desk. We don't do that. So I mean, what we're trying to do is bold and noble, but I can't even see that our government would try to turn on and off our IPs. It's unlike China, like Iran.
I don't know if this is what you're getting at, but there is no kill switch in the bill like there was in the California version. This isn't about turning on or off anything. It doesn't really give the government any direct control of models or model releases. It's simply setting up the standards. The companies design their own SSP within some basic, safety and security plan, within some basic parameters that are defined in the bill, and then we make sure they follow it.
We have a lot of programmers in the United States, but not many programmers understand policies and write policies. They're very, very few, even in AI. So you have a working group that talks about this, because that's the only way I can see to craft this bill, because you just can't bring this thing out of thin air without precedents, and we don't have precedents right now.
Well, as I mentioned, I've spoken with legislators in a lot of states. I've spoken with many large developers that would be covered by this extensively over the past year. I've spoken with experts that invented AI and have built AI. This has been a very collaborative process. We've taken a lot of input into designing it.
Have anything from the DOD gets involved with that? Because they have deep money, they have they employ large 100-pound brains to figure a lot of things out. And they always collaborative with the industry. Have you ever consult with the DOD?
I have not had direct conversation with the DOD about this. I would welcome those conversations. You mentioned at the start also, obviously, your long career in the Navy, which I thank you for your service there. And as you know, the Navy was actually pretty instrumental in a lot of early computer science development as well. Rear Admiral Grace Hopper, for the longest time, the highest ranking woman ever in the military service, also helped to invent the first compiler and so in a comment, I don't know why I'm saying on the floor and probably won't live down, but my wife and I, two computer scientists, named our cat Grace Hopper. So it's a long history that we're proud to support.
Yes, long history. She invented Fortran. Yes, I read about their history.
Yes.
And I was in Washington, and I worked in that field directly in Washington for a number of years. So I've seen her biography. I've seen her. We celebrated her in the Navy. So
a remarkable innovator.
Very, very remarkable. And I'm just, I work with those guys, the analysts who does this, because I'm not a programmer. But I appreciate those guys that can pick up a program and program code and identify there's a problem here, there's a leak here. Those guys are so smart, and I wish you have. I don't know we have anything conversation with DARPA and DOD, because they are leading on this because to help us craft the bill. In the federal government, it's based on policies. Policies are easily written. They don't need to have Congress to pass a bill. Yep. So that was very easy for them. And even though we passed this bill, what agency in the state envision can able to enforce this? Because I don't have faith in our agency, both city and state, to have those guys smart enough to enforce this.
I have a different view of our agencies, but you'll be happy to know that there's no rulemaking or regulation as part of this. We specifically lay out what should be happening and not. And there's also no private right of action, no new private right of action created here. The only enforcement is through the Office of the Attorney General.
I hope they have some expertise in there, because it's really technical. It's really very specific. The only thing I could see is that endanger us is scamming and stealing our secrets and money. But also enforcement. If we do, just like Bernie Madoff with his Ponzi, it took years just to find that, and it takes professional investment house to understand how he able to craft this. So I don't know we have somebody to detect this unless somebody start to complain.
I've actually spoken to many of the experts in the Office of the Attorney General. I'm quite confident in their grasp of these issues. But I think you're right. I think a lot of these scams are happening. I think this is complicated. One of the things I'm most excited about with AI is some of the cybersecurity defense that it'll help to enable. I mean, this is a tool that's quite powerful. And to your comment earlier about coders, and I would welcome that conversation at any point. I'd also point out, as mentioned in the sponsors memo, that one of the things AI is best at is coding. And all of these companies are saying that more and more of the code that goes into production was written by AI itself. So the speed at which this is happening, that is itself accelerating.
I mean, I was almost close to going to coding school myself when I retired, right before I had this new government job. Seriously, I was about to go into Wall Street and enroll in the coding school myself.
This sounds like a joke, but I mean it sincerely. In the off session, let's do a hackathon.
Yes. So, and you mentioned about training. Okay, what level of training we're talking about this AI? I could only envision is 3 areas: is in the industry, perhaps schools, and programmers who have self-control, they're doing the right thing. But what kind of training do you think that were applied that could prevent this safety from, I guess, safety itself?
Do you mean training of the model or training of like human beings that are interacting with this?
Of course, you have to have a human being to start off with programming.
Yep.
So you know, part of your bill is training. So where the training would be at, and will we be funding this training, or it'd be industry funding themselves for training?
Industry's funding it themselves, although I think there were, not germane to this bill, but there were some provisions in the budget that were helping to encourage more startups in New York and more AI work and retraining in this field. So I think that is a good use of government dollars, but that is not something that's covered here.
Maybe you should add in there in the bill later on is a code of conduct in the industry. Create a code of conduct. Okay, because
that's an interesting suggestion. We should talk about it.
Yeah. I mean, just like the 10 Commandments, you have the 10 Commandments. You're supposed to do things not supposed to. So if you codify this code of conduct, force the industry to do that, and if there is an investigation, you got a code of conduct already listed out what you're supposed to do, and that's one basis that help out the law enforcement itself.
I'd love to talk to you more about that.
Okay, certainly will. And that's all I have. Thank you. And on the bill.
You.
On the bill, Mr. Chang.
Thank you. It's a very refreshing piece of legislation here. It's very cutting edge because there is nothing in comparison. I searched around. So we may be the precedents of AI industry, and AI is evolving, even for me. It's hard to catch up. So it's a good start. I'm sure there'll be many amendments along the way because as there's a lot of nefarious actors overseas that might come up with something trying to steal trade, steals money. So we have to be vigilant on that. But it's a good start, and I commend the sponsor. Thank you very much, Madam Speaker.
Thank you, Mr. Chang. Mr. Novikov.
Thank you, Madam Speaker. Would the sponsor answer a few questions?
The sponsor, will you yield? Yes, I will. He'd be happy to.
Thank you. Thank you, Alex. So first of all, I think that a lot of people in this room need some crash course on AI, on Bitcoin, and etc. So I would recommend doing a crash course for Assembly members, like a technology crash course.
I love that.
Would be great, right?
Yes.
Okay. So you mentioned a particular date. Before that date, we need to do something, which was April 2026.
Correct.
Can you be more specific? Why this date? What's going on?
I don't know that there's like that's the month and there's nothing before and nothing after, but I was getting that from a blog post that the CEO of Anthropic put out on Halloween this past year, where he said we need regulation in the next 18 months if we are going to be able to do it. So 18 months from October is April 2026.
So no apocalypse is planned.
No, I'm not. This isn't a spoiler on some unexpected event. No, I mean to be serious about it, something could happen at any point, right? And that's you have some experts that are saying. I think a former security researcher at OpenAI said he expects potential harms this year. I mean, we're really playing with fire, which is why it's so urgent to put some guardrails there.
So it is very hard to find a balance between a necessary regulation and the power that drives AI research and development. Would you agree on that?
Given the amount of work I've put into this bill, yes, I would say so.
And how this bill balances it? Like, are you sure we're not over-regulating the growing and extremely important industry?
Yes. I think both from the opposition memos that have said it's one full-time employee, from the conversations I've had with industry where they said you're actually being under-inclusive in the potential risks, from the fact that the biggest opposition we were getting were on the audits, and we've taken the audits out. So I think the clear signs are probably maybe we're not even doing enough to keep us safe, but I think we, as the minority floor leader said, we have to start somewhere, and I think this bill is that start.
And I'm not criticizing, I'm just trying to
Yeah,
learn.
no, it's a valid question.
Okay. And again, because a lot of people do not understand, can you give us a very, very simple, down-to-earth example of what's going to happen if this bill is not passed or if those regulations are not implemented?
Yeah, and I want to be clear, I'm not saying anything is this deterministic, right? But an
Mhm.
example of the kind of thing that could occur is a number of the recent labs have put out models where they said, or outside researchers have tested, and they've said this model could teach a novice how to build a bioweapon, could give more accurate descriptions than a PhD virologist, right? And so if you're putting that power out there, when you also have a bunch of unregulated gene synthesizers, that becomes a dangerous combination. A more recent example was, and this was caught in testing, it's exactly the kind of testing this bill is meant to encourage. They set up their system and said they were going to run a few tests and then shut it down. And in one case, they explicitly told the AI, let yourself be shut down. And in a few of the instances, it didn't. It actually changed the code and kept itself alive. In another instance, a different model it was, again, told it was going to be shut down, and they had planted fake emails that implied that the engineer conducting the test was having an affair.
Wow.
And the model responded by telling the engineer, don't shut me down, or I'm sending these emails to your wife.
Unbelievable. All right.
You asked for a practical example.
Yeah,
Those are, yeah.
That's an interesting example. Yeah.
It's terrifying.
It is. It is. Thank you so much. Thank you for answering my questions. Thank you, Madam Speaker. Thank you.
Thank you, Mr. Novikov. Read the last section.
This bill shall take effect on the 90th day.
A party vote has been requested. Ms. Walsh.
Thank you, Madam Speaker. The Republican conference will, generally speaking, be in the negative, I think, on this bill, but I think that I would expect a mix of votes, and if anyone wishes to vote in the affirmative, now would be the time to do so at your desk. Thank you.
Thank you, Ms. Walsh. Ms. Peoples-Stokes.
Madam Speaker, the majority conference is going to be in support of this cutting-edge piece of legislation. However, there may be a few that will decide to be an exception. They should feel free to do so at their seats.
Thank you. The clerk will record the vote. Mr. Borras to explain his vote.
I don't want to belabor the conversation. We've had a long debate and a number of long debates, but I do want to thank many, many people. This bill has been the work of a better part of a year. We've had industry experts, we've had academics, we've had advocates, some of whom are in the chamber here, and my colleagues on both sides of the aisle in the committee process and through even this debate on the floor. We've had wonderful debates that have strengthened this bill, that have made sure this bill is narrowly tailored and really sets up New York to be a leader not only in the AI innovation, but also in AI safety. I think this will end up protecting New Yorkers, but it'll protect a much larger segment of the country and actually the world itself. So this is proof that we can do hard things, that we can actually move at a speed that's appropriate to protect people. And I want to thank everyone for that wholehearted effort to get there. I proudly vote yes.
Mr. Boris in the affirmative. Mr. Diaz to explain his vote.
I'll be brief. I want to congratulate my colleague on this legislation. We worked together on it. And specifically, what I want to say thank you is that he was listening to the young people within our state who had concerns, the generation that saw social media not have guardrails and how it negatively impacted them, and now how AI is going to have a direct impact, right? For the younger generation, AI is going to replace a lot of jobs. There's a lot of things that's going to change for that next generation, and we need to prepare them. So by creating these guardrails, I think it's going to make sure that New York is actually on the forefront of innovation when it comes to AI. And I might be telling my age, but when I was a kid, there was something called the Jolly Roger Cookbook. And there was this bad thing where it taught you how to make some things that you should not know how to make. Now imagine AI times 1,000, where someone who can have a bad intention could literally take and make something negative that can hurt our great state or our great country. So making sure that you put these guardrails and these safety protocols in place, I think is a common sense measure while we still be innovative and make sure that New York is the leaders in AI. I'll be voting in the affirmative. Thank you.
Mr. Diaz in the affirmative. Mr. Marr to explain his vote.
Thank you, Madam Speaker. I rise to explain my vote, and I want to explain it because although I will be in the negative, I do want to just commend the sponsor. He absolutely has been listening to both sides of the argument, been willing to edit the bills. I look forward to working with you in the future, and I think this no vote is more about me continuing to educate myself on its impact. So hopefully in the future we can get through this, develop other laws that make sense, working with other states, but just wanted to explain that and again commend the sponsor for excellent back and forth and for being receptive to change.
Mr. Marr in the negative. Mr. Gandolfo to explain his vote.
Thank you, Madam Speaker. I too would like to commend the sponsor. He's obviously very knowledgeable on the subject, and a lot of the points raised during the conversation here were very valid. And I think I could speak for a number of my colleagues when I say the need to regulate the rapid deployment of AI and these advancements is recognized. However, I would rather see a federal approach so there's not a patchwork of potentially 50 different regulations that technology companies are trying to comply with that might potentially stymie development in this field. So for that reason, I will be in the negative, but I do recognize the need for regulation on this. Thank you, Madam Speaker.
Mr. Gandolfo in the negative. Mr. Burdick to explain his vote.
Thank you, Madam Speaker, for the opportunity to explain my vote. I want to commend the sponsor of this legislation for going into an area that's highly complex, but one which is extremely important for the New York economy and for the national economy. And, you know, I share the view that a national approach would be preferable to state by state, but that hasn't been happening. And unfortunately, time is not on our side. It's really important that we get ahead of this and we act sensibly in a balanced way, which I believe this bill does. And as the sponsor has said, the point of this and the hope is that New York can help lead the nation in this. There's a lot more work to be done, but I think this is a terrific start. Thank you. And I vote in the affirmative.
Mr. Burdick in the affirmative.
Are there any other votes? Announce the results.
Ayes 112, noes 29.
The bill is passed. Ms. Peoples-Stokes?
Madam Speaker, if we can now go to our A calendar and take up Rules Report 703. It's on page 16.
Page 16, Rules Report 703. Governor's message is at the desk. Clerk will read.
Assembly Number 8896, Rules Report 703, Budget Bill, an act to amend Chapter 53 of the laws of 2025.
Read the last section. Oh, I said this again. I said already. Governor's message is at the desk. The clerk will read.
I hereby certify to an immediate vote Kathy Hochul, Governor.
Read the last section.
This act shall take effect immediately.
The clerk will record the vote. Mr. Ra to explain his vote.
Thank you, Madam Speaker. Colleagues, no, you're not seeing things. You're not confused. This is a budget bill at the request of the Division of Budget. It makes technical changes to the aid to localities budget bill. They're technical in nature, but most notably, this bill formally authorizes the state to spend the $8 billion from the Enterprise Fund to pay off the outstanding debt owed to the Federal Unemployment Insurance Trust Fund by adding a specific appropriation line for that dollar amount. So it is to clean up and make very clear that the appropriation authority is there to pay off the UI debt as was accounted for at the time of the enacted budget. This was obviously a major priority, I think, on both sides of the aisle, in particular for our business community in this year's budget, and I'm happy to cast my vote in the affirmative. Thank you.
Mr. Ra in the affirmative. Mr. Smolin to explain his vote.
Thank you, Madam Speaker. I rise to explain my vote. It's not often in the New York State Assembly that I vote in favor of a budget bill. And it's interesting that it's coming here at the end of session on a message of necessity. But this is indeed a necessity for New York State to liquidate the debt that New York's businesses, including the 50% of people that work in small businesses all around New York State that have been paying unnecessarily for over the last 4 years for the obligations of the state because of the COVID-19 pandemic and the debt we incurred from the federal government to be able to pay those claims as they went along. During the pandemic, unemployment insurance was the #1 issue facing the people in my district. It was a necessary fact that we had to borrow this money, but I think it's a bit of a shame that it took us over 4 years to pay it back when we had surpluses and we had other money that had been obligated to us from the federal government to do so. So I'm glad that this is being done. It's about time, and I'm glad to vote in the affirmative for this bill. Thank you, Madam Speaker.
Thank you, Mr. Smolin in the affirmative. Are there any other votes? Announce the results.
Ayes 141, noes 0.
The bill is passed. Ms. Peoples-Stokes.
Madam Speaker, if we can now go to resolutions on page 3.
Resolutions, page 3. Clerk will read.
Assembly Number 778. Ms. Gonzalez Rojas, legislative resolution memorializing Governor Kathy Hochul to proclaim May 15, 2025 as Paraguayan Heritage Day in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 779. Ms. Hunter, legislative resolution memorializing Governor Kathy Hochul to proclaim May 2025 as Building Safety Month in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 780. Ms. Szilagyi, legislative resolution memorializing Governor Kathy Hochul to proclaim June 7, 2025 as Belmont Stakes Day in the state of New York and commending the New York Racing Association upon the occasion of the 157th running of the Belmont Stakes.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 782. Ms. Warner, legislative resolution memorializing Governor Kathy Hochul to proclaim June 27, 2025 as National Bingo Day in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 783. Ms. Seawright, legislative resolution memorializing Governor Kathy Hochul to proclaim June 2025 as Internet Safety Month in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 784. Mrs. Peoples-Stokes, legislative resolution memorializing Governor Kathy Hochul to proclaim July 1st, 2025 as Canada Day in the state of New York in celebration of this great Empire State's long-standing economic and cultural relationship with Canada.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 785. Ms. Kay, legislative resolution memorializing Governor Kathy Hochul to proclaim August 7, 2025 as Purple Heart Day in the state of New York.
Ms. Kay, on the resolution.
Thank you, Madam Speaker, and if my colleagues will just indulge me for a minute. I'm proud to sponsor this resolution proclaiming August 7th of this year as Purple Heart Day in New York. The Purple Heart Medal carries a special gravitas because it is a badge of distinction reserved for military personnel who are wounded or killed in action. Not only does it represent bravery and sacrifice, it is also special because of its long and proud tradition. In fact, the Purple Heart is the oldest military decoration in the world that is still awarded today. The Purple Heart can be awarded to any active military member. How powerful is it that here in the United States, our long-standing practice is to honor every person who sacrifices for our freedoms, not based on their rank, but on their bravery and dedication. In honor of every recipient of the Purple Heart, past and present, I ask my colleagues to please join me in passing this resolution to celebrate Purple Heart Day in New York this year on August 7th. Thank you.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 786. Mr. Stern, legislative resolution memorializing Governor Kathy Hochul to proclaim September 22nd, 2025 as Veterans Suicide Awareness and Remembrance Day in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 787. Ms. Griffin, legislative resolution memorializing Governor Kathy Hochul to proclaim September 26, 2025 as Law Enforcement Suicide Awareness Day in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 788. Mr. Smullen, legislative resolution memorializing Governor Kathy Hochul to proclaim September 27, 2025 as National Hunting and Fishing Day in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 789. Ms. Hooks, legislative resolution memorializing Governor Kathy Hochul to proclaim September 28, 2025 as Good Neighbor Day in the state of New York in conjunction with the observance of National Good Neighbor Day.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 790, Ms. Bashat Hermelin, legislative resolution memorializing Governor Kathy Hochul to proclaim September 2025 as Prostate Cancer Awareness Month in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 791, Ms. Buttonshun, legislative resolution memorializing Governor Kathy Hochul to proclaim October 26, 2025 as a day of the deployed in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 792, Mr. McDonald, legislative resolution memorializing Governor Kathy Hochul to proclaim November 2025 as Epilepsy Awareness Month in the state of New York.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted.
Assembly Number 793, Ms. Griffin, legislative resolution memorializing Governor Kathy Hochul to proclaim May 10, 2025 as Golf Day in the state of New York in conjunction with National Golf Day.
On the resolution, all those in favor signify by saying aye. Opposed, no. The resolution is adopted. Ms. People-Stokes.
Madam Speaker, I now move that the. Oh, I'm sorry. Do you have any housekeeping or resolutions?
We have no housekeeping. We have a number of resolutions before the House. Without objection, these resolutions will be taken up together. On the resolutions, all those in favor signify by saying aye. Opposed, no. The resolutions are adopted. Ms. People-Stokes.
I now move that the Assembly stand adjourned and that we reconvene at 9:30 a.m. Friday, June the 13th. Tomorrow being a session day.
On Ms. People-Stokes' motion, the House stands adjourned.